I wanted to move the injunction application tomorrow, my lord, without service. I was seeking leave, ex parte.
Commercial?
Commercial.
Give.
Obliged.
My lord, may I be permitted to mention, my lord, a suit for eviction, my lord. Your lordship had adjourned these matters, my lord, to the 17th of July in view of the pendency of the decision before the division bench involving, my lord, the 106 dispute. My lord, the decision has come, my lord, squarely in our favor. I was only praying, my lord, if any date could be fixed, my lord, prior thereto.
What is the stage on in that?
My lord, the suit is ready for hearing. My lord, the respondents have taken out an application for rejection of my plaint. Order 7, Rule 11, my lord.
What is the stage? What hearing?
My lord, the Order 7, Rule 11.
That isn't disposed of.
No, my lord. It is pending.
Acha.
Lordship had postponed the matters to
disposal.
yes, my lord. The 17th of July, my lord. I was only praying, my lord, if a date prior thereto could be.
Before.
My lord, I'll hand up this list, my lord, in the event.
Give then to be mentioned, mein rakho. Give the other notice to the
yes,
other.
my lord, I have. I'll again serve a notice. I'm so grateful.
Lordship,
My lord.
Respondents in this matter.
Which matter?
In this matter only, Lordship. Lordship, I'm being led by Mr. Rupak Ghosh. Any day, Lordship.
Yes, I am fixing as a to be mentioned. Come, then we'll, in presence of both the parties, I will fix that.
I'm so grateful.
My lord, I'm mentioning a matter for correction of typographical error in the order, my lord. My lord, on the third page, Mr. Saros Dasgupta was appointed as a special referee for determining the issue of mean profit. The name of Mr. Dasgupta is incorrect.
Only the name.
My lord.
कहाँ से लिखे नाम? Sorosich. So. But either no defendant भी है ना? Who is for the defendant?
My lord,
Mr. मेरे को correction में रखो.
My lord, I shall give a notice to other side, my lord.
My lord, may I please have your liberty to mention a matter? My lord, it's appearing as item number 50 of today's list. My lord, in this matter, my lord has directed paper publication, and we are for that defendant for whom the paper publication was.
Paper publication for?
My lord, we haven't been served with the plaint or the summons.
For the plaintiff.
For the defendant for whom the paper publication was made.
Paper publication for what?
My lord, for summons, substituted service.
By the defendant?
By the plaintiff. We are for the defendant for whom the paper publication
paper
was.
Publication you came to know?
Yes, my lord.
Now what do you want?
My lord, we had contacted the advocate for the plaintiff, the number which was given in the publication. So they had said that they will require an order from the court for service of the plaint upon us. And we had served the notice, but my lord, I cannot see anyone today.
So what you want?
My lord, they said they will be requiring an order from your lordship to service the plaint.
तो ये सूट में क्यों पेंडिंग है? सूट में क्यों आया? जब सर्विस नहीं हुआ तो?
My lord, there are other defendants also.
Maybe, but service नहीं है तो for orders में रखो इसको. Tomorrow या day after tomorrow orders में रखो.
50.
Item number?
My lord, 50. 50.
Okay.
Then grateful, my lord.
Well, may I have your lordship's kind leave to mention, well, this is a matter where your lordship had not stayed the warrant of arrest. Well, we had paid the principal amount. With regard to the interest also, my lord, we have paid in full. We have paid in full. Well, in the full satisfaction of the decree. So the other side, if your lordship kindly keeps it to be mentioned, my lord, I am mentioning upon notice only. But my lord, if they come, your lordship can record my lord satisfaction of the decree. Well, tomorrow
to be
great.
Grateful. Yes, next.
May I be permitted to mention a matter? Your lordship, on the last occasion, your lordship had asked to serve upon the defendant. Defendant has not been appearing. Through writ of summons, we have issued the writ of summons. It has been, the defendant has received it through post, your lordship. But the bailiff apparently is asking for a direction from your lordship for service upon the defendant, your lordship.
Postal authority report is there?
Yes, your lordship.
So what do you want now?
Your lordship, I'm seeking an order from your lordship for service upon the defendants through court, your lordship. And if that is not done, then I'm praying for an undefended suit, your lordship. ex parte. We have also sent a letter to the registrar, Your Lordship, for whether they have entered appearance or not. They haven't, Your Lordship, till date.
But as for the postal receipt, they have entered appearance. What about you have not taken steps for bailiff service?
Your Lordship, this is the service report, Your Lordship. It says item delivered through postal acknowledgement, Your Lordship.
Correct.
But through court, it has not received, Your Lordship. Through court.
Through court it is. So you want sent to through court also?
Yes, Your Lordship, or through Hague Convention, if Your Lordship so pleases.
Pursues could be mentioned. Yes, next.
Your Lordship.
Call the matter.
Your Lordship, I'm appearing for the plaintiff in the matter. I'm seeking for a 5-minute Passover because I'm being led by Mrs. Suparna Mukherjee, who is just reaching the court.
It's
Just 5-minute Passover.
just a departmental proceedings. We have filed an application for subpoena under Order 16 before the department. Now the department has placed this matter before this honorable court for necessary direction. Mrs. Boyjanti Mukhopadhyay, Mr. Boyjanto Mukhopadhyay, Central Forensic Laboratory. He is in Bhopal right now. So I think, Your Lordship, the department has placed for necessary orders so that, Your Lordship, the subpoena can be issued and for his presence.
Your Lordship, there are two things that we want to bring to Your Lordship's notice. One is this application for subpoena. This was directed by Your Lordship. This was never served upon us. Commissioner is appointed in the matter. The evidence is being recorded by the learned commissioner. The learned commissioner had already fixed 17th of June and 18th of June pursuant to Your Lordship's order. The defendant witness second was also examined and Your Lordship had ordered immediately after defendant 2 is over, subpoena application will be taken out, and Your Lordship had specifically ordered that the learned commissioner will not grant any adjournments for the sittings. This was recorded in Your Lordship's order. Your Lordship, the commissioner had fixed 17th and 18th of June after the reopening from the summer vacation for defendant witness 3, that is CFSL, and on 16th, we receive an email intimation from the learned commissioner whereby we get to know that the sittings were adjourned because the defendant chose not to even intimate us their request for adjournment and did not even serve this. We only got it from the.
With due respect, Your Lordship, the subpoena application is between myself and the department. Your Lordship, I am not required to serve, but though, Your Lordship, we have intimated to the learned commissioner and the commissioner has already intimated them by serving that particular application. If Your Lordship kindly sees.
So how the subpoena will be served?
Subpoena will be served, Your Lordship. The department will take steps, or if the department will say, Your Lordship, the subpoena after giving in the entirety, I can serve Your Lordship through speed post, whatever Your Lordship thinks fit.
But no, that is the problem. That's why the report has come. I find
yes, Your Lordship,
the court is passing an order for subpoena.
Yes, Your Lordship.
Court, I don't know. I didn't find any rules in the original side. The office is preparing the subpoena and handing over it to the advocate on record.
Yes, sir.
But it should be otherwise. The requisite has to be filed by the advocate, has to be submitted to the department, and department through the Sarif it has to be served. But it is going on because in one case I find that it has been given some other report, court has passed some other report. When the court has inquired into the matter, then I find that subsequently the subpoena was handed over to the advocate on record. Advocate on record has not served, but the registrar has given a report, the subpoena has been served. And the court has passed some different order.
Lordship, in this matter, Your Lordship, whatever you because CFSL report is very important for us. So whatever Your Lordship.
So okay, I am passing an order. You take appropriate step for issuance subpoena. Subpoena should be sent through the Sarif.
Sheriff, Your Lordship.
Your Lordship, I'm not objecting at all. I'm not coming in the way. I'm only humbly praying that one, they serve us, and second, a time frame may be given. It's a commercial suit.
Already my order reflects it. My
Your Lordship,
when the
subpoena, the date will be mentioned. He has to come on that particular date,
Because,
whatever the department
because
will give me.
this court cannot fix because subpoena as per the convenient of the office it has to be fixed.
Yes, because we requested your lordship, the gentleman, because your lordship, there is a procedure. He is the central government, your lordship, high official. Unless and until a subpoena will go, he'll not come.
Correct. That's
Yes.
correct.
But your lordship,
And
taking the subpoena,
another one thing, for the witness, the subpoena is not the proper way under the CPC. Subpoena is only with regard to protection of documents.
Official documents.
Official documents.
My problem, your lordship, is the yes,
I've seen in everything.
Yes,
for the summons, for the examination of the witness, that is a proper form to the witness, to the summons to the witness.
So this problem I found because there are certain documents in police station which I cannot produce. Then the officer in charge will come and produce that.
Yeah,
but now problem is the CFSL has given a report. Now CFSL is of the opinion that we have given the report on the basis of the request made by the insurance company and the surveyor. So we will not go before the court of law because this is our. I will go only on the official.
If you want to take the benefit of the report, you have to examine the person who has submitted the report.
And his presence is required to be, your lordship, directed.
So whether this incumbent is able to come to the Kolkata,
yes, we have
important post they are
yes,
holding.
Yes, we have inquired, your lordship. He is in Bhopal. But whenever your lordship, the date will be given, if after 2 weeks, he will, your lordship, make arrangements and come. Okay, it's a court order. He has to come.
So appearing for the plaintiff, so appearing for the defendant. You are for the plaintiff.
I'm for the defendant.
I'm appearing for the plaintiff.
The defendant has filed an application being GA-Com 7 of 2025, praying for a direction for issuance of subpoena upon the director CFSL Bhopal for giving evidence in the present suit. Counsel for the plaintiff submits that though the defendant has filed an application being GA-Com 7 of 2025, neither any notice was served nor any intimation was given to the plaintiff. See, further submit that when the order was passed for appointment of commissioner, has categorically directed that the suit has to be in the commission is directed to expedite the matter, and the parties are also directed not to take any adjournment when the expert will appear before the commissioner for examination. Consider the submission made by the counsel for the respective parties. This court find that the defendant, in support of his case, intend to examine the director CFSL Bhopal, who has submitted the report in the instant case. Accordingly, this court find that accordingly the master is directed to issue subpoena upon the director CFSL Bhopal for appearance before the commissioner on when is the date?
No date has
been fixed, but we require, your lordship, 2 weeks time because he has come from Bhopal, your lordship.
Today we are on 23rd.
Any date, your lordship, after 2 weeks?
So 28th, 29th August, July.
Yes, your lordship.
Yes, madam.
Sufficient time.
क्या बोला? Issuance of summon upon the director of Bhopal for appearance before the commissioner on 28th of July 2025, and if required also on 29th of July 2025 for examination and cross-examination before the commissioner. The master and official referee of this court is directed to issue the subpoena upon the director CFSL Bhopal through the 'To whom it can be served? Through the bailiff will not go, then it will be
if any officer from the office
of the sheriff of the office.
Yes.
From the sheriff of the office. The GA number so is disposed of.
Your lordship.
And the defendant be directed, your lordship, to put all the requisites.
The defendant is directed to immediately take appropriate steps to file requisites before the office of the masters of this court for issuance of subpoena.
Requisites and costs, if any, because we have to.
Requisites includes.
Your Lordship, the learned commissioner was directed to file the report by 25th of June 25, if that could be extended, Your Lordship.
File report.
Yes, Your Lordship, the report
Acha,
of the, yes, that
So,
if that could be extended.
Filing of report by the Advocate Commissioner is extended till 4th of August 2020.
4th August. I'm grateful.
Let the matter appear on 4th August 2020.
Lord, I beg to appear on behalf of the plaintiff. So, my lord, the problem is in this particular suit, this was a dispute regarding infringement of intellectual properties, my lord. So this matter will be most obviously renumbered as IP, your lordship. So if your lordship
has to be released by your lordship in that.
But my lord, after having proper directions that this needs to be renumbered as IP.
So suffering for the plaintiff, suffering for the defendant. This court find that the suit is connected with the intellectual property matters. Accordingly, the matter is released from the list of this court with the direction to place before the appropriate court after assigning the new number of intellectual.
My lord, the problem is I had mentioned this matter before, your lordship. After that also we had gone to this. So if your lordship kindly notes that this I had submitted that this matter relates to intellectual property.
The service upon the judgment date was not completed. Service upon the judgment date, my lord. Kindly fix it next week, my lord. In
Which
the
one?
7, my lord. 7, my lord. In the meantime, we will serve this. We send, my lord. It not delivered.
As per so and so suffering for the degree holder. So and so suffering for the degree holder. As per the made by the counsel for the degree holder, cases adjourned. Let the matter appear on 4th July.
4th July. Grateful, lordship.
Sure, I'm for the decree holder. This execution application is from my lord's decree that we have taken out an execution application. Lordship, may I have the liberty to pray for prayers E and F, because the defendant had entered appearance in the matter, and they have thereafter they have failed to appear, and an ex parte decree was passed. So I am only praying for prayers E and F in respect of the tabular statement.
What is the decree?
Worship, the decree is for an amount of 11,54,992 along with interest.
There's no appeal pending.
There is no appeal.
Have they preferred an appeal?
There is no appeal. They have not preferred any appeal.
9 crore people. So and so appearing for the degree holder. The degree holder has filed the present application for execution of the decree passed by this court dated
December 3, 2024.
December 2024, wherein this court directed the defendant to pay a sum of rupees 9 crore 52 lakhs 920.75 along with interest at the rate of 18% per annum. Full stop. In spite of the decree passed by this court, the judgment debtor has not filed and not paid the decretal amount as well as the interest. According the decree holders filed the present execution petition. Full stop. Counsel for the decree holder prays for
Praise E and F.
Praise for order in terms of prayer E and F.
Yes, Lord.
E and F. Consider the submission made by the counsel for the plaintiff. Prayer E and F of the tabular statement is granted till the disposal of the present execution application. Full stop. The judgment debtor have issued notice, no?
No, we have not issued notice.
The plaintiff and the decree holder is directed to issue notice and also to serve the copy of this order. And the judgment debtor is filed. Only one?
Only one.
Is directed to file the affidavit of assets on the next date fix. Leaves the matter on 22nd July 2025.
I'm grateful.
I appear for the decree holder, my lord.
Yes.
Your lordship's decree of 26th July 2024. We are within 2 years, my lord. There is no appeal. So, my lord, I was praying for orders in terms of prayers A to F.
Prayer?
A to F. E and F are for filing affidavit of assets, but I was praying for orders in terms of prayers A and A to D. A to E, D, A to F.
So appearing for the decree holder. The decree holders file the present application for execution of the decree passed, judgment and decree passed by this court dated.
Judgment and decree dated 26 July
2024, wherein this court has directed the defendant or defendants?
Defendants.
Directed the defendants to pay a sum of rupees.
The principal sum is, there are claims were on account of several heads. The total sum due as on the date of filing of the execution application is 7 crore 40 lakh.
Now, what was the decree?
The decree was 2 crores, 2 crores for principal sum on the mortgage, 2 crores in damages, 10 lakhs towards the amount forfeited by Hyundai, and then interest on that.
One. No appeal is there?
No appeal.
Was a decree directing the judgment debtor to pay rupees 2 crore being the damages and rupees 10 lakhs. No. Decree. Uh, 2 crore being the principal amount along with the interest at the rate of 12% per annum. At the rate of 12% per annum till the
Your Lordship will get everything in paragraph 7.
Realization of the total amount and further amount of rupees 2 crore being the amount for damages suffered by the plaintiff and further amount of rupees 10 lakhs being the forfeited amount. In spite of the decree passed by this court, the defendant has not paid the amount. Accordingly, the plaintiff has filed the present application for execution of the judgment and decree passed by this court. Counsel for the plaintiff submit that in spite of the decree passed by this court, the judgment debtor has not paid the decretal amount and the interest. Accordingly, he prays for.
And I am praying for prayers in terms of prayers A, B, and C.
Prays for order in terms of prayer A, B, and C.
And so far as prayer D is concerned, my lord, the paragraph number where the assets are described is been mentioned as 12, but it should be read as paragraph 11, my lord.
Let they come. A, B, and C. C till the disposal of the present application. Full list. The plaintiff is and the decree holder is directed to serve the notice along with this order to the judgment debtor, and the judgment debtor is directed to file the affidavit of assets on the next date fix. Please the matter on 23rd July 2020.
If your lordship may be pleased to pass an order of injunction on the immovable properties also mentioned in paragraph 11. Very well. 22nd July, your lord. Obliged. 23rd.
Lord, Act number 10, my lord, I'm appearing for the plaintiff, lordship. This is my defendant, my lord, where directions were passed on the last occasion for filing of affidavit of evidence by the defendant. And my lord had also set out a timeline for, since the evidence was being recorded by a commissioner, my lord, a commissioner was also appointed. But my lord, it so happened that my lord, the evidence was filed on the last working day prior to the summer vacations. Thereafter, my lord, there was a 2-week vacation, and my lord, both parties, my lord, despite best effort, my lord, we could not hold the inspection of documents, and my lord, we are slightly delayed, lordship. And my lord, we have also we have raised concerns with the learned advocate for the defendant, my lord, that some of the documents are not legible. Now, they have also provided us with an additional set of documents. We have also gone through, my lord. This appears to be the conundrum between the parties, lordship. So, lordship, I'll pray, my lord. I'm sure my learned friend will also agree, my lord, if a time can be extended for us to comply with the directions of your lordship.
You are not complied with the admission and denial.
My lord, it is because
in your submission, this court has disposed of and also appointed the commissioner.
Yes, my lord. And my lord, there is one other.
Normally, this court, unless and until this is so how where is the
My
issue?
lord, there is one other issue, my lord. That, my lord, we will need your lordships to clarify this, my lord. This, my lord, they have filed their affidavit of evidence marking all documents as exhibits. Now, my lord, when we had tendered our witness, my lord, we had tendered each and every document before the commissioner, and my lord, objections as raised by the
evidence is going on. Where is the provision for again discordant inspection of the document further?
My lord, it is their documents, my lord, that we'll have to give our
additional documents.
Yes, my lord, additional documents. And then, my lord, certain illegible documents have surfaced, my lord, which we have informed them. And it has taken us some time to bring forth all documents on record, my lord. I've marked those documents in the affidavit as well. Lordship can take up their affidavit, my lord. These are completely illegible. Lord, kindly sees, my lord, page 60.
So it is not served to you. Legible copy?
No, my lord, we've not received.
Give them legible copies, my lord.
Yes.
And as far as the second, I don't know whether my learned friend is actually pressing this point. Once the affidavit, my lord, proves the documents in evidence, then further examination in chief is not required, my lord. That is judgment of our court also. The affidavit proves the documents. They may have chosen to lead additional oral evidence to prove the documents in addition to the affidavit in chief.
No, he's telling that what the additional document
Yes.
upon out of that document.
Those are
It's not
illegible.
legible.
We'll give legible copies.
And we'll have to inspect also, my lord, of the originals because these are additional documents. So we will file our additional admission denial as well.
So when the case will be proceeded further?
We gave them.
Lord, we can do it within this week, lordship.
Lord, we had served the copy, the legible copy to her.
Yes, and my lord, they requested inspection, my lord. We've called upon them to take inspection. Whatever it is, my lord, we'll do it, my lord.
My lord, we have not received
An email
that's my instruction. For inspection, my lord, we've not received any intimation from their side.
We'll extend the time. You want extension?
Yes, my lord.
You kindly extend the time.
But we can do it within this week and the commission can be held.
Today is what?
My lord, next 10 days, my lord.
Census and suffering for the defendant. As per the order passed by this court dated 2nd May 2025, the commissioner is required to file report by 20th June 2025. The learned counsel for the defendant.
Well, time for the plaintiff.
Plaintiff submit that though this court by an order dated 2nd May 2025 has allowed the defendant to disclose the additional document. Accordingly, the advocate on record of the defendant has served the copy of the additional document with the additional document, but after going through the same, it was found that some of the documents are not legible. Accordingly, the plaintiff has requested the defendant for supply of legible copy of the document, but the same could not be served, due to which inspection of the additional document could not be done. Counsel for the defendant submit that. When you serve the legible copy?
It's served. Today we are on Monday. By Wednesday, my lord, latest.
The counsel for the defendant submit that they will serve the legible copy of the document.
24th, 25th, 26th.
The plaintiff by
26th, please, my lord.
By 26th. 26th.
Yes, please.
June 2025. Full stop.
And give inspection also.
And also disclose their original document to the plaintiff for inspection.
Yes, ma'am.
For inspection. The defendant is directed to complete the inspection of the document of the plaintiff by 2nd July 2025.
The other way around. The plaintiff is directed to
yes.
the other way around. Please.
Plaintiff is directed to complete the inspection of the document by 2nd July 2020.
Please.
Full stop. Then what is when the date is fixed before the commissioner?
That date has no dates are fixed, my lord.
In view of the above, time to file report by the commissioner is, and the only the one witness. How many witnesses?
One witness.
We have one witness.
The time to file report by the commissioner is extended till 30th July 2025.
Yes, ma'am.
Okay, July. Grateful, my lord.
Grateful.
ये नहीं है ना? ये है क्या? ये क्या है? ये नहीं है, कब डाला? ये तो रीनंबर तो होंगे, पुराना जी है. Yes.
May it please, my lord. I am for the defendant in this suit, my lord. This is my application, GF5. I am.
What you applied for?
I made an application in terms of Order 13A of the Code of Civil Procedure as amended, as amended for the Commercial Codes Act. It is my submission that the part of the claim that the plaintiff has made in the suit can be decided summarily.
You filed.
My lord, I have filed. Kindly gives me a moment, my lord.
Have they filed an application for leave?
No, my lord, no application. I am for the defendant, but I must.
You are for the defendant?
Yes, my lord.
And you have filed an application?
Yes, my lord, I have filed an application. The court possibly, my lord, if my lord subject to the test that my lord puts me through, it does not debar me from making this application out. If I feel, my lord, in their plaint summarily a claim may be decided, I can possibly file this application. Of course, subject to the test that my lord puts me through.
You for the defendant?
Yes, I am for the defendant.
And you filed a chapter
Yes.
13A?
Yes.
Without the counter claim?
Yes.
You have to satisfy this.
Sure. May I attempt and satisfy your honor?
And without the leave? Without the leave application?
Yes, but I have not.
When you received the
may I also indicate, I have filed my written statement also in the suit. When the writ of summons was lodged and received by me, I have filed the written statement on the 31st day, wherein I sought for leave for my lord. My lord granted that leave for me to file 1 day belatedly, my lord. May I just place Order 13A for a moment?
Order
13A. My lord. Yes.
Yes.
Yes, my lord. May I place, my lord?
Yes.
Order 13 is summary judgment. My lord, this is applicable to the commercial disputes post the October Amendment of 2015. This order, may I place? This order sets out the procedure by which courts may decide a claim pertaining to any commercial dispute without recording oral evidence. For the purposes of this order, the word claim shall include part of a claim, any particular question on which the claim, whether in whole or in part, depends, or see a counterclaim as the case may be. You know, in my understanding, I fall under Order 13A, Rule 1, Subclause 2B.
Any particular question on which the claim, whether whole or part, depends?
Yes, my lord. Their claim, my lord, is for that they have given me goods or I have purchased goods from them on an approval basis. They have appended invoices to their plaint saying that there are 11 such invoices on the basis of which I have purchased goods on approval basis from their office. On approval basis, my lord, is defined in the Goods and Services Tax Act. It says that if a good is produced on an approval basis, the plaintiff ought to have filed trans 1, which comes under section Rule 120. I shall also place those. Rule 120 of the GST Rules 2017. It says that if goods are given on an approval basis, they have to mandatorily, within 120 days, within 90 days, disclose the same before the GST authorities. Why? Because...
But that is different. But where is your claim?
My
So
claim
that
is
the
that the
court
goods
can
were
decide on your application.
my claim is that the goods were never sent to me. That is my
Where
claim.
is your claim?
My written statement
The
discloses
plaintiff is filed the suit.
Yes,
Plaintiff has made a claim.
Yes,
Where is your claim?
Their claim can
So
be
that this court can pass an order under chapter under order
yes.
13A.
My claim is that this case that they have made out, wherein they say that these goods were purchased by me from their office, can be decided summarily on the basis of the documents that they have given. And my lord can, subject to the test that my lord puts me through, reject their claim in my application. I am led by Mr. Gupta. May I kindly?
Just if your lordship kindly sees the scope of order 13A, it's really quite wide. That where the defendant can also take out an application and the plaint case can also be dismissed on that. But I filed my written statement. Now, my lord, to that, my lord, I have annexed.
You filed the
written statement. But now, my lord, in my humble
written statement, you made a counterclaim.
No, I have not made a counterclaim. There was initially an application filed in the suit by somebody else who was initially added as a party, who has already been struck off from the array of parties under an application in the nature of Order 1 Rule 10. Now, this is the defendants, the principal defendants have now come up with this Order 13 application on the simple point that from the documents disclosed with the plaint and as well as my GSTR returns, which I have annexed with my written statement, it would clearly be evident that, my lord, none of the goods which the plaintiffs claim to have delivered to me, though mandatorily covered under the GST Act and GST is applicable on them, the plaintiff has, my lord, filed any GST returns in respect of that same, and there is no question of me claiming any input credit for that. Now, my lord, for that purpose, my lord, if from the documents disclosed by both the parties, the court can come to a conclusion, my lord, then under Order 13A, my lord, your lordship can, my lord, pass an order dismissing the suit. So that is why, my lord, in my humble submission, my lord, we have taken out this application. As per the procedure provided for under this provision, they would get a chance of 30 days to, my lord,
to tell like this, you file an application for dismissal of the suit under the under this chapter.
Yes.
He is telling that he has made a claim. He is making the submission since beginning. He's made the claim.
I'm sorry, my lord. He was meaning claim for dismissal of the suit.
There is no claim. How he can make a claim?
I apologize on his behalf. His claim is for
Your Lordship, I am appearing on behalf of the plaintiff. I am led by Mr. Gunjan Shah in this matter, and due to the medical emergency of his father.
Have you received the copy?
Yes, Lordship.
A5.
Yes, Lordship, I have received a copy, but I didn't get any instruction from the advocate on record. As such, I am praying for some time. By the end of this week, he will come.
Have you filed affidavit or not?
Yes, I am intending to file the affidavit in opposition, Your
As
Lordship.
per the procedure prescribed, they would get 30 days.
So that's I surprised. He's telling that the claim.
His argument was claim for dismissal, but it's not our claim. It's
Suffering for the plaintiff, suffering for the defendant. Defendant has filed the present application under Order 13 capital A of the Code of Civil Procedure. Counsel for the plaintiff requests for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks.
Your Lordship, 3 weeks.
Could I humbly suggest one thing subject to what falls from the statute prescribes 30 days. So, my lord, if they can, if they may not be able to raise any issue on that, my lord. So
within 4 weeks, 30 days. Within 4 weeks, reply if any there to be filed within
2 weeks.
2 weeks thereafter. This is the matter on 19th August.
Much obliged.
Well,
my application, my lord. I appear for the sole defendant, my lord. Application for extension of time to file the written statement upon conversion from a non-commercial to the commercial division, my lord.
So this is what is this is a IP matter?
No, my lord.
No, my lord.
A suit.
Sure.
Suit, my lord.
Suit for recovery of money.
My lord, suit for instituted by me for recovery of money on account of goods sold and delivered pursuant to an application for a judgment upon admission, my lord, part of the suit has been decreed in my favor and execution is pending. So far as the remaining part is concerned, my lord, the suit is restricted to that. Now, my lord, the suit was filed in the year 2016, my lord. Writ of summons was also served in the year 2016. It was only transferred, my lord, sometimes late in the year 2024 as a commercial suit, my lord. Thereafter, they made an application, my lord, for extension of time to file written statement. Now, my learned friend have already concluded their submissions. They have relied on two judgments. One is an unreported judgment passed by this honorable court, and one is a judgment, my lord, in the case of
I just
Raj process. Raj process. So that's another.
Just one thing, Lord. Since I have completed my, I have cited two judgments, Lord. One of the Honorable Supreme Court, and relying on that, one from our High Court, Lord, a Honorable Coordinate Bench. So, my lord, two things, my lord. I just wanted to add one last submission, my lord. Claim was for, in the suit was for 51 lakhs and all. They filed a judgment upon admission, my lord, on the basis of an agreement, my lord, where we had agreed to pay 27 lakhs. Now, he has got a decree of 19 lakhs. Look, balance, my lord, he also knew is a disputed sum. That is all I wanted to submit, my lord. Add to that, but only thing is, my lord, this is my, I rest my case, but I have a fixed, my lord, matter going on in the next courtroom, my lord. But my junior is here, my lord. He will. May I take your lordship's leave, my lord?
Now, my lord will kindly see that. My lord will kindly consider this, the facts first. Kindly takes my affidavit in opposition. My lord kindly turns to page number 10 of my affidavit in opposition, where I have annexed an order of 5th of February 2016. Immediately after filing of the suit, my lord, I had filed this application for judgment upon admission. My lord will see that despite filing of the affidavit of service, my lord, the defendant remained unrepresented. I was asked to serve again.
Yes.
My lord kindly turns the page over, 18 February 2016.
You are for the plaintiff.
I am for the plaintiff, my lord. 18 February 2016, my lord, even then the defendant did not appear. Despite service, the court recorded that, my lord, and proceeded to, my lord, grant me the decree for part of the claim amount. But that, my lord, will find at page 12. But my lord will see that from the very beginning, the defendants, despite service, were not appearing. Now, kindly turns the page over to page number 13, my lord. This is the service report which has shown that it was served by the process server on the defendant on 21st of March 2016. So this is an important date, my lord. This is when they received the writ of summons. My lord, thereafter, my lord will kindly turn the page over to, I have annexed all those documents saying that they have not filed their written statement. I have obtained the certificate. Now, my lord will kindly take the next date, important date at page 16. This is the 4th December.
They entered appearance on 8th of March.
Yes.
And your notice was served on 21st of March.
Yes, because they had entered appearance because I had already served them with the copy of the application. So they received the copy of the application and they immediately entered appearance. Writ of summons was served later on, my lord. Now, my lord will so my lord, they had entered appearance also. So it is not like they were not aware of the suit. That was in, my lord, 8 March 2016. Now, my lord will kindly see page number 16. 4th December 2024 is the order by which, my lord, the suit was directed to be transferred to the commercial division of this court. Now, my lord will kindly see, they take their petition. When was this filed, my lord? This order was passed on, my lord, 4th of December. So, my lord, they filed this master summons was taken out on 30th of January 2025 as per the master summons served on me. And the affidavit, my lord, was affirmed on 30th January 2025, but I believe it was sometimes filed in the February, I think.
30th January?
30th January.
Yes.
So that is also post 30 days from 4th of December, nonetheless. Now, my lord, what my learned friend is arguing is that the strict time of 120 days for filing of a written statement will not apply to a suit which has been transferred. If my lord goes through the petition, it is the contention of my learned friend that this transfer gives them a fresh lease of life and they have a right, an unfettered right to file a written statement within 120 days. That, my lord will find, kindly takes their petition once and kindly sees, my lord, paragraph number 11 onwards. My lord, when the suit had appeared before the suit court, my lord, they had appeared and they wanted to file a written statement. The honorable judge said that you must take out an application for that purpose. Liberty was granted. This liberty does not grant them an unfettered right to have the written statement filed. Paragraph number 12 kindly sees this is their case that they have made out. The defendant states and submits that when a suit is in the nature of a commercial dispute has been filed before coming into force of the Commercial Courts Act 2015, the same shall be required to be transferred from the regular division to the commercial division, and the prescribed period to file the written statement under second proviso to Order 5 Rule 11 of the Code of Civil Procedure shall not apply to the transferred suit. My lord, paragraph number 13 and 14. The defendant states and submits it has now been settled that if a suit in the nature of commercial dispute has been transferred from a regular division to a commercial division, the defendant will get a fresh period of 120 days to file the written statement. This, my lord, I have joining issues with my learned friend. From the date of order of such transfer, the present suit has been transferred from the regular division to the commercial division by the order dated 4th of December 2024 of this honorable court, and the same has been renumbered as CS com number such and such by the department of this honorable court on 19th December. Therefore, the defendant is entitled to get a fresh period to file his written statements. In the facts and circumstances, I submit that leave may be granted. Now, my lord will turn the pages of the entire application. My lord may take it from me. There is not one line of explanation as to the delay in taking out this application, why the written statement could not be filed despite. I have specifically, everything is on record. They received the writ of summons in the year 2016. Not one line of explanation as to why, what caused the delay for the satisfaction of the court. Their entire application proceeds on the basis that they have an unfettered right. Now, my lord, will kindly consider the judgment that they had relied on. Kindly takes the judgment of Raj process, my lord. My lord, here also the suit was initially instituted. I'll just give the facts of the case to show that there was no abnormal delay in this case. Kindly takes paragraph 5 of that judgment. The respondent herein filed a suit for recovery of damages on the file of the Civil Court Senior Jalgaon in December 2017. So December 2017, the suit was filed. The suit, admittedly, the suit summons was served on the appellant's hearing on 16th of February 2018. So within 2 months, my lord, the writ of summons was served. They did not file the written statement. Therefore, on 3rd of July 2018, that is 5 months after the writ of summons was served, it was directed that the suit would proceed ex parte because no written statement was filed. On 11th of August 2018, paragraph number 7, my lord. On 11th August 2018, the District Court Jalgaon was designated as a commercial court. Thereafter, my lord, the commercial court rejected all 3 applications because they filed an application for, my lord, extension of time to file written statement 11th April 2019. And my lord will see that in the middle of paragraph number 7, after transfer, defendant numbers 1 and 4, who are the appellants, herein moved 3 applications respectively for condonation of delay, for recalling the order that no written statement was filed, and for setting aside the order directing the proceeding to go on ex parte. That was rejected by the commercial court on 11th of April 2019. So it can be deduced that these 3 applications were filed sometimes between August 2018 and April 2019. That is more or less in the same year. This is after 8 years, my lord. Now, my lord will see what is the law that has been laid down in this judgment. Paragraph number 9 onwards. There is no dispute about the fact that at the time when the suit was filed, at the time when the order dated 3rd of July 2018 was passed, the court before which the suit was pending was a normal civil court. It was only after the order dated 3rd of July 2018 was passed, directing the matter to proceed ex parte, that the matter got transferred to a commercial court. It is also an admitted fact that the period of 120 days as stipulated in the second proviso to Sub-Rule 1 of Rule 1 of Order 5 CPC and the proviso to Rule 1 of Order 8 expired on 18th of June 2018. In other words, the time that was available, if a strict interpretation is given to the aforesaid provisions, was nothing because the time of 120 days has expired even when the matter was pending before the court. Reliance was placed by the High Court on the judgment of this court in SCG Contracts India versus case Chamankar Infrastructure. This is that judgment which said it's a mandatory provision, my lord, the amendment that is brought by the Commercial Courts Act, in support of the contention that the timeline prescribed under the second proviso to Sub-Rule 1 of Rule 1 of Order 5 CPC is mandatory and the appellants have forfeited their right to file written statements. Now, the reasoning in paragraph number 13. But we do not agree. The suit that became the subject matter of dispute in SCG Contracts India Private Limited appears to have been filed before the commercial court and not before the normal civil court. Insofar as normal civil courts are concerned, it is the proviso to Order 8 Rule 1 CPC which applies. That is without the amendment, my lord. In Salem Advocate Bar Association versus Union of India, the court held that the proviso to Rule 1 of Order 8 CPC is directory and not mandatory. An exception was carved out in SCG contracts to this rule by this court insofar as commercial disputes are concerned by invoking the second proviso to Subrule 1 of Rule 1 of the Order 5. Therefore, to apply the same principle to a matter where the suit was instituted before the normal civil court and transferred to a commercial court after the expiry of 120 days would be to give a complete twist to the interpretation given by the three-member bench in Salem Advocate Bar Association to the proviso of Order 8 Rule 1. In fact, the decision in SCG Contracts India Private Limited is by a two-member bench which was dealing with the second proviso to Subrule 1 of Rule 1 of Order 5. Therefore, when the decision of the three-member bench in Salem Advocate Bar Association was cited before the court in SCG Contracts, this court held in paragraph 11 that the earlier law on Order 8 Rule 1 has now been set at naught. Therefore, what is to be applied to a normal civil court is Order 8 Rule 1 and the interpretation given to the same in Salem Advocate Bar Association. My lord, paragraph numbers 13 and 14 makes a distinction between a suit which has been filed before the commercial court, in which case, my lord, 120 days is mandatory, and so far as in a case which was filed in a civil court but subsequently transferred, my lord, Salem has to be followed, my lord. In that case, it is not mandatory, but then it becomes discretionary. Nowhere in this judgment it says that if a suit is transferred, the defendant gets a fresh lease of life and 120 days to file the written statement. That is not the ratio which has been laid down in this judgment, my lord. Similarly, my lord, in the unreported judgment which has been relied upon by my learned friend, that proposition is not there. I would have understood if it was laid down that for a transferred case, a fresh lease of life, fresh 120 days, it will be available. That is not. Now, my lord, kindly seize the judgment of Salem Advocates Bar Association. Kindly seize, my lord. This judgment is reported in 2005, Volume 6, SCC, page 344. Copy that. My lord, kindly comes to paragraph number 14 of this judgment. This is the one which had held in, my lord, we have been following throughout, that it is the 120 days insofar as a normal civil suit is concerned, not a commercial suit. It is a discretionary provision. The court may extend the time beyond 120 days. Yes. Now, but even then, my lord, discretion has to be exercised. Kindly seize, my lord, Order 8 Rule 1 as amended. My lord, paragraph number 14, 15, 16. 17 and 18 discusses the judgments. 19. Now, kindly seize, my lord, paragraph number 20 and 21. The use of the word shall in Order 8 Rule 1 by itself is not conclusive to determine whether the provision is mandatory or directory. We have to ascertain the object which is required to be served by the provision and its design and context in which is enacted. The use of the word shall is ordinarily indicative of mandatory nature of the provision, but having regard to the context in which it is used or having regard to the intention of the legislation, the same can be construed as discretionary. The rule in question has to advance the cause of justice and not to defeat it. The rules of procedure are made to advance the cause of justice and not to defeat it. Construction of the rule of procedure which promotes justice and prevents miscarriage has to be preferred. The rules of procedure are the handmaid of justice and not its mistress. In the present context, the strict interpretation would defeat justice. In construing this provision, support can also be had from Order 8 Rule 10, of which provides that where any party from whom a written statement is required under Rule 1 or Rule 9 fails to present the same within the time permitted or fixed by court, the court shall pronounce judgment against him or make such other order in relation to the suit as it thinks fit. On failure to file written statement under this provision, the court has been given the discretion either to pronounce judgment against the defendant or make such other order in relation to the suit as it thinks fit. In the context of the provision, despite use of the word shall, the court has been given the discretion to pronounce or not to pronounce the judgment against the defendant, even if the written statement is not filed, and instead pass such order as it may think fit in relation to the suit. In construing the provision of Order 8 Rule 1 and Rule 10, the doctrine of harmonious construction is required to be applied. The effect would be that under Rule 10, Order 8, the court in its discretion would have the power to allow the defendant to file the written statement even after the expiry of the period of 90 days provided in Order 8 Rule 1. There is no restriction in Order 8 Rule 1, Order 8 Rule 10 that after expiry of 90 days, further time cannot be granted. The court has wide power to make such order in relation to the suit as it thinks fit. Clearly, therefore, the provision of Order 8 Rule 1 providing for the upper limit of 90 days to file the written statement is directory. Up till now, my lord, it has been held to be directory. The next few lines I'm relying on. Having said so, we wish to make it clear that the rule that the order extending time to file written statement cannot be made in routine manner. The time can be extended only in exceptionally hard cases. While extending time, it has to be borne in mind that the legislature has fixed the upper time limit of 90 days. The discretion of the court to extend the time shall not be so frequently and routinely exercised so as to nullify the period fixed by the Order 8 Rule 1. So, my lord, the judgment that my learned friend relied on simply stated that so far as a suit which has been filed before the Commercial Courts Act, SCG will apply. And so far as a suit which is transferred, in that case, my lord, Salem will apply. Here, my lord, the Salem says, even then, my lord, it is discretion and it is not an unfettered right. There is not a one line of explanation, my lord, given in the application that has been taken out as to why they could not. They knew that the application was filed. They were served. That was also recorded in the orders passed by Justice Tandon. I have shown that they had entered appearance on 8th of March. I have shown that they have been served with the writ of summons immediately thereafter. And my lord, Commercial Courts Act now will kindly see the provision contained in section 15. There also, my lord, I would humbly submit that the aspect of discretion has come in. Kindly see, my lord, section 15, subsection 4.
Section 4, sub-proviso come to proviso.
Yes, my lord. Provided that the proviso to sub-rule 1 of Rule 1 of Order 5 of the Code of Civil Procedure shall not apply to such transferred suit. My lord, I am agreeable with this, my lord. Or application, and the court may, in its discretion, prescribe a new time period within which the written statement shall be filed. So the power has been given to the court under this proviso, my lord, to either fix a new timeline or refuse to fix. My lord, this is my humble submission. These are my humble submissions. There is not one line of explanation. This is exactly what Salem Bar Association prevented, that it should not be done in a routine manner. And the defendants have come in as if they have an unfettered right. Once it is transferred, I can wait for an unlimited period of time. Once it is transferred, I'll notice that order of transfer. I'll come in. I have a right to file the written statement.
Yes.
My lord, they should be disallowed, my lord, from filing the written statement. These are my humble submissions.
Yes.
My lord,
There is an explanation.
My lord, may I just follow you kind?
Show me the explanation, that's all. One question I'm asking you. Show me the explanation in your application.
Well, there is no explanation given
And
in application.
the law which you have cited, paragraph 13, that is the law. These are the two questions. You explain this. You show me the explanation for the last 4 years.
Lordship, may I? Just give me just 2 minutes time, your lordship. But admittedly, there is no explanation. Admittedly, there is no explanation given in this application, your lordship. That's there, your lordship. But the difficulty is, your lordship, that I want to indicate, your lordship, if your lordship see the plaint and as well as the agreement.
Court will not go into the plaint and agreement. The court is only concerned with the application which you have filed, whether you are entitled to be extended the time in terms of the Order 8 Rules 1.
My lord,
the section 15 of the Commercial Code.
In this matter, in respect of this also, I want to indicate one thing: the conduct of the plaintiff itself. Why I'm saying so? But the suit was filed. My lord, may I?
I am so. That's why show me the averment in your application. The plaintiff has done this. Plaintiff has done this. That's why you are not able to file the return. Show me.
Well, there is no explanation given in the application.
So if you are not given the explanation, how the court can allow? You are not given the explanation, how the court can allow? You rely upon the judgment. The every facts of the every cases are different.
Yes, your lordship. But the cases, in this case, your lordship, the suit has not been transferred into an undefended suit, your lordship. My lord, since the 2006.
Necessary undefended suit. Only the court has to see whether you file the written statement within
Yes,
the
your lordship. But since 2016, no step was taken by the plaintiff for the further proceed of the suit. So, why I'm saying so, your lordship? If your lordship see the agreement for once, the agreement was for 27 lakhs. But if it's happening for the agreement,
again you are entering into
no, I'm showing.
I am asking you, show me all the things has been pleaded in your agreement.
But this was not pleaded in this
your
application. This was not pleaded in the application. That is there, your lordship. But I'm indicating, your lordship, because there is no step was taken by them. We are under impression. The defendant was under impression that they already got the decreed amount what they are actually wanted to. So on the basis of that, your lordship could not proceed with the suit, because since 2016, your lordship, no step was taken by the plaintiff itself, my lord. No, 2016, after got the part decree of 2000 of 19 lakhs.
You are keeping watch. When they get this ex parte decree, then you will come with the Order 9 Rule 30.
My lord,
You are watching so that the further the suit can be delayed and docket of the court can be increased with the pendency of the suit.
My lord, only I have make a submission before your lordship.
That is going on. The other party watch till the undefended suit is decreed. Immediately after the decree, you will come. The writ of summons was not served. Preliminary decree was passed. Subsequently, no notice was issued. All the things. Then again, the process will start. You
My
show
lord,
me in the your application what
there is no explanation. There is no explanation.
done. If you have not taken the ground and the paragraph 13, that is not the law. That is a discretion. You have asked for the mandatory.
My lord, we have only sought for the we only ask for the extension time for WS. WS is ready, your lordship. Lordship give me the time for that.
That's all.
My lord, since there is no explanations given in my application, that is true, your lordship. That is admitted position, my lord. But only I will ask for we are ready for, my lord. We prefer this application.
How the court can allow? If you're not shown the cause, why should you be allowed to file the return statement after the period of 4 years?
My lord, I'm just only harping on the position of the present situation of the law. The judge, I have placed judgment before your lordship. The judgment is saying that since it has been transferred to a commercial suit, your lordship, and suit is in the initial stage, your lordship, not even completed. See, if the suit is proceeded, your lordship.
Is ready.
Lordship.
The written statement is ready.
Yes, your lordship.
Filed.
No, my lord, we can file our lordship. Yes, your lordship.
It is affirmed.
Yes,
When
your
it was affirmed.
On 30th January, your lordship. That is within.
So why you not disclose the written statement along
My lord,
with the master summons?
This matter, may I submit your lordship, but this was matter pending before just before lordship coordinate bench, your lordship. My lord, that in that court, but my lord, in that my lord, before the coordinate bench, your lordship, in that process, the process of your lordship's direction was for filing of the written statement along with the application, your lordship, and that was not there.
That doesn't require any leave from the court. It is you to do. What are the document you want to rely? It has to be included with the pre-applications. That leave is not required by any of the court. You can disclose any document in the application. The court will consider whether that is necessary for consideration or not. You are not stated also all the things. Where you are stated in your application, your written statement is ready.
No, my lord, that is also
Where
not.
you are stated. That is also not there.
Not
then. How many days time? How many days delay is to be conducted? That is also not mentioned.
My lord, may I? My lord, yeah.
Just one thing. It's not 4 years, my lord. It's 8 years because writ of summons.
I am telling that.
My lord, the thing is, your lordship, that it was converted in the by 19th December 2000, lordship, on 16th January, your lordship, 2025, leave be granted to file an proper application, to file a written statement, your lordship, and on that from that period, your lordship, we have filed. If I take the leave of this court, your lordship, then we have filed within 30 days, your lordship. We have affirmed within 30 days, your lordship.
Sensation suffering for the plaintiff, sensation suffering for the defendant. The plaintiff defendant has filed an application being GA. Where is your application? GA Form 2 of 2025. Praying for extension of time to file return statement. Hearing concluded. CAB. Yes, call the master.
Grateful lordship.
CAB.
Next.
7:30.
Okay. Yes. Yes.
And I appear for one of the respondents. We are opposing this application.
Yes.
No one is appearing. Your Lordship has been pleased to dispose of the suit. They've made an application for review of that order. It was not allowed. Then they wanted recall. Then they went to the division bench. Division bench asked them.
My lord, I'm being led by Mr. Rupak Ghosh. He is on his legs in court 41. My lord, I'm praying for a short Passover.
Let the matter appear after the puja vacation.
Your Lordship,
Let the matter appear.
Let it be dismissed then.
we will.
This is the going. What can be done?
But this,
I am passing an order. You are going to the appeal when you are mentioning the matter when the court is fixed. So record the presence of all the parties. The matter is specially fixed today, 11:30 on the prayer made by the counsel for the parties. But when the matter is called today, it is found that the arguing counsel is busy in the other court. Accordingly, the case is adjourned. Let the matter appear after the puja vacation. Yes, next call the matter.
May I only make one submission?
No, sir, Mr. Sen, sorry. I am fed up with this.
As your Lordship, that is why they have come up with the
that's
review.
why. Let
Your
it be.
Lordship will recall, my lord. That is why.
Already the suit is dismissed. Let them proceed.
Well, the only
difficult-
respondent number 5 who's not involved in all this, Malad, our remuneration is stuff.
Why the matter is mentioned? If your advocate is not ready to come before this court,
And they are supposed to reply.
that's why you have mentioned the matter.
My lord, we have mentioned.
Why you have mentioned?
May I?
And why you are agreed for the 11:30 when your advocate is very busy in the other court?
Your Lordship will make it CAV. We have all made our
Okay.
submission.
Hearing concluded, CAV.
Yes.
My lord,
Hearing concluded, CAV. Yes.
Yes. Obligation.
My lord, may I file a short note, my lord, to that?
Sorry. Not to play with the court.
My lord, may grant me was.
Why you are mentioning the matter? If your advocate is not having the time to appear before this court, why you are mentioning the matter and taking the time from this court by specific matter?
My lord, I apologize. My
Okay.
My lord,
Yes,
kindly,
yes, yes. What is the
This is the second round, Mallet. Point out, Mallet. But here, Mallet, the plaintiff, Mallet, I'll just come straight to the point, Mallet. Mallet, the plaintiff has supplied certain goods to my learned friend's client, and Mallet, they have acknowledged that there is a due of 99 lakhs, Mallet. Your Lordship remembers, Mallet, if your Lordship remembers, Mallet. And Mallet, Mr. Banerjee took the point that I have not served the plaint, and then he said that the property has been sold elsewhere, and he produced a sale deed, Mallet. And if your Lordship remembers, then I'll start from there, Mallet. Your Lordship had passed an order. Now, Mallet, now we find that they have not yet filed their application, affidavit in opposition to that application. Now, Mallet, will kindly appreciate we have taken out an application because this change of circumstances, Mallet. My claim, which is an admitted claim, Mallet, is now completely unsecured. And looking at the conduct of my learned friend's client, who, Mallet, if your Lordship remembers, show the letters, the 2 letters. They said that we are going to sell the property and settle it with you. Now they've sold the property according to their client, Mallet, according to their submission. And I'm lurching in the dark, Mallet. I don't have any security. But I'm seeking an injunction on their bank account, Mallet, to the extent of the amount which is due and payable to me. So this is the crux of my matter, Mallet. So
I am taking the point of maintainability because he has the first, his GA1, where he gets an ex parte ad interim, then he doesn't comply with 39(3)AB. That's a different aspect. It has the same price as this one has. In that, the direction for affidavits, which we are to file by Wednesday, and they have to file their reply, that matter is fixed. His praise here or his praise there?
You filed a separate application.
He's filed a GA2.
Yeah, point out, Mallet. Let us take the one of
So
the
I-
prayers.
What is the J1?
GA1, Mallet, first prayer was show cause for security.
Correct.
And Mallet, injunction on the property.
Correct.
GA2, Mallet, because obviously now I'm finding that they are trying to render my injunction, Mallet. Whatever, I have now come up, Mallet, for an injunction on the bank account. So, Mallet, these prayers are different. And it is on the changed circumstances. They were supposed to file an affidavit. They took an extension. Affidavit is yet forthcoming.
No, the time is not over.
No, first time it was over. You took an extension. So the point is, Mallet,
the plaint was not served.
Mallet, plaint I sought to serve.
No, but that's not us. And prayer, Mr.
today, my lord, that cannot be a ground in this application. With humility, I say. I've served the copy of the.
So you want to file affidavit?
Yes,
in
yes,
this?
my lord. And Lordship will keep the point of maintainability. His prayer D in GA1 is his prayer B in GA2.
When the GA1 is fixed?
GA1 is fixed on the 17th of July.
My lord, kindly seize my
Lordship,
prayer
have a look
B.
at the last order, my lord. Hey, this is the last order of 11th of June 2025. And there is an injunction. I say the property is sold. Your Lordship will recall, Your Lordship pointed out that I can't read Hindi. There was that the schedule was not there. So he said that no, the schedule is not there. The injunction is there on the property. And the court opined that for whatever it's worth, I'm extending the injunction. His same prayers, his prayers B, D in GA1 is his prayer B in
you
GA2.
do one thing. How soon? Because
I will adhere to this timeline. Not I'm settling the affidavit today.
Okay.
In the evening. Yes, yes. That I was supposed to file my affidavit in opposition within 2 weeks from June 11th. I'll keep to that. This matter is coming up on 17th of July, GA1. He has all those prayers there.
I am only on this if he has finished. But today your lordship was of the view that there should be an injunction. Whatever good, bad, indifferent now. Now, my lord, I have come up before your lordship. I've been able to demonstrate that prima facie they have already dealt with the problem. So, my lord, the finding of your lordship on that day, my lord, was that I was required to be protected. Now, my lord, whatever the matter is, because of the factual circumstances, my lord, I am not protected anymore. So, my lord, I've come before your lordship that this was the circumstances. There's a change in circumstances. Because on that day, I knew that there's this property. So, therefore, I took an injunction. Now, my lord, they have come up and said, look, we have sold it. So, my lord, I should be protected. So, I'm only saying that my lord will kindly protect me. I wasn't.
Okay, do one thing. The matter is fixed on 17. In the meantime, let he also file the by
affidavit
by 10 days. 10 days.
10 days, yes.
Come on 17. Both applications
can be heard of.
But at least let him assure that there's money in his bank.
Or he didn't get that order in the first application.
He's going to deal with it.
Well, he didn't
come
get
on
that order
17. Come on 17.
But in the first application, I never paid for it because I paid for the injunction of property.
Correct.
Now, my lord, today he
is. This application now is appearing. Let he get the chance to file the reply.
I'm only one point. It does not take me MS, my lord. My lord, I am before your lordship at an ad interim stage in this application. My lord, he is appearing definitely, my lord. My lord, that does not prevent me from seeking an ad interim order.
Correct.
Why I am seeking the ad interim order? Because, my lord, I am in a position where my rights are being defeated, and it is evident on the face of it. Because, my lord, today, my lord, he cannot dispute the fact that. Just a second, Mr. Banerjee. Let me complete. You make a submission. He cannot dispute the fact that 1 crore 14 is due to me.
No, I'm disputing that
fact. Just a minute, Mr. Banerjee. Please let me finish. Please let me finish. I'm not going to tell you anything when you're going to submit. My lord, from his scheme, your lordship has already found it that he has admitted 99 lakhs odd. It is admitted.
Correct.
Now, my lord, if it's admitted, my lord, I'm only submitting this, my lord. Kindly considers the conduct. This is Rahul Shah. Kindly considers the conduct, my lord. Today he comes up. He shows your lordship a schedule, a deed which doesn't have a schedule. Now, my lord, he says, I've sold it. That is his submission. So, my lord, your lordship's injunction for some reason, good, bad, indifferent, which I had taken on the good belief that yes, it is available, my lord, is now completely rendered infructuous. Therefore, my lord, I've come before your lordship because your lordship has held that I should be protected. Therefore, I'm coming before your lordship that till the time they do it, your lordship kindly protects me. If now today, my lord, he comes and says and shows that he has been sold, that property is no more there. My lord, then your lordship's first order. Well, it is not that because I've taken a choice on a property, I'm not entitled to any further orders.
No, that's correct. Now he's telling that this is.
But he'll come and say the money is also gone.
This is also the prayer deed.
But then may I make one submission?
Okay.
Let him disclose. Let him not. No injunction. Let him disclose whatever money he has as on today.
Correct.
I'll file an affidavit.
Let the file affidavit. He will not disclose. Naturally, if he will not disclose, naturally when the court
will kindly direct them to disclose.
No, my lord.
As on date, what
if
money
I
is,
don't disclose, if that is to his advantage, he will take advantage of it.
Because
I will not,
because
he is not a secured creditor.
Supreme for the plaintiff.
6 months later, he files an application, tries to get all orders.
Plaintiff has filed the application being GA-Com 48 of 2025, praying for interim order. Full counsel for the defendant submitted. The similar matter is fixed on 17th of July 2025 and prays for fixing the present application 17 July 2020. Counsel for the plaintiff pressing for ad interim order. with regard to prayer B of the instant application, prayer A of the instant application. Full stop. Counsel for the defendant submitted. The similar prayer has been made in GA1, of 2020 and GA1 of 2025, which is in prayer D, and he prays for hearing of both the application together. We have the above. The defendant is directed to file the affidavit in opposition by 4th of July 2025. After serving the copy to the learned counsel for the plaintiff, reply be filed by 14th of July 2025, 15th of July 2025. Let GA Com 48 of 2025 be placed along with GA Com 1 of 2025 on 17th July. Very great. Come on that.
I was only says, if your lordship could direct them, then let them, because one kindly appreciates.
Come on that.
Now Lesha also says, at this point of time,
his conduct is not. I have not even made my submission. I will not disclose
let the affidavit. Let the affidavit disclose. If it is not, we'll see to that.
He's coming back on the 17th.
Only the point that what money has got.
Come on that.
That is why, because my injunction has been lost.
Come on that day, Mr. Ray. Come on that day.
Grateful.
Yes.
Item 14, my lord, I appear on behalf of the defendant number 1. My lord, my affidavit is ready. My lord, I wish to file it, my lord, only that the client needs to see it, my lord, possibly tomorrow.
By
Day after,
July,
we'll be
reply
able
by
to file
19
it.
July. New
Yes, my
motion.
lord. Well, it's ready, only I need, my lord,
You are appearing for whom?
My lord, defendant number 1.
What about the defendant number 2?
Your lordship, I am for defendant number 2, your lordship. I have a demurrer point, your lordship. I filed my application as section 8 served. It is
What about this application? Demurrer, I will see to that. What about the GA1? Reply, where is the affidavit?
Lordship, it is ready, it will be account today.
And what about the 1, 4, 5, 6, 8? You are appearing for all.
I am only for.
On the last occasion, all are
appearing for all. My lord, we are filing one composite affidavit on behalf of all the appearing. My lord, 1, 4, 5, 8 to 16.
8 to 16. Yes, madam.
Lordships may be pleased to fix it tomorrow then. Everybody is ready to affirm it, your lordships. We are praying for an interim.
Where is the demurrer application?
Lordship, it's GA2, your lordship.
It is listed.
My lord, I'm sorry, my
served
lord.
the copy?
I'm only appearing for one. My lord, instruction.
What about the F? That's why I'm asking. On the last occasion, 1,
Yes.
5, 8 and 16 appeared.
My lord, we have instructions to appear only for one, my lord.
If my
Have you served the demurrer application? Where is the affidavit of service?
Your
lordship, they are accepting.
Have you received?
Yes, your lordships. I
Okay.
shall file.
What is the submission?
Your lordships, I shall file an opposition. I'm like.
Correct.
Respond.
What is the ground in demurrer?
Your lordship, there is an arbitration agreement between the plaintiff and the defendant number 2. Your lordship, that agreement I have already annexed, and they have relied on that agreement only. It's a memorandum of understanding, clause 11, your lordship. If your lordship comes to page 7, para 4 of my IA, and the document is also annexed.
Arbitration clause.
The clause is
This
set
is
out.
with regard to the defendant number 2.
Yes, your lordship.
What about the other defendants?
Lordship, once it comes for hearing, I will show that.
Okay.
Your lordship, affidavit of services.
Appearing for the plaintiff. Appearing for the defendant number. Who is for the defendant number 1?
Lord, I appear.
Appearing for the defendant number 1 and appearing for the defendant number 2. Counsel for the defendant number 2 submit that. Though on the earlier occasion, he has appeared on behalf of the defendant number 1, 4, 5, 8 to 16, but the defendant number 1 is, but the learned counsel is only having instruction to appear on behalf of the defendant number 1 only. Defendant number 1 only. So counsel for the defendant number 2 submit that the defendant number 2 has filed any.
Your lordship, the affidavit of service along with the notice of motion has been.
Defendants prays for extension of time to file affidavit in opposition.
Your lordships, a plaintiff.
1 week. File affidavit in opposition. Let affidavit in opposition be filed by when?
Within 1 week.
It's almost written.
By 1st of July 2025. Reply, if any, there to be filed by
Within 1 week.
by 10th of July 2025. Counsel for the plaintiff press for time to file affidavit in counsel on the defendant has filed an application being GA-Com 2 of 2025. What is the prayer in the GA2? GA2?
Lordship, the prayer is to Lordship, the prayer is at page 11, Your Lordship, to reference to arbitration and form, and in the meantime,
File an application being GA2 Com 2 of 2025, praying for referring the parties to the arbitration. Counsel for the plaintiff press for time to file affidavit in opposition. Let affidavit in opposition be filed by 2nd July. Why? 1st July.
Other defendants will not be.
1st July. 1st July, reply if any there to be filed. 10th July. List the matter. List both the applications being GA-Com 1 of 2025 and GA2 of 2025 on 16th of July 2026.
But the section 8 has not been served upon, but we are defendant of one, but has to be.
Defend number 1.
Your Lordship, 1 indulgence, 2 and 3. We am for 2 and 3. Defend number
what? 2 and 3. 2 and 3 करो. क्या बोलो पढ़ो. 2 and 3. हाँ. No. Dependent number 1. क्या करता है यार. ठीक है. Dependent number 1, though he had appeared on behalf of the 4, 5, 6, 18 to 16, but today he submits that he is only appearing for the defendant number 1. ठीक.
Lordship, before your Lordship takes up the next matter, may I submit my unconditional apology with regard to 11:30 matter, Millard, both the senior and
matter over, sir.
I'm really sorry, Millard.
My lord, in item number 15, I appear for the plaintiff. My lord, this is my injunction application, my lord. I will be taking step for servicing upon the defendants. But my lord, 1 week's time may be granted to effect service. Otherwise, I can move ex parte also. Yes.
For service? How many defendants are there?
Only one.
So offering for the plaintiff.
Paying for not this.
Counsel for the plaintiff submitted the notice.
Notice of motion along with the application.
Notice of motion along with the copy of the application being GA-Com 1 of 2025 could not be served of one defendant and pressed for a week time. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 3rd of July 2025. In the meantime, the plaintiff is directed to serve the copy to the defendant and to file affidavit on the next date fix. Next. Yes.
After this, the suit was filed, but we were served with a caveat. We have served them, but may I move the application? It's an application for essentially for judgment on admission with other prayers for injunction. It's an admitted claim.
But, may I file an affidavit? Because
may I press? I mean, led by Mr. Bose.
Kindly gives you a moment. This one. Yes. But on money suit arising out of price of goods sold and delivered unpaid. Well, the interlocutory application is based on judgment upon admission, but I want attachment of their bank account. I want security and for a direction for them to disclose their assets. But the claim, if your Lordship, may I just tell you, Lordship, if your Lordship kindly first turn to page 103, here your Lordship will find, there is no dispute on the fact that I have sold and delivered to them. There is no dispute of the fact that they have paid part of the money. Part consideration towards the price of goods sold and delivered has admittedly been paid by them. Now, the invoices which we have raised upon the defendant appears from page 14 to 102. None of them could be in dispute. I'll show your Lordship the subsequent documents. Kindly take first the document appearing at page 103. This is why I'm showing your Lordship the conduct part.
Yes.
But that, in my respectful submission, on the basis of that, we seek your lordship discretion at the ad interim stage for the purpose of passing an order of this nature. Now, kindly see, on 15 September, he furnishes a bank guarantee to the extent of the balance consideration which was due and payable. My lord, here your lordship will find Agarwal Pipe and Fittings is the defendant.
Yes.
So they were selling I am a manufacturer of pipes. My brand name is Ashirvad. So they were selling my brand. So now if your lordship will see, this is the bank guarantee that they furnish. Now my lord, by this letter, 3 crore. Now my lord, kindly see the bank guarantee, which is immediately thereafter. My lord, at page 105, I'll just show your lordship only one portion of the bank guarantee. At page 105, my lord, where it starts, to Ashirvad Pipe. So I am the beneficiary under the guarantee.
Yes.
My lord, lordship will kindly make a note of the claim expiry date, which is, my lord, serial number 7, 8th of September 2025.
Correct.
Now, my lord, your lordship will kindly see this guarantee has been given for what? What is the scope of the bank guarantee? Now, your lordship will see the last sentence of the first paragraph. In favor of the supplier, which is my clients, the plaintiff before your lordship, for the payment of the supplies made by the supplier.
Where from
My lord,
reading?
the first paragraph where dear sir in consideration, the last sentence, my lord, if your lordship sees serial number 15 and 16, there's a numbering on the left, 15 and 16.
That's why
Placitum
I thought
is
it
like
is the
a
serial number.
It's like an advanced placitum. 15 and 16. It says, my lord, the guarantee for the scheduled commercial bank such and such of rupees 3 crore in favor of the supplier for the payment of supplies made by the supplier.
Correct.
So, my lord, my claim period is till 8th of September 2025. So, it's still valid. Now, my lord, interestingly, what happens? Now, my lord, kindly see the balance confirmation which is given by them at page 108. And, my lord, kindly make a note of the date of the balance confirmation at page 108.
Yes.
30th of September 2023. Now, my lord, a party has failed to pay. There could be multiple reasons. I have to have my claim adjudicated. Now, my lord, taking recourse to fraudulent means is something very different. So that is where the conduct part comes in. My lord, kindly see 30th of September 2023 gives me a balance confirmation.
Yes.
Now, my lord, kindly see, immediately thereafter, your lordship will see page 109, which is a part of page 108, is the statement, the customer ledger. Now, my lord, kindly, this customer ledger comes to an end at page 128. All the goods that I have sold, and my lord, at page 128, your lordship will find absolutely the net balance at the extreme bottom right.
3 crore 56.
Correct. And my lord, see the seal of the company, the signature.
Agrawal Pipe.
Correct. Now, my lord, then starts my demands. Now, I'll show your lordship one demand and the response to my demand. My lord, kindly take first page 129 towards the bottom of page 129. I just wish to draw your lordship to a trail mail, just to response. I say, my lord, I am Agarwal Pipes. Phani Kumar is my representative. And my lord, their representative is Madhusudan Ajit Saria, which is the proprietor. Now, my lord, kindly take the bottom of page 129. Your lordship will say, dear Madhu sir, which is the defendant, please look into the current overdue of 3.40 crossed over 100 days. Now, my lord, kindly come to the upper portion of page 129.
Who has sent this mail?
This mail has been sent by the plaintiff to the defendant.
Ani Kumar Kota, it is you.
Yes. No, my lord, kindly see the bottom of the page. Dear Madhu sir, I am sending. Phani is me. So I send the statement at 129, my spilling over to 130. What I wish to show your lordship is the upper portion of page 129, which is the response to this mail of mine.
Correct. Madhusudan has given.
Correct.
This is a defendant.
Yes, he's the defendant, the proprietor of the defendant firm.
Yes.
Well, kindly see what he says. We were not expecting things will become such after 19 years of hard work. We had discussed ways to resolve the impasse, and this regard had a discussion with Mr. such and such, and a meeting was supposed to be happening on such and such. March closing outstanding was 11 crore. Plus channel finance of 4.2 crore, which has now been reduced to
3.40. Admission.
Complete admission. My lord, this is not the only admission. Thereafter, my lord, there are multiple exchange of correspondence between the parties. Then, my lord, interestingly, your lordship will see, lordship kindly comes to page 133. 133. My lord, I realize that this money is not going to be paid. So then I invoke the bank guarantee and I write to the bank. Now, that is my invocation letter is at page 133. 31st of January 2024.
Yes.
And my lord, your lordship will be, my lord, we were shocked. I think your lordship would be at least surprised. My lord, kindly take page 135, the letter of the bank. This is the response of the bank. At page 135, after I invoke the bank guarantee, this is the reply to the invocation of bank guarantee. And your lordship recalls, my lord, the bank guarantee valid till September 2025. I am the beneficiary. So he is writing, with reference to your letter of 31st January, it is informed that the captioned bank guarantee has been closed in our records on 6th October 2024. Your lordship recalls, my lord, that admission letter, 30th September, they have given that admission letter. And in 30th of September, which is at page 129, he admits. So after 6 days, now, my lord, your lordship will kindly allow me to read on. Closed in our records on 6th October, pursuant to the receipt of original bank guarantee, along with the request letter dated 4th October 2023 from the applicant Agarwal Pipe and Fittings, or cancellation of the aforesaid bank guarantee for, I stand corrected, received at our Calcutta office on 4th October 2025. Now, my lord, interestingly, my lord, kindly keep this, my lord, kindly read this with page 103. The original bank guarantee, he had given it to me.
Yes.
So how did the original was produced by him before the bank guarantee, and he cancelled it on the 4th of October, realizing 30th, when I make the demand at page 127, he says that 340 is due after confirmation. So after 4 days, he goes and cancels the bank guarantee, realizing that now I'm going to invoke the bank guarantee. Well, that's how the commercial world functions. Now, my lord, it doesn't stop here. Now, my lord, he withdraws the bank guarantee by giving original. So what he has done is, he's forged the bank guarantee. The bank guarantee which he has given to me, because if the bank, I have to consider that the bank guarantee that was given to me in the letter, which is at page 103, was the original bank guarantee. Now, what he has done, he has gone to the bank and furnished the original bank guarantee. So it could not have gone. So there cannot be two originals of one bank guarantee. So what he gave it to me is a forged bank guarantee. So what do? I file a complaint. Now look at this. My lord, in a bail application, what he says, my lord, kindly take page 137. I'll show your lordship one paragraph in the application for bail that he, I stand corrected. It's a 482, my lord, criminal revisional application.
No.
Huh?
Bail.
Why I stand corrected. Now
Yeah.
it is the bail. Yes. BNSS. My lord, so my lord, this is the anticipatory bail application. My lord, I just wish to draw your lordship and to one paragraph. Para 150, page 150, paragraph 16, 16.
Yes.
Well, kindly see this. Kindly see para 16. Well, towards the middle of the paragraph, your lordship will see, in regard to the rest D of 337, the reconciliation was going on. So here also there is an admission in his anticipatory bail application. So, my lord, under these circumstances, my lord, if this is the conduct of a party who owes money and he admits, well, I just wish to draw your lordship's attention to two prayers in my interlocutory application, which I seek at this stage, my lord. My lord, kindly, because, my lord, that Rahul Shah judgment, my lord, indicates in a money claim what is the scope. Now, your lordship has to, my lord, apply your lordship discretion, my lord, in a claim of this nature, because, my lord, unequivocal admission of the debt. Now, my lord, one is admission, the other is the conduct. So basically, my lord, if I don't get protected at this stage, my decree, which I am likely to get, and I've got sufficient reasons to believe that I will get a decree, it will become a paper decree. Well, a person having a conduct of this is also not a company, it's a proprietor. He will sell, transfer, do everything. I'm not kindly take, my lord, prayer B, which starts at page 10. My lord, I seek an injunction restraining him from operating the bank accounts, which is at para 21, without leaving behind a sum of the admitted debt. Then I am asking for security, and I'm also asking for affidavits to be disclosed in terms of Rahul Shah judgment.
Yes.
Well, these are my respectful submissions. But conduct is such, my lord.
No, my lord, we need to file an affidavit to that. But before that, my lord, the defendant, my lord, Agarwal Pipes and Fittings is a partnership firm that is known to them. It is not a proprietorship firm, my lord, concern, my lord. Now, my lord, initially, my lord, the suit has been instituted. Possibly, my lord, institution of the suit is bad, my lord, because my lord, it has to be instituted in the name of Agarwal Pipes and Fittings. I am not the proprietor. I am one of the partners. Now, my lord, so far as my lord, the issue relating to bank guarantee is concerned, my lord, criminal proceeding has been initiated, my lord. Police is yet to file the charge sheet, my lord. Charge sheet has not yet been filed. We are on bail, my lord. Now, my lord, I was just seeking, my lord, that these are issues of 2023, my lord. Till this period, my lord, they have waited, my lord.
How you can revoke the bank guarantee, which is up till the May 2025, September 2025?
My lord, that we can explain that because my lord, we have also
Okay, you
sufficient
explain.
counter.
I am directing to maintain that account. You explain all the things. You cannot go in both hands. You have given the bank guarantee of 3 crore.
My lord, I have
up till the September 2025, and you have revoked the bank guarantee. You have taken the bank guarantee. Correct. And admitting that
My lord,
3.40
that situation we shall be
and
able
in
to
the
explain.
application also, in the bail application also, you admitted that it
No,
is
not admitted, my lord. That is
you settled. Kindly come to the page 150.
In this regard, the rest of the dues of rupees 3 crores 37 lakhs 37, the reconciliation was going on.
Then
and the firm of your petitioner will definitely settle the claim to the present company, but it must be brought down to a legitimate figure after reconciliation by and between both the parties. Well, it was subject to reconciliation. Well, it is not that we are admitting that amount, my lord.
Reconciliation, but you admit some amount is there.
My lord, because my lord, certain goods are lying with us that we have intend to hand it over. There are certain claims, my lord, which we are entitled to, my lord. As my lord, they are distributors, my lord. We are also entitled to certain.
First, you have to justify why, under which circumstances you have revoked the bank guarantee.
That we shall explain in the affidavit.
Hearing now, I am hearing the ad interim. If you want to oppose the ad interim, you explain that. If I satisfy, I will give you liberty to file affidavit. You satisfy this court how you have revoked the bank guarantee, which was up till September 2025. That is the only question here.
Lordship, in that event, my lord, can I take instruction tomorrow, my lord? Only.
No. Tomorrow, then other advocate will come?
No, my lord. I shall, my lord.
No. Sorry.
Because I have also appeared in the mediation proceeding, my lord.
How the cases has been tackled here?
My lord, kindly give it tomorrow, my lord. We shall, my lord, explain.
So appearing for the plaintiff. So appearing for the defendant. The plaintiff has filed the present application being GA-1 of 2025, praying for ad interim order.
May I have your lordship kindly, my lord?
Full stop. Ad interim. Counsel for the defendant pressed for time to file affidavit in opposition. Full stop. The plaintiff has filed a suit against the defendant, praying for. Where is your prayer in the suit? You're not disclosed here.
No, but the plaint is annexed at page 169.
169.
Yes, volume 2, Manoj. And the reliefs are at page 175.
Has prayed for a decree for a sum of rupees 3,37,40,888 along with interest at the rate of 18% per annum. Full. Counsel for the plaintiff submit that the plaintiff has supplied the materials to the defendant and the invoices have been enclosed in the present application, disclosed in the present application. The defendant has issued the bank guarantee of rupees 3 crore in favor of the plaintiff. And the validity of the said bank guarantee is 8 September 2025. September 2025. Full stop. In the bank guarantee, it is also mentioned that the bank guarantee is in favor of the plaintiff for the payment of the supplies made by the supplier. Full stop. Counsel for the plaintiff submit that and full stop. This could also find that the defendant has also admitted the claim of the plaintiff for a total sum of rupees 3.40 crore. The plaintiff has also relied upon the confirmation of account which was duly approved by the defendant. The plaintiff has brought to the notice of this court, the counsel for the plaintiff has brought to the notice of this court to the email dated 15th November 2023, wherein the defendant has admitted the claim of the plaintiff for a sum of rupees 3.40 crore. Though the bank guarantee of rupees 3 crore is valid up till 8th of September 2025, but when the plaintiff has approached the bank for realization of the said amount, the bank by a communication dated 6th of February 2024 informed the plaintiff that on 6th of October 2024, on receipt of the original bank guarantee along with the request letter dated 4th October 2023 from the defendant, the bank guarantee has been cancelled. When the plaintiff came to know that the bank guarantee, though it was valid up till 8 September 2025, but the defendant has cancelled the said bank guarantee. Accordingly, the plaintiff has made a complaint before the concerned police authority, and the police authority has initiated a criminal case against the defendant, and the defendant has filed an application for grant of bail, wherein the defendant has in the bail application the defendant has stated as follows, page 150 paragraph 16. Page 150 paragraph 16. बीच में आएगा, quote कर देंगे. Counsel for the defendant submits that the defendant has never admitted the said amount, and the defendant will disclose all the document in the affidavit in opposition why the defendant has cancelled the bank guarantee. Consider the above, this court find that the plaintiff has made out considering the above, this court find that the plaintiff has made out a prima facie case and balance of convenience and inconvenience in favor of the plaintiff. This court also find that at this stage the plaintiff ad interim order is not passed, the plaintiff will suffer irreparable loss and injuries. Considering the above, the defendant their man, agent, servants, assigns are restrained from disposing or removing or siphoning off any fund or operating any bank accounts linked with the permanent permanent account number within bracket PAN without keeping aside the amount of rupees 3, 37, 40, 888 till 17th of July 2020.
My lord, I am raising the issue of maintainability of this suit, my lord, because my lord, it is not a
plaintiff is directed, the plaintiff is directed to serve the copy of the plaint, documents, application and the document enclosed therein to the defendant immediately and to file affidavit of service on the next date fixed. List the matter.
My lord, only thing, my lord,
the matter on 17 July 2020.
The issue of maintainability, my lord, we kept because
Counsel
it
for
is
the plaintiff counsel for the defendant submits that the plaintiff has raised the issue of the maintainability, the maintainability is kept open.
Because it is my
the maintainability has been and the point of maintainability has been raised by the counsel for the plaintiff after dictating the order.
Defendant, my lord, that my lord, I have indicated initially, my lord, because it is not a it is on account of
prayer D.
it is on account of partnership
Disclosure of assets. Prayer D.
Come on, let
my lord, may I indicate, my lord, it is my lord a partnership form, my lord.
Come with an application.
Only my permanent account number, my lord, may not be attached, my lord. Because my lord, it is my personal permanent account number, my lord. And my lord, it is on account of the partnership form, my lord, that use.
Call the letter.
Plot 17, I am for the plaintiff. There are two applications appearing filed by the defendant.
Your Lordship, I appear for the defendants. We had a change brief, Your Lordship. Seeking for a week's accommodation. We also need a few cause papers which are still pending. We are yet to receive them.
Affidavits are completed in both these applications.
Yes, pleading. What is the applications?
Look, these are two applications they have filed. One for revocation of leave granted for filing the plaint, and the second is for rejection of the plaint. Both are on similar grounds. The ground is that there's an exclusive jurisdiction clause subjecting to Gurgaon, and we have filed here.
Yes.
This is the
Lordship, we had a change brief.
Sense appearing for the plaintiff. Sense appearing for the defendant. It is fine from the record that pleadings in connection with GA3 and GA4 of 2025 is completed and matter is ready for hearing. Counsel for the plaintiff defendant prays for time. In view of the submission made by the counsel for the defendant, case is adjourned. Let the matter appear on 21st of July 2020. Next.
My lord, one more thing, my lord, your lordship had already directed for discovery inspection, my lord. Plaint, the defendant have filed the written statement. We have offered them 3 times, my lord. They have not provided discovery inspection, neither have they taken discovery and inspection of our documents, my lord.
Lordship,
If that be
we
closed.
would be requiring some time.
If
counsel for the plaintiff submit that you all already completed.
We have offered them. They have not taken, so we'll
for the plaintiff submit that the plaintiff has offered the document to the defendant for inspection, but the defendant has not come forward either for complete the inspection nor the defendant has disclosed their document for inspection. Counsel for the defendant prays for time. In view of the submission made by the counsel for the parties, the plaintiff is directed have already disclosed.
Yes, my lord.
The defendant is directed to complete the discovery and complete the inspection of the document of the plaintiff by 10th of July 2025 and also to disclose their document to the defendant by 10th of July 2025 and the plaintiff is directed to complete the discovery and inspection of the complete the inspection of the document of the defendant by 15th of July 2025. In the meantime, the parties are also directed to exchange their suggested issues. List the suit on 21st of July for framing of issues.
Item number 18, I'm appearing for the plaintiff petitioner.
But before my learned friend starts, my lord, my client's instruction is perhaps a copy has not yet reached them. I am told that
what is not reached?
the copy of this application. This is a new application that has been taken out. My lord will recall here, my lord had disposed of my recall application by a judgment and order. My lord, thereafter some application has been filed. It's not with us at present. Let me, my lord, take instructions from my client whether it's been
order is
received.
passed?
My lord had, my lord initially had waived the or dispensed with issuance of formal writ of summons since a copy of the amended plaint was handed over to my advocate on record. Thereafter, we filed an application for recall. My lord had modified the order, had not recalled the order, had modified the order, directing them to amend the cause title of the plaint to reflect.
Yes, I remember.
For incorporate the registered address of the defendant
ah,
company.
yes.
That has been done, Your Lordship. A copy of the affidavit of service.
What
copy
you have
has-
done? What affidavit of service?
No, affidavit of service for I have for forwarding the amended copy of the plaint to the dependent company. Other two registered two addresses. One is the registered address that is in Mumbai, which has been freshly incorporated. Another one which was already pre-existing, Shakespeare's Horoni, Your Lordship. As per the endorsement, Your Lordship, I have found that they have also already received the copy of the application along with the amended plaint at the registered
directly,
office.
You send directly or through the?
No, through department, Your Lordship. Master summons was
Have
taken.
you received the report?
Yes.
Report is here.
Report is not with me at
Then
present. No, report is not.
obtain the report. If it is received,
Very-
then I will
very-
proceed the matter.
Very well, Lordship. Can you keep it tomorrow?
Or you will get able to obtain report.
No, Your Lordship kindly provides me some time.
So and so suffering for the plaintiff. So and so suffering for the defendant. Counsel for the plaintiff submit that the plaintiff has taken appropriate step for issuance of fresh writ of summons upon the defendant, but he has not obtained report whether it was served or not. Accordingly, press for time. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 15th of July.
My lord, in the meantime, could a copy just be given to? I understand.
Then again, you will come with an application.
For that
I
reason, I
understand.
sent it to the
That's why I was reticent in making that.
Grateful.
Your Lordship, appear for the plaintiff, Your Lordship.
My application.
Yes.
Your Lordship, I'm being led by Mr. Jantosh Gupta is appearing virtually, Your Lordship.
Reply is ready on our part.
Where is your affidavit? Reply?
Reply is ready. We have already solved them.
What is the application for?
For
Year 2?
time to file written statement, Your Lordship.
Time to file return statement. How many days delay?
It is out of time by 30 days. We have not yet. It is ready
Before
on
120?
Before 120. Sir.
Before 120. So what is the objection?
My lord, they have not come up before your lordship with clean hands. My lord, the writ of summons was served on 15th of March. I have annexed the sheriff's report with my opposition, my lord. Now, despite that, my learned friend's contention is that it has been served on 24th of March.
Where is that affidavit in opposition? Affidavit in opposition, kya hai, Babu? Yes. Page number?
Just gives me a moment, my lord. My learned junior is also there, my lord, to assist.
Page 6, Your Lordship. Annexary.
Item delivered on 15th of March.
Yes.
2025. What is their contention?
That they have received it on 24th of March, my lord. And my lord, till date, the written statement has also not seen the light of the day.
Yes. How you have dealt with the page 6? How you dealt with the reply?
In reply, I have.
Which paragraph dealt with the annexure A?
Speak proof thereof.
Strict proof thereof.
Yes,
So there is an official report.
But according to our instruction, Your Lordship, we have received on that
The
day.
court will go by the official record or as per your instruction.
Your Lordship, the written statement is ready on our part. It is.
If the 15th March is taken with the you out of the 120 days.
No.
Then
of course not.
So why you are on that? When
No.
you file the written statement?
Written
Where is the written statement? You filed?
No, it is
Not yet filed.
It cannot be filed, Your Lordship.
Achha?
Without the leave of the court. I have tried to file.
Have you taken the leave?
No, I have not.
Then?
Because the matter is pending before Your Lordship.
Gone.
If the matter is pending, we
Where is the written statement? You are not include the written statement along with this.
no. When it was affirmed, your lordship.
When you are affirmed the written statement.
18th, your lordship. 18th of June. And it was affirmed on 10th, if I'm not wrong. 10th, yes. According to my
Still you are not aware of the what this court has taken the process with regard to the filing of the written statement in the commercial division. If you are not filing within 120 days, within 30 days, still you are not aware of that.
No.
You're not in the not the bar member.
No, I am not the bar member.
You're not the bar member.
I am the advocate records junior.
No.
I'm
So how you are practicing here? You are not a bar member.
No, I am practicing was right to practice is there, your lordship, but not.
You are not a member of any of the bar of the Calcutta High Court.
No. Right to practice is there, your lordship, but it is not necessary to have the association in any.
If you how you can know what is the process? You don't know. The total bar knows how what process has been adopted by this court with regard to the filing of the written statement. It is not filed within 130 within 30 days.
Then your lordship kindly adjourn the matter for a day, your lordship. Let me come back.
15 March.
15 March.
15 March. When you accept, when you affirm the written statement?
On 18th of June.
18th of June. Yes, Mr. Sengupta.
Well, it's more just beyond the 90 days period.
120.
Yes, 120 would have been the day. So, well, whatever falls from your lordship, but I haven't been served with a copy of any written statement as of now.
Show me your written statement.
In fact, exactly 100 days, my lord. Just calculated it.
18th June.
18 June would be around 95, 96 days.
Sense suffering for the plaintiff, sense suffering for the defendant. Sole defendant.
Sole defendant.
Sole defendant. The defendant has filed the present application being GA within bracket
File the copy to the other side, your lordship.
2 of 2025. Praying for extension of time to file written statement. Extension of time. Counsel for the plaintiff submit that the defendant. Counsel for the defendant submit that the defendant has received the writ of summons on 24th of March 2025 at Punjab, and the defendant has entered appearance on 8th of April 2025 by filing Wakalatnama. The defendant could not file the written statement by 23rd of April 2025, that is within 30 days from the date of receipt of the writ of summons. Counsel for the defendant submit that the documents which the defendant has relied upon is lying in the registered office of the defendant at Punjab, and the same was sent to the advocate on record of the defendant Kolkata. Due to transmission of the documents for preparation of the written statement, the 30 days was over, due to which the defendant could not file the written statement. He submits that though the defendant has not filed the written statement within the 30 days, but the defendant has affirmed the written statement, prepared the written statement, has affirmed the written statement on 18th of June 2025. 18th of June 2025, that is within the period of 120 days. And as such, he prays for acceptance of the written statement. Per control, an advocate appearing for the defendant raised objection and submits that as per the report of the Deputy Sheriff of Calcutta. The writ of summons was served upon the defendant through the postal service on 15th of March 2025, not on 24th of March and not on 24th of March 2025, as stated by the plaintiff, as stated by the defendant. Counsel for the plaintiff further submit that defendant has not shown any cause why the defendant has not filed the written statement within the period of 30 days. The counsel for the defendant also raised the objection if the defendant has affirmed the written statement, why the defendant has not disclosed the said written statement in the present application. He prays for rejection of the application. Heard the learned counsel for the respective parties peruse the materials on record. This court find that as per the report of Deputy Sheriff of Calcutta dated 8th April 2025, the writ of summons through the postal services was served upon the defendant on 15th of March 2025. The plaintiff and the defendant has not shown any contrary document or evidence to establish that the writ of summons was served upon the defendant on 24th of March 2025. We'll take the 2025 full stop. Even though if it is taken that even though if this court taken into consideration with regard to service of writ of summons upon the defendant on 15th of March 2025 and the affidavit affirmed by the affidavit of the written statement affirmed by the defendant is on 18th of June 2025, that is within the period of 120th day, within the period of full stop. The defendant in the application has categorically mentioned that the regional office of the registered office of the defendant is at Punjab, and due to transmission of the documents from Punjab to Kolkata and for preparation of the written statement, 30 days was over, due to which the written statement could not be filed. This court find that the defendant has shown sufficient cause for non-filing of the written statement within the period of within a period of 30 days, but has filed the written, but has affirmed the written statement, which was shown to this court, affirmed the written statement on 18th of June 2025 within the period of 120 days. Thus, this court is of the view one opportunity should be given to the defendant to file the written statement, subject to payment of cost of rupees 5,000 to the State Legal Service Authority within a week from date. There is no counter claim.
There is no
Counter claim. There is any counter claim. Full stop. The department is directed to accept the written statement, subject to scrutiny by the department. Full stop. The defendant is directed to serve the copy of the written statement in course of the day.
During the course of the day. I have already filed.
Of the day. And the defendant is also directed to furnish the proof of payment of the cost to the State Legal Service Authority on the next date fix.
Your Lordship,
the GA number, GA Com 2 of 2025 is disposed of. Yes.
Your Lordship, with regard to previous order, Your Lordship, kindly takes out 9 June 2025. Instead of, in paragraph number 3, instead
Paragraph
of
3, Your
defendant, Your Lordship, it will be plaintiff.
And on the fourth paragraph, it will be defendant instead of.
Defendant pays for time to file affidavit in reply. Which one?
Your Lordship, paragraph 3, the defendant has filed if it is
affidavit in
option, it will be
opposition. After serving the copy to the London Counsel for the plaintiff.
Lordship, that will be the plaintiff has filed the opposition. We are for the plaintiff.
Counsel for the respective parties. Counsel for the respective parties draw the attention of this court to the order dated 9th of June 2025, wherein in paragraph 3, this court has recorded that the defendant has filed the affidavit in opposition, but that should be recorded as plaintiff has filed the written filed affidavit in opposition. Simultaneously, in the last line of the said paragraph, the learned counsel for the instead of the plaintiff, the word shall be read as defendant.
And the written statement has been filed, Your Lordship. I have already
They have
handed.
just been served out.
Grateful,
Lord.
Grateful, man. Deeply obliged.
Yes.
Madam, I have to fix a date, only today for hearing.
We don't yet have any clarity with regard to the.
No, look, we have inquired from the.
Let
OST.
the communication
OST.
be made. We have also inquired, we understand that.
No, can't be. OST, we have asked, and it's before this bench. I don't know why this.
Okay.
Kindly
I am fixing a date for hearing. In the meantime, it is assigned. It is assigned. It is there. It is there. There is
absolutely
no problem.
grateful.
Yes, Mr.
What Mr. Shah has said, Milord, I don't think anything else is to be said. Only thing, Lord, as I was requesting on the last occasion, Your Lordship fixes a date. Let the file go before the Honorable the Chief Justice so that a clarification can be at least
It's
made.
not your persons are the senior most. That is not the procedure for sending the. If I release, that's why I'm telling.
I'm not.
If both the parties says it may release.
No, Malad,
I have
today,
no
Malad,
difficulty
it has
for release.
come up for Malad fixing a Malad date for hearing. Malad, can you do that?
I am not.
Let's not
praying
get
for
into
a
this,
delay
Malad, unnecessarily.
because we have said that Mr. Banerjee's client has objection. I don't want to say that. Since, Milord, we have given a letter, we have not yet received any official communication. Maybe, Milord, if the file is sent, keeping the matter in the list or on record, so that a clarification.
No, this kind of procedure, I'm so sorry, Malad. I have to disagree, Malad, with the learned advocate general.
I am fixing a date.
Yes, Malad, kindly fix it.
But if your Lordship may kindly record.
Kindly fix a date.
Please record.
I will record. A date there. So-and-so appearing for the petitioner, so-and-so appearing for the respondent. It is submitted by the learned counsel for the petitioner that still no order has been received from the office of the Honorable Chief Justice of the Court, whether the matter is assigned to any other court or is remain with this court. Full stop. Counsel for the learned advocate general submits that the record of this court, record of this case may be sent to the Honorable Chief Justice for taking decision. But this court find that there is no procedure for sending any file, record of this of the case to the London Honorable Chief Justice unless and until it has been called for. It is found that both the parties have made their representation before the Honorable Chief Justice. It is the Honorable Chief Justice to take decision. If required, if the Honorable Chief Justice will require the record, naturally this court will send the record to the Honorable Chief Justice. In view of the above, it is found from the record, the pleadings have been completed, the matter is ready for hearing. Let the matter appear on.
But sometimes after 4th.
I will be in some difficulty.
First, second, and third.
When? After the 4th of July.
It will come on August.
July, kindly, I was praying. It's quite a.
24 July at 12:30. 24 July 12:30.
Is it possible, Malad, any day before that or Malad?
Before that, because till 12th there is a problem. Then कुछ और कोई डेट नहीं है उससे पहले. Come on
17th, 18th,
24th,
17th, 18th, है ना?
नहीं है.
हाँ?
24th.
Come on 24th July at 12:30.
I'm grateful.
Oh, then sorry, can we Malad 22nd? 23rd?
21st, 22nd, 23rd.
21st I mean 23rd. 24th था को. Very well.
I'm grateful.
24th Malad at
12:30.
12:30.
Malad, my witness is here. Witness for the defendant number 1.
Yes.
Chief will begin.
Yes.
I solemnly affirm
that whatever I depose
that whatever I depose
by way of evidence,
by way of evidence,
I shall speak the truth.
I shall speak the truth.
No part of it shall be false,
No part of it shall be false,
and I shall not conceal anything.
and I shall not conceal anything.
What is your name?
Sandeep Sethia. Sandeep Sethia.
Sethia spelling?
SUNDEEP.
NDEEP.
Sethia. SETHIA.
SETHI. Father's name?
Ranjit Singh Sethia.
Ranjit Singh Sethia. Your age?
61.
Occupation?
Businessman.
Residential address?
I live in Mundwa, Pune.
Sorry, sir.
Mundwa, MUNDHWA. Do you want the full address or?
Full address.
Okay. F101.
101.
Satellite Towers.
Satellite Towers.
Mundwa,
Dua.
Pune.
Pune.
411036.
411036.
May I begin? Mr. Sethia, what is your connection with this suit?
I am the director of the defendant number 1.
Since when have you been a director of the defendant number 1?
Since the 31st of March, 2005.
What are your academic qualifications?
I have a master's degree in engineering, economics and management from the University of Oxford. Engineering, economics and management.
And management.
University of Oxford.
University of Oxford.
Are you aware of the facts and circumstances of this case?
Yes, I have gone through the records and I am aware of the facts. Aware of them.
What is the business of the defendant number 1, RK Agencies Limited?
RK Agencies Limited is in the business of tea trading.
Tea trading. Tea trading.
And what is the connection between RK Agencies Limited and the plaintiff, Central Bank of India, insofar as the disputes in this suit are concerned?
In 1984, RK Agencies Limited deposited 20 lakh rupees with the Central Bank of India, Calcutta main branch. Upon maturity of the fixed deposit after 6 months, RK Agencies sought refund of its fixed deposit.
Sought refund.
Of its fixed deposit. The bank denied refund and RK Agencies was constrained to file suit CS 297 of 1987. 1987. The suit was decreed in favor of RK Agencies on 3rd February 2012.
Was there any appeal preferred from the decree you have spoken of?
Yes. Decree, appeals were preferred before the division bench and before the Supreme Court, and the decree was upheld in 2014 and 2017.
Has RK Agencies Limited executed this decree?
No, we tried to execute the decree.
No.
In 2017, but the bank was able to obtain a stay on execution of the decree by depositing 1.29 crore rupees with this court.
With this court.
This court. was such deposit made pursuant to any order of this honorable court?
Yes, the interlocutory judge directed the bank to deposit the money before confirming the stay, and the stay was
Before confirming the stay,
and the stay was confirmed until disposal of this suit.
until disposal of the present suit.
Just for clarification, Mr. Setia, was this order passed in the present suit, CS 107 of 2017?
Yes.
Yes. Now you have spoken about a fixed deposit. Do you recall what was the interest payable on that fixed deposit of 1984?
The original interest on the fixed deposit, which was for 6 months, was 6% per annum. The instruction of the advocate of RK Agencies Limited at the time of making the deposit instructed the bank to renew the deposit for identical periods, compounding the value at deposit rates prevailing from time to time.
International division. Now, prior to filing the suit of 1987, which you mentioned, did RK Agencies Limited seek refund of the fixed deposit from the bank?
Yes, the bank directed RK Agencies to contact its international division at the head office in Bombay.
So, can I take it that the original fixed deposit was deposited in Calcutta?
Yes, at the main branch, Calcutta.
Except it's disputed. It's not a disputed fact. I'm just clarifying. Listen. Yes. Now, do you recall what the reasons given by the international division were for not refunding the fixed deposit?
The international division wrote to the advocate of RK Agencies and said that the money of the fixed deposit was being retained by the bank under lien, LIEN, for its litigated claim against SL Sathya Liners Limited in London.
Was there any agreement in writing between RK Agencies Limited and the plaintiff bank in such regard?
Nothing at all.
Now, who was the plaintiff in the 1987 suit?
RK Agencies Limited.
And who was the defendant?
Central Bank of India.
Before obtaining the decree, were any orders passed in the 1987 suit?
Yes. At first, RK Agencies Limited made an application for a summary judgment against the bank. The bank filed an affidavit in opposition in 1987 to oppose this application for summary judgment.
Now, do you know what the defense taken by the bank was in their said affidavit?
There were basically two defenses. On the one hand, the bank said that the fixed deposit had been arranged for payment of decretal debts owing to the bank in London. On the other hand, the bank said that it was prevented from refunding the fixed deposit by a blocking order of the Reserve Bank of India, dated 5th of September 1986.
Was the contention regarding the blocking order mentioned by the International Division in its letter prior to the suit?
No, the letter of the International Division was dated prior to the blocking order of the Reserve Bank of India.
Besides the blocking order, are you aware of any other order or permission granted by the Reserve Bank of India relating to this fixed deposit?
Yes. I just wanted to add to the answer to the previous question. Sorry.
He wanted to add something to
the first witness volunteer. First witness.
Well, he can answer in this question itself.
Yeah.
But yes,
you continue. You can say that.
The International Division did not mention Drum Place Limited when it wrote to RK Agencies Limited, but the affidavit in opposition introduced Drum Place Limited in the defense in this new defense 2 years later.
Yes, the question he's answered the previous question.
Earlier. It was
Just
taken
repeat
as a
the
volunteer.
next question. ওনাকে repeat করেন প্রশ্নটা।
Yes, indeed. The bank approached the Reserve Bank of India for permission to adjust its claim against SL Setia Liners Limited in London. And the Reserve Bank of India refused this permission. The bank did not disclose this correspondence. It was discovered when the judge called the RBI to give evidence. And the RBI disclosed it.
What was the result of the application for summary judgment, which you referred to?
A summary judgment was given against the bank. However, it was overturned on technical grounds on appeal.
On technical grounds in appeal.
And the matter was returned to suit.
Did the bank contest the suit of 1987?
Yes. It filed written statement in 2004. And it amended the written statement in 2006.
2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 2006. 20
what was the stand taken by the bank in its written statement filed in 2004? Do you recall?
Yes.
Show it to him.
In 2004, the bank continued to assert that it held decrees against the English companies. It changed its stand by saying that it had already appropriated the fixed deposit in spite of the blocking order of the RBI continuing to be in force. And it had adjusted the decretal debts of the London companies and Ranjit Singh Sethia.
By English companies, which companies do you mean?
I'm trying to save ink, but I mean SL Sethia Liners Limited.
No, answer the question.
No. I mean SL Sethia Liners Limited and Drum Place Limited.
Did the bank have a decree against SL Sethia Liners Limited?
The bank had no decree against SL Sethia Liners Limited. This is clear now. But for 30 years, all throughout the suit of CS 297 of 1987,
97 of 1987,
the bank repeatedly bluffed to the court that it held a decree for the debt of SL Sethia Liners Limited.
Did the bank have a decree against Drum Place Limited?
The bank disclosed a copy of a default judgment that it obtained before the Queen's Bench Division of the High Court in London on the 9th of January 1985.
Was this decree against Drum Place Limited disclosed in the suit of 1987?
Not at first. But when the bank was asked to produce a decree against SL Sethia Liners Limited, it disclosed the decree against Drum Place Limited. The bank didn't inform the court that it had already executed the decree
That he had already executed the decree
in London on the 21st of October 1985, and Drum Place Limited had been wound up and a receiver had been appointed on the company.
Now, you stated that the written statement was amended by the bank in 2006. Do you know whether any application for amendment was filed before this honorable court?
Yes, the bank filed an application in late August.
Exhibit 1.
In late August 2006.
Annex question. No. Where's the annex to? This one. I am showing you exhibit 1/3. Exhibit 1/3 in this suit, brackets being DD 46 at page 249 to 262 of the judge's brief of documents. Can you confirm that this is the application made by the bank? 249. Yes. And after perusing the document, can you tell my lord what was the reason sought for amendment? Sought for amending the written statement. What was the reason given for amending the written statement?
Yes, this is the document. The main reason for amending the written statement is given in an internal letter written by the bank and attached at paragraph 15 and marked D. This letter was a letter dated 7th of August 2006 from the main branch to the international division.
Is the document you are referring to the last at page 262 of exhibit 1/3?
Yes, that's correct.
Can you tell my lord very briefly the purport of this document?
This document claims to have transferred on the 7th of August 2006 a sum of 20 lakhs and 60,000 rupees to the international division for adjustment in the bank account of Setia Group of Companies. The letter suggests that since the bank account of Setia Group of Companies has been transferred from London to India, there is no restriction on adjustment of the debt of the bank. Sorry. It's completely concocted. Concocted. That's what I have to say.
Do you are you aware of any entity known as the Setia Group of Companies?
I have not heard of such an entity or bank account. The bank did not mention it for the first 19 years.
Are you aware of whether any bank account of either SL Setia Liners Limited or Drum Place Limited were transferred to India, as seems to be suggested by the bank?
The bank even tried to provide some evidence that the account was transferred, but the evidence only proves that the accounts of SL Setia Liners Limited and Drum Place Limited were both written off in London, and they were not transferred to the international division.
Last one. Now, after this,
Yes.
After this application for amendment of the written statement was made, was the written statement in the 1987 suit amended by the bank?
I'm sorry, could you repeat?
Was the written statement amended by the bank?
Yes, it was amended on the 16th of November, 2006.
What was the stand taken by the bank in the amended written statement of 2006? What was the defense taken by the bank in the 2006 written statement?
In 2006,
the amended written statement, yes.
This is that the bank has adjusted the fixed deposit in 2006 to set off the debt of Setia Group of Companies Limited. Which had been transferred to India.
Now, after the filing of the pleadings in the 1987 suit, did any of the parties adduce oral evidence?
Yes, they did. For RK Agencies Limited, Mr. Subhash Priyadarshi adduced evidence. And for the bank, Mr. Madhukar Shyam Gupta, the chief manager of the main branch, adduced.
Chief manager adduced evidence.
And when was the suit finally decreed? When was the 1987 suit finally decreed?
The decree
by
was
the trial court.
The decree was given against the bank on 3rd of February 2012. The judge observed in his judgment that the bank had been changing its defense throughout the proceedings.
Did you have any role to play in the during the course of the 1987 suit personally?
Well, I personally was supervising the litigation for the company after I became director in 2005.
Then do you know that according to the bank, what was the interest that had accrued on the fixed deposit up to the date of the decree?
The bank did not disclose its own provision of interest on the fixed deposit. The bank claimed that it had only paid interest up till 28th of May 1985. We now know 28th of May. 28th of May. We now know, because it has been disclosed after the suit was finally disposed, that the bank calculated the interest on the fixed deposit up to the 7th of August 2006 and transferred that money to its own profit and loss account by a manifold which it suppressed. That interest was, according to the bank's calculation, worth 89 lakhs. It was, of course, a wrong calculation.
Why do you say it was a wrong calculation?
The method adopted by the bank has, sorry,
exhibit number.
The bank has supplied the computation of the interest that it passed by the second manifold.
Passed by the second manifold.
The bank has also supplied
numbers
the historic interest rates for deposits held by the bank. The method of computing the compound interest by the bank is correct. It has compounded the interest at 6 monthly rates, 6 monthly rests. However, the interest rates applied by the bank are much lower than the bank would pay even on a fixed deposit.
I'm sorry, have you finished?
Yes.
না হ্যাঁ এই সুটেই আমাদের সুটে এই তো জাজেস 58 পেজ 58 না কিন্তু আমি বলছি original মানে the photocopies of mine are totally
Show the original.
I don't know if the originals were given or it was a common document. So I'll just show it to you. Mr. Setia, please have a look at exhibits A22 and A23. The copies whereof are at page 58 and 59 of the
volume 1.
Like 58 and 59-60 of the judge's brief of documents. দেখুন page 58 টা ওটা volume 1 টা দেখুন
volume 1 में हूँ 58 देखो उसमें है
তোমার notes for arguments में लगाना है
you are going to A24 like same A24
oh
Mr. Ghosh
yes
I know they are very bad copies.
Common documents. Yeah, but I think I'm just showing it to him. The important part right on the top right hand corner is illegible, the amounts.
Where is the original?
And please tell my lord, the bank has disclosed.
Yes.
Are these the two manifolds you are speaking of? Have a look at them.
Yes, they are. I have had a look at them. They are the two manifolds that I am speaking of. The first manifold is for 20 lakhs and 60,000 rupees. Second manifold is for 89 lakhs 87,442 rupees.
You have stated that one of these manifolds had not been disclosed in the 1987 suit at all. Which manifold were you referring?
The manifold of 89 lakhs. This is, there is evidence for this.
The manifold of
89 lakhs.
89 lakhs. You are referring to page 59, exhibit A23. Am I correct?
That's correct.
Now, besides, now, in the 1987 suit, can you tell my lord who were the solicitors or advocate on record of RK Agencies Limited and of the Central Bank of India?
The advocate of RK Agencies Limited, who filed the suit, was RK Khanna of Khanna and Company. But at the time we are talking about, the advocate of RK Agencies was Mr. U.S. Menon. And the advocate of the bank at this time was Charu Chandra Basu.
Around the time when the bank informed the court that it had appropriated the money, was there any correspondence between the advocates?
Yes. Mr. Menon wrote to Charu Chandra Basu to protest at the unilateral appropriation of the fixed deposit by the bank whilst the matter was being heard by the court. And also to question the lack of interest in the said appropriation. And Charu Chandra Basu replied to that letter of Mr. Menon on 21st of August.
The identification.
August.
I'm showing you
21st August 2006.
a document, a copy whereof is disclosed at page 15 to 23 of the third additional judge's brief of documents as DD 94. Can you tell my lord what is this document?
This is the reply of Charu Chandra Basu dated 21st of August 2006 to U.S. Menon.
Is this the original document? An original document?
Yes, it is an original document.
Where did you obtain this document?
From the advocate.
Which advocate?
Mr. Menon.
Mr. Menon. Now, are you acquainted at all with the signature at page 6 of this document?
I have seen it on many other documents, but I do not know whose signature it is.
Was this letter written in the during the course of the litigation between the parties?
Yes, it was.
May I tender this?
Signature.
I think
that's correct.
These have been disclosed, that he could have objected to the disclosure.
Earlier
There were 2 letters that were not proved. I'm just, otherwise everything's by consent.
Whether this letter.
Let it go down, his objection. This letter's been disclosed by us. It's a series.
Earlier it was not exhibited.
No, because their witness said, it was their witness said, I don't know who was the advocate on record.
Exhibit?
Exhibit
11 with objection. With objection as the as the letter and as the said document is correspondence between 2 advocates.
These are 2 different letters. This letter has already been proved. This one?
No. Expert identity.
I am showing you, well, just one more. I am showing you another document which is disclosed as DD 96 at page 25 and 26 of the third additional judge's brief of documents. Can you tell my lord what this document is? The last thing. 25.
This is a document dated 19th of March 2008 from Charu Chandra Basu to U.S. Menon. It attaches a copy of the document that we were just discussing, and it reiterates that Central Bank of India has never alleged that RK Agencies Limited gave a guarantee in respect of the liability of Messrs. Setia Group of Companies and Messrs. Setia Liners Limited.
How did you obtain this document?
From Mr. Menon.
Is this an original document?
Yes.
Are you acquainted with the signature at on page 2?
It's the same signature as in the previous document.
Or may I tender this? Same.
Subject to objection on the same.
As the same objection. Yes, next.
This is done. Wrong, 19th March, the wrong letter. I'll show it. This is which one? I'm sorry. And I'll do this tomorrow. It's our letters. This is in reply to this. And tomorrow your lordship has kept it, so I'll continue.
Sense suffering for the plaintiff, sense suffering for the defendant. Defendant is the witness, na?
Defendant
witness is present. And
right, so that you can start tomorrow. Day after.
Started during his examination. Documents were marked as exhibit 11 and 12 with objection. Due to paucity of time, economic chief could not be completed. According, chief is defer. This
same thing
that is already fixed tomorrow at 11:30. The matter of tomorrow at 12.
Adjournment till Thursday.
Huh?
Adjournment till Thursday, Your Lordship. Mr. Kundalia was engaged in the
Item number?
4.
You are appearing for?
Defendant number 1, Your Lordship. We were supposed to begin our reply today, but today itself a matter was urgently listed and fixed at 2 p.m. before the division bench. That's why Mr. Kundalia, but he...
Record an order.
My lord, in this matter, I am for the petitioner, my lord.
Yes. I am on behalf of the defendant number 2. Mr. Kundalia conveys his sincere apologies, Your Lordship.
My lord, the interim order is due to expire on 27 June. Your lordship will kindly suitably extend it also.
Okay. Item number? You are for the plaintiff?
Oh, yes.
So appearing for the plaintiff. You are appearing for defendant number 1?
Yes, Your Lord.
So appearing for the defendant number 1. So appearing for the defendant number 2. The matter is specially fixed today for hearing, for argument on behalf of the defendant number 2, defendant number 1. Especially fixed today at 2 p.m. for hearing, for argument on behalf of the defendant number 1. But today, when the matter is called, the learned counsel appearing for the defendant number 1 has pressed for time on the ground that the arguing advocate is busy in the other court. In view of the above, the case is adjourned, subject to payment of cost of rupees 25,000 to the State Legal Service Authority within a week from date. Let the matter give the date.
Your Lordship.
Let the matter appear on
Your Lordship, Mr.
4th of August at 3:45
Your Lordship,
Counsel
the other matter was mentioned without a notice to us, Your Lordship.
Counsel for the plaintiff submitted that the interim order going to is only up till 27th of June 2025 and paid for extension.
Your Lordship, you may kindly reconsider, Your Lordship.
Interim order is extended. Interim order is extended till 8th of July 2025 or until further order.
My lord has adjourned the case till 4th August.
Yes.
So 8 July will be 8. Your lordship has extended the interim order.
What can be? Because on the
no, I was saying
you all persons. Yes.
Your lordship has interim order till
8th of August. 8th of August.
Your Lordship, Mr.
Dependent number 2
instructed me that he conveys his sincere apologies.
I have accepted your apology with the cost of rupees 20,000.
Your Lordship, may please reconsider. Your Lordship, may please
Okay.
Call mention, my lord.
Lordship, I appear for the respondents in item number 20. Respondent plain language.
Yes. Who has filed this application?
Defendant has filed this application.
What?
For extension of time to file
Who
written
is for the defendant?
They have stated in their application, my lord, that they entered appearance by filing Wakalatnama on 5th May. Writ of summons was served on 7th May. 30 days time was expired on 6th May. And now they have filed this application, my lord. 30 days has already been expired, my lord.
When you received the writ of summons?
On 7th April. According to their statement made in the application, 7th April.
Pass over, let them come. Pass over. Next.
Lordship, item number 21, I appear for the defendant.
Yes.
Lordship, the GA is the plaintiff's application under order 13A for summary judgment. Lordship, the plaintiff had begun submission summarily on the last occasion. And I find that my learned friend was there in the first half, but is not there today. Affidavits are complete, my lord. I am opposing the application.
Pass over.
I am obliged.
Next.
Item number 22.
Your Lordship, I am appearing on behalf of the defendant number 2.
Which matter?
Your Lordship, this is Kunal Finance. Kunal Finance versus Vinayak Maker.
You are appearing for the defendant
Defendant number 2, Your Lordship. Defendant number 3 is already expired. And defendant number 1 is the partnership firm, which is no more there. Your Lordship,
Your Lordship, the petitioner, the plaintiffs have filed an application for substitution of the legal heir in place of defendant number 3, Your Lordship. Your Lordship, that application was being heard. Your Lordship, plaintiff has already finished the arguments and I was being led by Mr. Moinak Bose, Your Lordship. So, Your Lordship, he's on his way. We have to conclude our arguments today, Your Lordship.
Passover.
Obliged, Your Lordship.
Next.
I am appearing on behalf of the petitioner. Can you please grant us a short Passover?
Passover.
Very much grateful of.
Next.
My Lord, in 24, I am for the petitioner. And on the earlier occasion, my Lord has granted time for affidavit in opposition to the respondent. We haven't yet received any affidavit from their side. It's a suit for goods sold and delivered, like the money.
You are appearing for?
For the petitioner.
Plaintiff.
Yes, my Lord.
Have you saw the amended copy of the plaint to all the parties?
My Lord, that I have to take instructions.
Take instruction. You are appearing for the plaintiff. There's a direction on 8th May. Concerning the submission, respective parties, the co-founder with regard to the handover the possession of the petition portion of the second floor of the premises, it would not be proper for this court direct the surrender. If defendant number 10 is intending to hand over the said floor, they can surrender. The plaintiff is directed to serve the amended copy of the plaint to all the parties.
Served.
Served.
So far I am concerned, I've been served, yes.
So what is the stage now?
I mean, the inspection discovery has not yet been done.
Written statement filed all.
Huh?
Written statement filed all parties.
I have filed. I have filed.
I'm appearing on behalf of the defendants number 3 at court, Lord, against whom the interim order of injunction has been confirmed by Your Lordship's last order. Lord, we were not represented, and there has also been a change of the advocates. But by Your Lordship's last order, Your Lordship was pleased to direct the plaintiff to serve a copy of the amended plaint to us. Lord, their advocate has served us a copy of the amended plaint, but without disclosing the documents. So I request, my Lord,
Who is for the plaintiff?
For the plaintiff, my lord.
Yes.
Mr. Devnath Ghosh is there, my lord. Mr. Shuchi Smith also is there.
But I only request, this is what was sent. My Lord, if this can, my Lord, if we can be favored with the documents which they have annexed. It's a commercial dispute. So all the
No,
documents-
earlier the plaint was not served.
No, there is no
Yes,
written
amended.
statement by them. There is no written
That is the
statement.
reason why. The amended plaint where the description of the defendant number 10 and his address has been amended pursuant to Your Lordship's order.
Correct.
Your Lordship directed them to serve us.
Correct.
My Lord, the documents, my Lord, has not come up along with this.
Who is for the plaintiff?
I only request, my Lord, no formal service through summons. If the documents can be handed up, then we will be in a...
Why you are not served?
But we have served, my lord.
It is-
But where is without
Documents
the
will-
document?
Hey, I'm carrying that's why I'm carrying the entire thing.
Without document.
I will let you know.
Huh?
I will inform my lord.
What?
That why it was not
Kindly
served.
record an order because we, my Lord,
Tell
our
me how
time will
soon
start.
you have received
Yes, I have received.
document
I have filed written statement also.
Of the
Documents are the same.
of the amendment.
No, amendment is only the name of the
Name of
defense.
the
I don't need to file amendment.
So earlier the
Well,
plaint
earlier
which
we
was
have
served
not
to
received.
you
No, writ of summons has not been received.
served to you.
No.
You are
But
appearing
I'm
for
appearing for the plaintiff, my lord.
you are appearing for whom?
But I'm appearing for the defendants number 3 and 3.
3 and
No, only 3.
3.
Yes.
So not writ of summons was served upon you?
Originally, writ of summons was not served on us because we, my Lord, we are not, my Lord, staying at this particular address which is mentioned. This is the suit premises which we are.
But so far as the plaint is concerned, as far as the instruction goes, I'm told that we offered inspection also,
No,
but
he is-
they have.
he is telling
Yes,
that-
but this is something anew because I do not know why.
No, he is telling that the plaint.
They don't decide if that be so.
That copy of the plaint was served.
Yes.
But without the document.
Yes, that is the only.
That
I'm
is the only. If you
requesting
give the
Then
document.
I'll have all the documents served here and now, if possible. Otherwise, in course of today, I'll have it sent over. Whoever is his advocate on record, if he could
So
indicate,
you are
I should
appearing for
have
the
it.
3. Who is for the 1?
Your Lordship, I'm for
One.
appearing for
Huh?
Your Lordship, I'm appearing for defendant number 1.
1. You filed written statement?
Yes, Your Lordship.
1 filed written statement. Two,
I am appealing. I have filed written statement.
written statement.
Yes.
Three,
So
you are
amendment
there.
is concerned, I am not filing additional, not required.
Three, you are there. Mr. Banerjee, you are three.
Yes, he is.
And four, Kunal Agrawal. Four, anybody is appearing. Earlier also none appears on behalf of the four. Notice out. Four, none appears. Five, none appears.
সবই ছিল কোথায় গেল আমি
Six,
জানি না।
none appears. Seven, none appears. Eight appears. And nine, none appears.
আপনি এই আমার অ্যাডভোকেট অন
এইটাতে একটু পাঠিয়ে দিও
So what about the other affidavits? The service has been completed.
Well, that's what I'm told, that the service is complete.
Report.
Service যে হয়েছে complete সেটা আছে।
And a certificate would have
Well,
served the purpose.
The advocate on record who deals with the matter, as I understand, he's not present today in court, but he has all the papers. I had seen it myself that it was served. In fact, at the stage of the interlocutory application, when it was being heard, the Lordship would recall Mr. Tilok Bose was leading me in the matter. At that stage, only the suit when was appearing. We had placed it before your Lordship.
No,
That
if it is,
everything.
then I will clear.
Yes, yes, I absolutely follow. Unfortunately, I'm handicapped. আছে সব ডকুমেন্টস আছে বার করুন কি সার্ভিস হয়ে গেছে দেখেন my lord will kindly bear with me for a
report आया है क्या?
the affidavit of service may I be permitted to place before your lordship the affidavit of service my lord
আমাকে তো ওরই যে বললো ধরে গেছে
এটা copy আছে?
ঠিক আছে না না নয় চলছে তুমি আছো তো তুমি থাকো না আমি আসছি না, না।
2 p.m. Defend number 3 defend number 3 documents fine
1, 2, 7, 8, and 9 have filed their written statement.
yes your lordship
I'm 2.
they have filed. We had offered inspection to defendant number 9. They have refused the inspection. We are ready and the documents may be placed before your lordship. 10 had taken, 9 has not taken. That's what the instruction is. My lord, I'm told defendant number 9 has taken inspection. Defendant number 10 has not taken.
3 achieve I'm 2. My time be extended.
Nah,
Defendant number 1 has filed, entered appearance through Radhika. Defendant number 2 entered appearance. Defendant number 3 and 4 entered appearance. Defendant number 7 entered appearance. Number 8 entered appearance. 9 entered appearance.
My lord, may I be permitted to file the affidavit of documents?
5, 6, 10, and 11 not entered appearance, either in person or through the advocate.
My lord, will take note of this. Now my advocate on record is here. The certificate shows that who has entered appearance and who hasn't. And yes, that is what enter appearance when a written statement file correct to enter appearance.
1, 2, 7, 8 filed.
Rest will be expert.
Yes. But I'm led by Mr. Ghosh.
No, what about the 5 and 6? Whether writ of summons is served?
Writ of summons?
5 and 6?
5 and 6 writ of summons.
Yes, served on everyone. 5, 6, 10, and 11?
My lord, the writ of summons I'm told is served on everyone. The details.
Loan accounts are important.
Substituted service for defendant number 10 and 11.
Somebody is appearing. T workers on the last occasion, somebody has appeared.
But the name got change of 10.
Yes, that has happened.
Fox
That
Mandal.
has been
appearing.
Mr. Anil Dhar was appearing. Fox and Mandal was appearing.
was appearing.
ABC Tea Workers Welfare.
My lord, for defend number 10 and 11, there was a substituted service order which was passed. We had complied with. This was the order
5
of
and
2011.
4 and 5?
Yes. 4 and 5 also.
Sorry, 5 and 6.
Everybody is served. I have the service report also. All the details are there, my lord, in the service reports. They are all tagged along.
You taking item? Yes, confirm. Yes, you keep it.
Yes, sir.
So who has filed the written statement?
That document is given me that I just gave the document.
My lord, this will show
Written
that
statement on behalf of the defendant 1, 2,
1,
7,
2,
8, 9.
7, 8, and 9 have filed their written statement.
And through so.
And we have also offered inspection to them, my lord. Only defendant number 9 has taken inspection, the others have not. May I be permitted to file my affidavit of documents, my lord?
No, if other parties are not, who has not appeared and not filed the written statement, then the undefended
Yes,
is
undefended.
But I have not been able to file the written statement. because the plaint
No,
allows
he
me
is
to
saying that
documents
he
relied
didn't
upon by
get
plaintiff
the
has not been
documents.
served upon me. I'm only asking for the documents.
Defendant number
to be
3
served
do
because
it.
I have been served with only the copy of the plaint.
Time
By
has
a
gone.
letter of 10th of June 2025, pursuant to your lordship's order of 8th of May.
There's fine emails.
Amended to the serve করে
Served
ছিল
at
ওদের
Delhi.
ওদের serve করে যোগ না
You may
amended
know where I am located. I'm located at South Delhi. Having my registered office at South Delhi.
কত দিবেন কত
Even number
Defendant number 3.
তিনটা দাও
It
তিনটা
takes
সার্ভিস
and I can hand up, what has
Service
been served on. I'm only asking for the documents so that I may be in a position
for
to
each
file
of
my
the defendant
Kindly do not do that.
authentic-
Three has been served. There's a service report. Time has gone.
so appearing for the plaintiff.
Bad luck.
There is a
Defend
order
number-
passed by your
Are
lordship.
bad luck.
Who is appearing for the defendant number 1?
One, hey, one bolo.
So appearing for the defendant number 1.
Two. 2. I am 2.
So appearing for the 2. Who is for the 3? And so appearing for the 3. 4, 5, 6, 7.
4, 5, 6, 7.
Nobody.
7 is the 7th though. CAC.
So
CAC 7.
8.
CAC is CAC.
हाँ, दिए थे ना, हाँ, just a pure
You are appearing for whom?
CAC is 7.
7. Who is appearing for the 8? Industrial Investment Bank? Nobody. 9? Nobody. 10?
চলে গেছে
11? Nobody.
আমি যখন এসেছি তখন he was making
Counsel for the
submissions
defendant number 3 submitted.
আমাদের এইসব কিছু ছিল না
So the plaintiff has served the amended copy of the plaint, but in the said plaint, the plaintiff has not. क्या बोला? Defendant number 3 has.
service which বলো secondary
But in the said plaint, the document relied by the plaintiff is not been served upon the defendant number 3. Counsel for the plaintiff submit that in course of the day, the plaintiff will serve the documents to the learned counsel appearing for the defendant number 3.
But time to file the written statement is gone. Services.
Amendment is allowed.
Please, sir, please. Hey, no.
There's an order passed. by
Kindly take
government
8th of
directing
June.
them to serve
Kindly
the
look at the
entire
service
set.
report. Today, can it be given again? Only the change of
Also
the
please
amendment.
your lordship's order of 8th of May.
Only cost title change. You will again file the written
defendant
statement.
number 3
There's a judgment whether you can only file as per the amendment, only change of name.
So that's why I'm again and again asking
Yes.
with regard to the earlier you received the writ of summons.
Yes, BT 2021.
2021 along
But
with the
thereafter your lordship has allowed an amendment.
amendment only with regard to the name of the defendant number 10.
Your lordship has directed them to serve me a
Correct. Only amended copy of the plaint. But it is not that a new cause of action. I am fixing undependent.
Kindly allow me to.
Why?
Time
Huh.
Order of 8th of May.
Correct.
I'm bringing to your lordship's kind notice that has not been complied.
I have recorded and they are serving the
But
copy.
They will be, and after that, whatever is my fate, I will have to take steps before your lordship.
Whatever it may be. Full stop. So how many defendants have filed the written statements?
7, 8 and 9
2, 7, 8 and 9. 1, 2,
It
7,
is
8 and
fine
9.
from the report of service report of the Deputy Sheriff of Calcutta. Writ of summon have been served upon all the defendants. All the defendants. Full stop. After receipt of the writ of summon, only the defendant number 2,
1, 1, 2,
7,
9.
8 and 9.
1 and 2 are the main defendants.
8 and 9 have filed their written statement. And the other parties, other defendants have not filed their written statements. Full stop. It is fine that the writ of summon have been served upon the defendants in the year 2021. But till date, no written statement has been filed. Counsel for the plaintiff, counsel for the defendant number 3 submits that in terms of the order passed by this court dated 8th May 2025, the amended plaint has been served to the defendant number 3, but no document has been served,
and as such he may be allowed to file return statement. At the learned counsel for the respective parties, this court finds that the defendant number 3 has received the writ of summons on 8th of October 2021, but has not choose to file the written statement. The amendment which was allowed only with regard to the name of the defendant number 10. That's why this court has directed plaintiff name and address of the defendant number 10, and for that only this court has directed by an order dated 8th May 2025 to serve the copy of the amended plaint. But nothing was amended in the facts in the pleadings of the plaint. In view of the above, as the defendants number 3 and 4, 3, 4, 5, 5 not 5 na? 3, 4, 5, 6, 10 and 11.
8 file correction.
The suit may be placed in the list of undefended suit. Full stop. The plaintiff has filed the affidavit of document. Let the same be affidavit of admission and denial of document. Let the same be kept with the record. What about the other?
Millard, one prayer. Your Lordship has said we place undefendant. Millard, actually the suit will appear before your Lordship
Against them.
Against we will proceed as if it's undefendant. So, Millard, the no separate thing, Millard, it is.
No.
Now, Millard, so far I am concerned with the defendant number 2. If you will kindly extend the time for inspection and discovery because we have missed out, Mr.
His application.
But we will file the documents.
We had given inspection long time back. They refused.
Plaintiff has filed the affidavit documents of what?
Oh, whatever we have, Millard, no one has ever disclosed anything.
Learned counsel for the defendants prays for extension of time to complete the discovery and inspection with document. For interest of justice, time to complete the discovery interest of justice, the plaintiff is directed to disclose their document to the all defendants on or before.
Millard, we have already disclosed.
I have received.
We had offered inspection.
I have to do it.
They refused.
The defendants.
Millard, they have not disclosed anything.
It's not that we refused.
Of the full stop. The counsel for the plaintiff submit that the plaintiff has disclosed their document, but none of the defendants have come forward for inspection of the same. Accordingly, all the defendants are directed to complete the inspection of the document of the plaintiff by 3rd of July 2025.
And also for our disclosures.
By 3rd of
sorry.
July 2025. And all the defendants who are intending to disclose their document and rely on any document who have disclosed their document in the written statement shall disclose the original document to the plaintiff by.
Millard, not all the defendants. Lordship said whoever has filed written statement.
I mentioned that.
The defendant's number who has filed the documents. Defendant number
1, 2, 7, 8,
1,
and
2, defendant number 1, 2, 7, 8, and 9 are directed to disclose their document to the plaintiff by 2nd of July 2025, and the plaintiff is liberty to inspect this document by 7th of July 2025.
7th, Millard, give 1 week.
By 11th of July 2025. Full stop. The parties are directed to file their admission and affidavit of admission and denial of the document within 2 weeks thereafter. In the meantime, the parties are also directed to exchange their suggested issues.
Millard, we have not exchange. We will otherwise because there is already a direction that all of us will come with suggested. I have come with mine.
Yes.
I have come with mine. Naturally, Millard, they probably haven't.
So come on that day.
Yes.
The parties are directed to come with the suggested issues on the next date fix. List the matter on 16 July 2025 for framing of issues.
Oblige.
Stays. Item 23 will on other side not there. So make it not. Court. 23 other sides application, they are not there.
अभी क्या मैटर चल रहा है? 23 was for the
I'm for item 21. My other side is passed over.
Passover. I will call.
23 Lordship makes it not today.
You are appearing for whom?
For the defendant.
It's for the
was not
plaintiff.
there.
So I will dismiss if nobody will come. That's why I pass over.
Very
Let's call the matter.
Well, at item number 25, we were unseen.
Item
and led by Mr.
25.
Bhattacharya.
I am sorry to appear on.
I'm appearing for the. I'm appearing for the defendant.
Yes.
Yes, I'm sorry to appear online, my lord, because I did not want to contract. I did not want my colleagues and your lordship to contract COVID. I am suffering from COVID right now, my lord.
Mr. Bhattacharya is very kind to all of us.
Yes. My lord, on the last date, my lord, I had shown the plaint, my lord, and I had shown, my lord, the plaint can only be dismissed either there is a want of cause of action or if the suit is barred by law. For
Correct.
example, section 69 of the Partnership Act or section 10 of the SEBI Act. And I have taken your lordship through the form of pleadings in form A, appendix A, form number 47 and 48.
Yes.
So, my lord, I have shown from the plaint that my suit does not suffer either from lack of cause of action, nor is it barred by any law.
Yes.
My lord, it has been emphatically argued by Mr. Mitra, relying on paragraph 11 at page 72 of the plaint, that I have already quantified my losses.
Yes.
My lord, this is a development agreement under which 35% is to come to me. 65% is to go to them. And in terms of the agreement, they are to execute a power of attorney in favor of one of my nominee because I am a company. Nominee so that necessary works for sanction before KMC, fire department, etc. can be obtained. My lord, the director was a director called one Mr. Mahesh Agarwal, who passed away during COVID 2020. After that, his wife, Mrs. Meena Agarwal, who is a director, applied to them, kindly grant me a fresh power of attorney so that the balance work, because 90% of the work is complete. What they said, we do not rely on personal skills of Meena Agarwal. There is no covenant either in the agreement, either in the development agreement or the power of attorney which requires any personal skill. And it was most emphatically argued by Mr. Mitra in paragraph 11, if your lordship kindly takes page 72, that I have quantified my losses.
This is volume 1, page number.
Volume 1, page 72, my lord, internal page 15 of the plaint.
Yes.
On account of development work, the petitioner has incurred a sum of rupees 5 crore 70 lakhs as on 31st of March and the further sum of 50 lakhs towards security deposit.
Yes.
But even if I had quantified any losses or had I claimed for compensation, the suit still wouldn't have been barred.
Yes.
Your lordship kindly takes the Specific Relief Act, section 21. This has undergone an amendment in 2018. My lord, your lordship kindly takes section 21.
Yes.
In a suit for specific performance of a contract, the plaintiff may also claim compensation for its breach. My lord will kindly mark the invert within the brackets in addition to such performance.
Yes.
My lord, at the bottom of that page, your lordship will find prior to amendment, it stood as either in addition or in substitution.
Yes.
In substitution has been deleted.
Correct.
So it is a right which has been conferred by me under the 2018 Act that along with specific performance, I am entitled to compensation.
Yes.
Now, my lord will also kindly read it with clause 3 of section 21. If in any such suit, the score decides that specific performance ought to be granted, but that is not that is not sufficient to satisfy the justice of the case, and that sub compensation for breach of contract should also be made to the plaintiff, it shall, my lord, the word is shall, award him such compensation accordingly. So in addition to specific performance, your lordship is entitled to grant me compensation for any loss which has been occasioned to me.
Correct.
Now, my lord, an interlocutory application was moved by us, and all the arguments which was raised by Mr. Mitro were raised before, my lord, the learned interlocutory judge. Before that, my lord, may I just show the notice of motion, which is at page 237 of volume 2.
Notice of motion. Page 237. No, that's 43.
Yes.
My lord, prayer A for an order of temporary injunction restraining the respondent, its men, agents, and assigns from alienating, encumbering, dealing with, dispossessing the suit properties, and or creating any third-party rights in respect of the subject premises, or interfering with the right of the petitioner, or to enter into any agreement with any third party on account of the balance work at the subject premises, being premises number 1 Upper Wood Street, Kolkata 1. This has been granted to me.
Yes.
My lord, next prayer. An order of temporary injunction restraining the respondent, its men, agents, and assigns from executing any fresh agreement with any third party which are the subject matter of the development agreement. That also was granted by the learned interlocutory judge.
Yes.
Now, my lord, prayer C, which is at page 238. An order of mandatory injunction directing the respondent to execute a power of attorney in favor of Meena Agarwal, the director of the petitioner, to execute the balance work. My lord, this was granted by the learned interlocutory judge. They preferred an appeal.
Correct.
So far as prayers A and B are concerned, that was not disturbed by the appellate court.
Correct.
Prayer C was saying that it tantamounted to granting final relief. Now, my lord, all these arguments which Mr. Mitro has made, my lord, your lordship kindly takes page 243, which is the order of the learned interlocutory judge, Justice Saraf, who was presiding over the interlocutory bench.
Yes.
Page 243, the judgment starts.
Yes.
Now, my lord, kindly takes page 244, paragraph 2. It has been referred, my lord, the amount of expense which I have undertaken, which was supported by my balance sheet.
Yes.
The petitioner incurred a sum of rupees 5 crore 70 lakhs odd on account of development work of the subject premises, along with a sum of rupees 50 lakhs towards security deposits against the such and such. As per the accounts, a cost of around 1 crore 79 lakhs was incurred, but this is beyond the period of 36 months. But if I may ask myself this question, their points in demurrer are, it was to be completed in 36 months, though the clause says it can be mutually extended. Can that be decided in a demurrer? Can that be decided without taking evidence? Whether the period for construction was 36 months or was it extended by mutual consent? Because the work went on beyond period of 3 years till Mr. Mahesh Agarwal was alive. Can it be decided in a question of demurrer?
Yes.
No. My lord, the work was being performed by the petitioner till the demise of its nominee and or director, Mr. Mahesh Agarwal, on 3rd April 2020, which is beyond 2018, beyond the period of 36 months.
Real estate, real estate. Yes.
I'm sorry, my lord.
Yes, continue.
My lord, by director, Mr. Mahesh Kumar Agarwal, on 3rd April 2020, which is beyond the period of 3 years.
Yes.
And there is no termination whatsoever. My lord, they tried to sneak in a document. I will show it from the order of Justice Saraf. They tried to sneak in a document which was a fabricated document, trying to show that there has been a termination, and they withdrew it. They said, we don't want to rely on this document.
Yes.
Sanction plan was granted on 18 November 2016. So the 3 years period would have been over on 17th of November 2019.
Yes.
And the same was due to expire on 17 November 2021. Taking this into consideration, the petitioner was allowed ad interim order restraining such and such. Now, I will not go into what Mr. Bachawat argued, which is at paragraph 3.
Yes.
My lord, just paragraph 4, I will just refer to. The petitioner avers that the time is never of the essence of the contract in case of immovable property unless expressly provided by the parties to a contract. The petitioner places reliance on Messrs. Hit Construction versus State of Maharashtra reported in 1979 2 SCC page 70 to contend that the question whether or not time was of the essence of the contract would essentially be a question of, my lord will kindly mark this, intention of the parties. Can intention be a demurrable question? To be gathered from the terms of the contract. That has to be decided after evidence. Thereafter, the petitioner states that the intention of the parties was not to make time the essence of the contract. Thus, the principle as laid down in the case of Hind Construction squarely applies. I will then, my lord, paragraph 5, my lord, because after amendment of the Specific Relief Act, so far as a contract in relation to a specific immovable property is concerned, my lord, specific performance is no longer discretionary. I will rely on this decision, my lord, which is relied on by Mr. Bachawat in paragraph 5. Then lastly, that is reported, I will rely on that.
Yes.
Now, my lord, kindly comes to paragraph 7. These are the same arguments which was made by Mr. Mitro before the interlocutory court.
Yes.
Mr. Mitro, senior advocate appearing for the defendant, argues that the registered development agreement dated 17th August 2015 does not create any right in the property. I would show that this is contradicted by a full bench judgment of our High Court as well as the Supreme Court of Justice Dhananjay Chandrachud. Once there is an interest in the property, that creates an interest in the property. The moment I am allocated a share in the property, I have an interest in the property. If it is simpliciter to construct, then it is not specifically enforceable. And the development agreement is not an agreement for sale because no stamp duty has been paid. Well, this is nobody's case. As per entry 5 of Schedule 1A of the stamp duty, further it is argued by him that as per section 14B of the Specific Relief Act, the contract which involves the performance of a continuous duty is not specifically enforceable. The defendant relies on Sushil Kumar Agarwal versus Meenakshi Sadhu, reported in 2019 2 SCC, to state that the specific conditions as mentioned in section 14(3)(c)(1) of the Specific Relief Act are not fulfilled by the plaintiff, which would allow the relief sought by the plaintiff. Subsequently, it was submitted by the counsel for the defendant respondent that the development agreement was dependent, my lord will kindly see this, was dependent on the personal qualification of late Mahesh Agarwal. This has been negated by the learned single judge. The defendant's power of attorney holder. The defendant does not have faith in personal qualification of his widow, Meena Agarwal. Where does the contract provide for this? That he has to be an architect or something, or an interior designer or something, whom the plaintiff wants to be appointed as a new power of attorney holder. Section 40.
But one thing it is striking to me, whether you are the developer.
Yes, my lord.
Correct. You want to complete the work, but the original developer, the partner died. Now you want
not the partner, he is the director.
Director died. So whether this will be before in the suit or before the state, what we say,
Consumer forum.
RERA.
No, my lord. Not RERA. Not RERA. Not RERA. RERA talks about, my lord, I can demonstrate to your lordship, RERA protects the consumers.
Allottees.
The allottees.
We are not the allottees.
Let us.
My lord, I will satisfy that, your lordship. It is only to protect the allottees.
Okay.
Judgment passed by your lordship.
Whom the plaintiff wants to be appointed as a new power of attorney holder of the defendant. Hence, section 14C of the after amendment, which states that the contract of which performance is dependent on the personal qualifications of the party is not enforceable. Well, it is not somebody like I engage Vincent van Gogh and he dies and then I ask Picasso to draw it. That is something which 14C talks about. That is what 14C talks about. That I engage Vincent van Gogh, he can't finish it, and I don't have belief in Picasso, who might be a member of the state art team. That is where 14(1)(c) comes into operation. And that has been discussed, my lord. The counsel for the defendant submits that the contract for development comes to an end on expiry of 36 months from the date of receipt of the sanction plan. He primarily relies on 14D to state that the nature of development contract makes it terminable. There has been no termination till date. Thereafter, it is submitted by the defendant. The time is of the essence of the development contract in the instant case. He places reliance on such and such, and more particularly the quotation of the Supreme Court in the case of Keshav Lal Lalubhai Patel versus Lalbhai Trikomal Mills, reported in 58 Supreme Court, to make this submission. Furthermore, the defendant submitted that by virtue of the mutual consent clause, so he admits that there is a mutual consent clause for extension of the development agreement comes to an end as both the parties did not mutually extend the time. But can it be decided in a demurrer application? Because evidence shows that work went on till Mahesh Agarwal was alive, till 2020. He relies on Anandram, Mangutram versus Bholaram such and such to buttress this argument. Subsequently, the defendant avers that time is as much of essence in a contract for transfer of immovable property as it is in the case of a movable property. Then he relies on few decisions. Now, my lord, the analysis and conclusions, which is at paragraph 11 at page 249.
Yes.
And these observations have not been set aside. I have heard the counsels appearing for both the parties and peruse the materials on record. The primary issue that needs to be decided in this application is whether time is of the essence of the development agreement entered into by both the parties. This issue requires interpretation of various clauses and conditions mentioned in the agreement. The relevant clauses of the development agreement are as follows. My lord, I have taken your lordship through these clauses. I will not trouble your lordship with these clauses. My lord, just only 6.3, which has been culled out in this judgment, the developer's allocation will comprise 35% of the sanctioned area in the new building and or building, which includes covered. The owner identified respective allocation 6.4 and 6.6.
Yes.
The new amended provision of the specific relief act are also required to be highlighted for adjudication of the issues involved in the instant case. The relevant provisions of the specific relief act are extracted below. Here, my lord, that Santosh Dhamma's judgment I will rely upon. Section 10, my lord, now has been amended,
Correct.
which has been culled out. Now, section 14, C, which is what they have relied upon.
Yes.
A personal qualification of the parties.
Correct.
And this has been considered by the learned judge. Section 16. Like my lord, this actually applies to cases where persons have talent. I engage R.D. Burman. R.D. Burman dies. I cannot rely on his son Because I had, or SD Burman, RD Burman, we don't know whether he has SR. We had engaged SD Burman. SD Burman dies. Whether it can be enforced by RD Burman.
You can go to the Kalyanji Anandji.
No. My lord, here is the difference. Here is the difference because the parties relied on the personal qualification of SD Burman. They might not have faith in the personal qualification of RD Burman.
Okay.
This would apply to a situation like that. Now, section 16 also has been referred to. Now, my lord, paragraph 13 at page 252.
Yes.
My lord, in the case of Hind construction, it was held by the Honorable Supreme Court that the question whether time of the essence of the contract is to be determined from the intention of the parties. That can only be done only after a trial, not at a demurrer stage to a contract, and where a parties to a contract contemplate postponement of a completion, time is not of the essence. The court interpreted various clauses that the specified time limit for the contract to be performed as per the building contract. Here, my lord will kindly recall that the clause says 36 months to be mutually extended by the parties. So whether there was a mutual extension or not, well, that has to be decided at the time of trial.
Yes.
Now, my lord, relevant paragraphs of the judgments are quoted. I am not troubling your lordship with the Hind construction entire judgment which has been culled out. Now, my lord, paragraph 14 at page 253. In the case of Kalidas Ghosh, it was held by this honorable court that subsequent contract of the parties is also of relevance to determine the intention of the parties regarding the stipulated time limit of the agreement. Relevant paragraphs. Because here it continued beyond 2019 till the date of death of Mahesh Agarwal.
Yes.
Now, my lord, paragraph 19 of that judgment has been set out at bottom of page 254.
Yes.
My lord, the subsequent contact of the parties would also throw some light on the original intention of the parties regarding the stipulated time limit of the agreement. The respondent is a company and not a private individual, yet it did not think it proper necessary to give any notice to the appellant on the expiry, initiating that the contract was avoided or that it stood cancelled. There is no letter of termination from them. Rather, they accepted the work. Now, my lord, this is very important. Paragraph 15, where my lord discusses Santosh Amma, which I will rely upon.
Yes.
In case of B. Santosh Amma, it was held by the Honorable Supreme Court that if there are no express consequences for not complying with a term mentioned in the agreement between the parties for sale of immovable property, then it cannot be said that time is of the essence. Relevant paragraphs of the judgments are delineated below. My lord, paragraph 62 of that judgment has been set out. The effective concurrent finding of the High Court and the Trial Court that the vendee has been ready and willing to perform and had in fact performed her obligations under the agreement is also unexceptionable for the following reasons. As observed above, the vendee paid rupees 40,000 out of the total consideration of 75,000. My lord, here I have constructed 90% of the building. I have spent more than 5 crores. As of the date of execution of the agreement itself, it is not disputed that the vendee further paid a sum of rupees 5,000 to the vendor's husband. It is vendor's own case that in terms of the agreement dated 21/3, the full consideration was to be paid within 45 days. The vendee claimed that she tendered 30,000 was not disputed by the vendor. In any case, the vendee obtained demand draft for 30,000 in favor of the vendor towards balance consideration within 40 days from the execution. It is well settled, my lord, the Roman 5, that time is not of the essence of agreements for sale of immovable property unless the agreement specifically expressly incorporates the consequences of cancellation of the agreement upon failure to comply with the term of the stipulated date. It does not here. Judgments relied on by the defendant respondents on the issue of time is of the essence need to be observed next. In the case of Sardamani, it was held by the Supreme Court that in an agreement for sale of immovable property, the purchaser can no longer take shelter under the principle that time is not of essence in performance of contracts relating to immovable property when he does not take any steps to complete the sale within the relevant period. Here I have taken, my lord, then the judgment has been set out.
20.
Then, my lord, page 258. Subsequently, in the case of Ferodas estates, these are all relied by Mr. Mitro, wherein the court observed that property prices have risen drastically. It may not be correctly to state that time is not of essence. But here they are going to get 65%. Whatever is the price today, the market price, they are going to get it.
Paragraph 20 onwards.
Now, my lord, Ambalal Saravai and everything considered. Now, my lord, paragraph 20, I am grateful to Ms. Ghosh at page 263.
Yes.
After going through the relevant clauses mentioned in the development agreement, it can be observed that the time limit of 36 months prescribed in clause 5.3 is extendable if the parties mutually agree to do the same. As per clause 3.2, the agreement for development of the suit premises will remain in force till the time the entire construction is completed. One may refer to clause 6.4, which contemplate the time period for identification of allocation may also be extended on a mutual agreement between the parties. All the above clauses points towards a situation where both the parties did not envisage the development agreement to be time-bound. The argument made by the counsel for the defendant, which is, my lord, the petitioner herein, that mutual agreement was not entered into for extension of time, hence the development agreement does not subsist, is not tenable. In the facts, in fact, presence and wording of such conditions clauses in the development agreement goes on to highlight that time is not of the essence. And my lord, these findings have not been tinkered with. No appellate court has set aside these findings. The principles derived in this case of Hind construction are accordingly applicable to the present case. The development agreement does not envisage any consequences for not sticking to the time limit of 36 months as mentioned in clause 8.1 and 5.3. That being the case, it is not correct to assume that the intention of the parties was to ensure that the work is completed within the deadline. In clause 5.3, for mutual extension of time, and clause 8.1 for development of the suit premises, nowhere is it mentioned that failing to comply with the deadline will lead to certain consequences or revocation of the development agreement. In fact, there is no clause in the entire agreement to indicate the consequences for not complying within the prescribed time period. Thus, the intention of the parties has to be looked into in light of the above clauses. The legal principles derived in Kalidas Ghosh with regard to intention and conduct of the parties is accordingly applicable to the facts of this case. Similarly, legal findings on the issue of time is of essence in the case of B. Santoshamma are relevant and applicable to the case in hand. It has to be noted that the respondent sought to reply, my lord, kindly cease their conduct, trying to fabricate documents, rely upon a purported letter of termination dated 19 November 2020, which was not pressed subsequently for the purpose of deciding this application. And they have not relied on this either. Also, when the petitioner sought reply from the respondent via letters and emails dated 26 July and 7th August, there was no communication from the side of the respondent with regard to termination of the site development. Such conduct of the respondent highlights that the development agreement was never terminated. Kindly looks at this. They're trying to fabricate documents and sneak in documents. Judgment cited and relied on by Mr. Mitra, counsel for the defendant, and are not applicable to the instant case as both relate to sale of immovable property. It was movable property, whereas the agreement for development has a different character. The principles obtained from these judgments are relevant for the cases where one party delays its obligations as per the sale agreement and the price property goes up, which makes specific performance of the contract inequitable for the seller. In fact, in the case at hand, the primary intention and the objective of the party was to make profits in the future based on the rising real estate prices, and such intention will get frustrated if specific performance of the agreement is not granted. Hence, both judgments are inapplicable to the current factual scenario. Counsel for the respondent has submitted that the petitioner at the most would be entitled to damages, and the petitioner is willing to secure such sum as may be as claimed to have been spent on account of construction. But that paragraph which I have just indicated to your lordship is completely misplaced. According to clause 6.3 of the development agreement, the developer's allocation will comprise of 35% of the sanctionable area in the said new building, which the developer would have a right to sell in terms of clause 6.5. Such right as embedded in the development agreement creates a right of the developer in the land and the proposed construction itself, which cannot be compensated in form of damages. In case of Sushil Kumar Agarwal, clause 2.5 of the development agreement mentions payment of construction cost via 58% of the constructed area as security, and upon failure, the owner, the developer, was entitled to realize its money by selling this 58% of the area kept as security. There is an apparent distinction between the nature of development agreement entered into by the parties in this case and the case that presently we are dealing with. In our case, clause 6.3 and 6.4 are unambiguous with respect to share allocation in the suit property between both the parties. Moreover, the above judgment does not examine the effect of amended provisions, that is section 14 of the Specific Relief Act. The judgment passed in HON'BLE Salabai is also inapplicable to the present factual scenario, as we are not dealing with the sale of an immovable property. In the present case, the development agreement has to be looked in a separate light and perspective. The argument raised by Mr. Mitra that specific performance cannot be allowed in a particular case where the contract would require continuous supervision from the court as per section 14b of the Specific Relief Act is also not tenable, as there is no micromanagement required by the court at all. This is not a case where the court would have to step in at each stage of the performance of the contract and supervise it. Accordingly, this argument is rejected. Counsel for the defendant has further submitted that the contract of which performance is dependent on the personal qualification of the parties, it's not specifically enforceable as per 14C of the Specific Relief Act. I am not inclined to accept this argument because the development agreement clearly highlights that certain works have to be performed by the architects and contractors, which does not require the new nominee, which is Meena Agarwal, to be personally qualified to complete and carry out the remaining works. Furthermore, it is to be noted that the development agreement is between two companies and not between an individual developers whose personal qualification was specifically required to carry out the development work. Hence, the above argument that the personal qualification of the earlier power of attorney holder is necessary and contract cannot accordingly be specifically enforced is rejected by me. Lastly, the judgment cited by the defendant on the issue, time is of the essence, are also inapplicable to our case. Venkateshwara Mineral and Anandram Mangatram deals with contracts where movable property is the subject matter of sale and purchase. We are not dealing with such property in the present case. Hence, the principles of these two judgments would not apply. Now, my lord, the penultimate paragraph. Upon examining the aforesaid judgments, the principles that emerge are delineated below. The terms of the contract are to be looked into, specifically the one that prescribes time as essence of contract. Other provisions of contract may, on its construction, exclude an inference that completion of a work by a particular date is fundamental. These are all to be tried. These are all triable issue, not a demurrable issue. Certain clauses that provide for mutual extension of the contract may also lead to the conclusion that time is not the essence of the contract. Not providing consequences for breach of time may also lead to the conclusion that time is not of the essence. Intention of the contracting parties should be ascertained not only from written words of the contract, but the nature of the property, which is the subject matter of the contract, the nature of the contract itself, and also from the surrounding circumstances. The subsequent conduct of the parties will also throw some light on the original intention of the parties regarding the stipulated time limit of the agreement. Finally, one may refer to Durab Kasabji Warden versus such and such in AIR to understand the guiding principles for passing a mandatory injunction. But this part was set aside. I will not show this to your lordship. Now, my lord, if your lordship kindly comes to page 270. My lord, the 10th line from the top. The new provision of the Specific Relief Act. Has your lordship found it?
Yes.
Provisions of the Specific Relief Act 1963 clearly delineates the procedure to be followed by a court when allowing for specific performance of a contract. In my view, if this particular agreement is not allowed to be specifically performed, irreparable loss and injury would be a result of the same. Just because damages can be computed in form of money spent by the developer, it does not mean that specific performance cannot be given. Umpteen judgments of the Honorable Supreme Court have been highlighted this point, and one need not go further into the same. Further, the submissions with regard to section 14B and 14C has already been discussed and rejected by me at paragraph 26. This judgment cited by the defendant have been distinguished by me on the facts and on law and clearly inapplicable to the present case. Keeping in mind the prima facie case has been made out, coupled with balance of inconvenience, allowed with the following directions. Well, these are the directions. The respondent is directed to not create any third-party right till further orders. The prayer for grant. Well, this prayer B was something which was set aside. The prayer for grant of mandatory injunction in favor of the nominee is allowed. Now, my lord, this is an appeal is preferred, which is at page 272. But unless the court is satisfied it has jurisdiction, court has no powers to pass an order. So the court was prima facie satisfied that it has jurisdiction and the suit is maintainable, and which was not even touched by the appellate court. We do not wish to keep this appeal pending, dispensing with formalities. We have heard it out and are disposing of the judgment. The appellant defendant before us is the owner of the subject property. The respondent is a developer. They had entered into an agreement for development. The plaint was verified, such and such. My lord, I will not. The prayers of the suit has been set out. Now, my lord, page 274. Now, my lord, if your lordship kindly takes the third last paragraph from page 274. Going by the reliefs in the plaint, it appears that the respondent plaintiff was seeking specific performance of a development agreement through the mode of execution of power of attorney in its favor by the appellant. Nothing else was sought to enable specific performance. If that be so, then at the ad interim stage, a direction on the appellant defendant to execute this power of attorney in favor of the respondent plaintiff or its nominee tantamounted to granting the final relief in the suit. But as far as the order made directing the appellant defendant not to create third-party rights in the suit till further orders, it is prima facie sustainable at this rate, subject to the appellant defendant ability displacing the prima facie case made out before the learned single judge at the ad interim stage on exchange of affidavits. My lord, I believe that application is still pending.
Yes. That
application is still pending. They have taken no steps. In those circumstances, we set aside that part of the impugned order directing the appellant to execute a power of attorney in favor of the respondent. The said other part of the order is sustained subject to the observations made below. And directions were given for filing of affidavits. My lord, I seek to rely on.
But the second last paragraph.
My lord.
The single judge will not be influenced by any fine.
Yes. My lord, that is for an ad interim order. I am here on a demurrer.
Okay.
I am here on a demurrer. It has not been demonstrated to your lordship that it is either barred by law or there is no cause of action in filing this suit.
Okay.
And now a point has been taken on section 12 that a part of the agreement cannot be enforced, which has been squarely covered by Santosh Amma, which is the only judgment which I seek to rely upon.
Okay.
And the full bench judgment of our High Court, my lord.
Okay.
But I believe.
How much time you take?
My lord, another 15-20 minutes, my lord.
Come on the next day.
My lord, only difficulty is, my lord, can it be on the next week, my lord, on next Monday? Because already I am suffering from COVID, and apart from that, whenever there is bad news, it's bad news from all sides.
First you take your rest.
Can it be on Monday, my lord?
Care of your health.
My lord, more than my health, I don't want my colleagues to fall ill because of me.
That's why suffering for the plaintiff, suffering for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 3rd July.
I'm grateful, madam.
Is it your lordship's pleasure that we hand over a copy of the judgments that we are going to cite now or on the next day?
If you give to other side, they can give. If time permit, they will give reply.
Very well. If
Mr. Mitra is aware of all those judgments. Both Mr. Mitra and Mr. Sharma.
Madam, may we be permitted to hand over copies to your lordship? Two of the decisions that we are relying upon, B. Santosh Amma, this is reported in 2020-19 Supreme Court cases, page 80, and the full bench decision of our Honorable High Court.
Comprising of all my lord justices. Justice Arijit Banerjee, Justice Oshim Banerjee, and Justice Sanjeev Banerjee.
This is of
We have handed over the copies to the other side also, lordship.
My lord can have it on record that we have handed over copies to my learned friend on the other side. 3rd of July.
Yes.
Grateful to lordship.
Grateful, my lord.
My lord, I profusely apologize for not being able to come at 2 p.m., my lord. My lord, I got stuck because of a possession matter which came in suddenly as an urgent matter before the division bench.
But what can be done? See, this court is having.
I understand completely. I have nothing to say other than apologizing, my lord.
All advocates knows if the date, because what happens, time is fixed. You are not taking the benefit of that time. The other.
I know. I myself said last time that it would be unfair if we don't abide by those orders. My lord, only one thing, it will be extremely embarrassing for this young boy who is in the first year if that 25,000 cost is there. Nothing else, my lord.
Cost at other. Cost at other.
In fact, I was ready with the matter. We had come with.
Okay, come on. Next week.
My lord, if can be preponed on, my lord has pushed it to August.
There is no time. That's why.
If Thursday also, if my lord keeps, I'll come and finish the matter.
Don't think any date is there. Koi date hai? There's not time. I can fix that, but time will not be.
Fine, I'll come back on.
I can fix the date, but the time can't.
I understand. My lord, 4th August. That punishment I'll take, my lord.
Yes, next.
Grateful.
Time fix করে দিক না 4th August ছাড়া
হবে না so 4th August, my lord, at 2 p.m. again.
No, 3:45. Yes.
On defendant suit, I appear for the defendant. My lord, I'd shown your lordship. This is that where, my lord, the central issue is, apart from other issues, whether there's a running and continuous account or the payments are bill-wise. This was, my lord, one of the main issues, and I'd shown your lordship, my lord, listing your lordship with the other issues. My lord, I've shown your lordship that from the ledger which is there, which he has produced, and the ledger which was annexed to the plaint, the dichotomy between the two ledgers, the ledger annexed to the plaint shows bill-wise payment. In fact, there's a specific narration to that effect. That narration is omitted from the ledger which is placed in evidence. Now, my lord, may I show your lordship a few questions of the plaintiff's witness, because he was the only witness in the suit. Kindly have, my lord. Chief, there is an affidavit evidence, and then there is further examination in chief, my lord.
Yes.
Affidavit evidence I have shown your lordship, my lord, 2 paragraphs. Now, my lord, may I show your lordship, coming back to the ledger, what his deposition on the ledger is, my lord?
Yeah, on commission, na?
On commission, please, my lord.
Of the plaintiff.
There is only the chief of the plaintiff, my lord, Neeraj Chokhani.
Neeraj Chokhani, yes.
Now, my lord, if your lordship kindly comes to question 125, which was put to him in evidence in chief.
125.
Yes, please, my lord.
Yes.
What is this document? This is the ledger of the account of the defendant as shown in our books of accounts. This is the document. Now, kindly see the next. Who has prepared this document? This document has been prepared by the office accountant and myself. And my lord, kindly make a note of the next few words. From the books of account of the company. Kindly make a note of this, my lord. He says, this ledger is a document which he may have prepared, his accountant may have prepared, but it is from the books of account of the company. So the books of account of the company, my lord, are the primary document. Primary evidence is the books of account of the company.
Correct.
This is secondary evidence, which is now a compilation. Now, my lord, kindly see 127. Although he has already said from the books of accounts, a further question is put to him in chief. On the basis of what documents was this ledger prepared? This ledger was prepared on the basis of invoices raised for the tea supplied. Now, my lord, kindly see the next. And the payments made by the defendant against these supplies. So, payments made by the defendant, my lord, there is, apart from the ledger, there is no proof of payment. So, again, my lord, primary document missing. Now, kindly see how he says further, my lord. Kindly now see 130. Where is the original of this document? The original of this document is with the defendant. He says the original ledger is with me. How was this document delivered to the defendant? At this moment, I do not recall how this document was delivered to the defendant. And this is all this is in chief. So he says that the original ledger which he has prepared, copy whereof is annexed here, original is with me. He says certified true copy. I'm sorry, my lord, I should have shown you lordship 129.
This is in chief.
This is chief. This is not cross. Evidence in chief, affidavit, then further oral evidence in chief.
Yes.
And your lordship kindly sees, my lord, what he is produced is the certified true copy of the ledger. The original ledger, he says, is with me, and there is no proof of service on me. And two very important things come out, my lord, from this chief. One, it is from the books of accounts of the company, which is the primary document, not produced. Second, proof of payments made by the defendant against these suppliers, there is no proof. Now, my lord, there are other issues also. I'll come to your, show your lordship, my lord. Now, kindly see 132 onwards. Now, this is at the next day. Now, having realized what he has done on the first day, further questions are put. Can you tell this honorable court as to how this document was prepared? This document was prepared from the books of accounts in our office, which are digitally stored in our accounting software in the computer. This particular ledger of the defendant is from our records of the books of accounts. So, my lord, the books of accounts which are digitally stored in his computer, printouts of that are not produced. Again, my lord, primary document not produced. Had this document been stored or prepared digitally in the accounting software in your computer? Yes, this document is prepared and stored in our accounting software. Then where is the original of the document? He has earlier said it is with me. Now kindly see, where is the original of the document? This is a digital record and stored in digital format in our computers, and certified copy of the original printouts have been given to the defendant. Can you recall as to how this document was given to the defendant? This document was handed over to the defendant, Mr. Dinesh Kumar Agarwal, personally by me in his official capacity as managing director. Now, very interesting here. Now, your lordship sees the witness suddenly recollects on the next day that he has himself personally handed over. And the previous day he says, I do not recall how this document was delivered. Kindly see now 131 read with 135. Miraculously, my lord, his memory comes back. Now, there on the other issues, my lord, I'll come to the questions later. So now on ledgers, your lordship sees these are his evidence in chief. Now, my lord, kindly see the cross-examination on the ledger. Kindly have question. Kindly have now 401 onwards, my lord. I want to show your lordship, my lord, why these ledgers and invoices cannot be. I'll show your lordship the law later, but on facts itself, I want to satisfy your lordship that this claim cannot stand. Kindly see 401 in cross now. Shown page 48 of the affidavit of evidence of PW1. Do you find from this purported invoice dated 22nd February 2018 being invoice number, my lord, kindly make a note, 1718 of 2018, that you have made a purported claim to the tune of rupees 7.48 lakhs odd? Yes, I do. Then shown page 38 of the plaint. Do you also find from this invoice that the invoice number mentioned herein is also 1718 of 2018, but which has a different date, 1st February 2018, for a different sum being 2,49,000? If yes, which invoice according to you is the actual invoice? Yes, I do. Both the invoices are correct. It is a clerical error in the numbering. So, my lord, for the same invoice now, kindly have, my lord, his affidavit evidence, page 48 once. Why this assumes some significance, my lord? Because your lordship will not find any proof of actual delivery of goods supplied. These are only invoices backed with a ledger. There is no proof of delivery of even a single good supplied against any of these invoices. Kindly come to page 38 of the plaint and page 48 of the ledger. I'm sorry, of his affidavit evidence.
38 of the plaint.
38 of the plaint and 48 of his affidavit evidence. corresponding document evidence में है या नहीं, तो plaint में है वो evidence में है या नहीं. Kindly see, my lord, page 38 of the plaint and 48 of the evidence. Kindly see, my lord, tax invoice number.
Yes, 1718.
18, tax invoice number 1718. Kindly see the difference in date.
Yes.
And kindly see the difference in amount.
Yes.
And my lord, these are, your lordship sees, these are tax invoices. These are not pro forma invoices. There's a component of IGST, CGST, SGST.
Yes.
So everything of his is computerized.
Yes.
And my lord, the invoice at page 38 of the plaint is not tendered in evidence.
This one?
Yes. Which is 48 of the evidence, yes. The document at 38 is not in the evidence. The document at page 38 of the plaint is not to be found in the evidence. Now, my lord, more interesting, I want to show your lordship, my lord, how this ledger, on the face of it, is a sham document. Kindly come back to the ledger, please, my lord, at page 67. And that is why he doesn't produce any primary evidence. Kindly come to the ledger at page 76, please, my lord, which is his exhibit D, which your lordship saw.
76?
Yes. 76 of his affidavit evidence.
Yes.
Now, my lord, this is his ledger. 1st April 2018, debit balance of 5463,833.41. Opening, first figure, my lord. Your lordship has that.
Yes, yes.
The ledger prior to this period is not disclosed. What he does disclose is, my lord, certain bills. The bills which are there prior to this date, he has disclosed all these invoices. Now, the bills which are prior to this date start at page, my lord, 31. Kindly turn to page 31 of the affidavit. Which is his first invoice.
Yes.
Your lordship has it, my lord?
Yes.
Now, this starts, my lord, this is according to him the start of the transaction. This is all the document he relies upon. Kindly see the date, 1st April 2017.
Yes.
Now, my lord, your lordship will not find any proof of service of this. There is no endorsement. There are some invoices later which bear some signatures. They say that is of my person. But 31, 32, 33 till 37 bear no, my lord, proof of delivery. More than that. In fact, till 38. So, in between, there is some signature of D. Sarkar, and in other invoices, there is no signature.
Yes.
Now, what I am trying to tell your lordship is this, that let us keep the delivery aside, I'll come to that later. The ledger starts with an opening balance, debit balance of 54,63,833.41 at page 76. The bills which are disclosed, your lordship has seen are from 1st April 2017. So, from 1st April 2017 to 31st March 2018.
1st April 17.
Yes, please, my lord, page 38, which your lordship just saw. I'm sorry, 31.
31, yes.
Yes.
1st April
This is he has to make out his case in support of this opening balance. So, 1st April 2017, where his bills start. And, my lord, 7th March 2018, where his bills end. Kindly come to page 53 for that financial year.
Page 53.
Yes. Is his last bill for that financial year, 17-18.
7 March 2018.
7th March 2018. Now, your lordship sees the next page is 17 July 2018. Kindly see the next page also, please, my lord. 54 is 17 July.
Yes.
So, my lord, kindly now come back to his ledger at page 76.
Yes.
His opening balance is of 54,63,833. So, we have to presume that ends with the bill of 7th March 2018. And the next transaction is of 17 July 2018. Now, my lord, I gave him all the benefit of doubt. These invoices then, which he has disclosed, assuming that none of these invoices were paid, they must add up to this figure of 54,63,000. These invoices for that previous financial year, where he starts with the opening balance of 54,63. So, my lord, as on 31st March 2018, the invoices which he discloses from page 31 to 53 must add up to this figure of 54,63,000. They do not add up. Kindly see, my lord, I prepared a computation chart to assist your lordship. This is not evidence. This is just a tabulation of the evidence which is already so-called evidence.
So, 31 to 54 is not matching.
It is not matching.
With regard to the opening balance.
53 क्या लिखे हो? 120? Yeah, there's a typographical 1 minute. The soft. It will be 53 lakh 120 2 zeros. But I'll hand it. The soft copy which came to me was correct, but it doesn't match. It doesn't match, my lord, with the
54.
It doesn't match. So, my lord, his opening balance figure, which is his whole claim, is not established even from the so-called invoices which he produces. he will have to show your lordship that these invoices at least add up to 5463.
Yes.
The invoices, my lord, at pages 31
to 53.
do not add up to, my lord, 5463 833.41. This figure is entirely imaginary. Even if I take these invoices to be genuine, even then it doesn't match. Now kindly come back to his cross, please, my lord. 40 that 16 sitting, my lord, 405. Now kindly see.
May I have your lordship's leave?
Yes.
Kindly see 404. So therefore, I take it that based on your evidence, both these invoices will be reflected in the books of accounts of the plaintiff. The answer is yes. Both these invoices, my lord, being the two discrepant invoices bearing the same numbers. In his affidavit evidence, he doesn't give this previous invoice. Yes. Now, have you disclosed the books of accounts of the plaintiff along with your evidence? Answer is yes. A complete statement of account of transactions with the defendant has been duly submitted. He says, I've submitted. Next question. Can you point out from the records of this case where the books of accounts can be found? I will revert with the appropriate answer on the next sitting. Now, my lord, I ask him on the next sitting. Kindly turn to, my lord, page 43, question 430.
Yes.
430. Are you in a position to answer questions 406 and 407 of your deposition today? The subject invoices, those are the two discrepant invoices, are not separately mentioned in the statement of accounts submitted by the plaintiff, as the subject invoices pertains to transaction from the previous financial year, and they are included in the brought forward figures mentioned in the statement. These invoices have been accepted, acknowledged, and admitted by the defendant. So, this books of account, which is a primary document, he is not able to show from the record because it is not there. Now, kindly come to 433. Although you have a claim for the financial year March 2018, you have not disclosed the ledger for the period prior to March 2018. The statement submitted by the plaintiff was for the net amount outstanding at the time of the claim, and it had brought forward figures from the previous year clearly mentioned in the statement of account. And kindly see, will you be able to show the breakup of this purported carried forward figure from your plaint or affidavit of evidence? Neither the plaint nor the affidavit of evidence would show the breakup of the carried forward figure from the previous financial year. It is a single carried forward figure of the dues from the last financial year as per the accounting procedure. Mr. Chokhani, where is the ledger pertaining to the period prior to 31st March in your plaint or in your affidavit of evidence? It is not there. I am now suggesting to you that the books of accounts which you have disclosed is a partial statement, does not contain any particular suggestion. I am not entitled to put, my lord. Kindly do not consider 436, but 434, 435. The ledger for 54 lakhs, which is his primary claim, is not there. Now, kindly come back to question on the correctness of his ledger. Kindly come to, my lord, 420, please, my lord. Question 419 and 420.
Yes.
Is there any document wherefrom it will appear that the defendant had stopped making payments? He says stop making payments at 418, please, my lord. Kindly come to 400. So therefore, it is your evidence that the business transaction between the parties was based on mutual good faith, as a result of which there was no need for any written communication between the parties. Yes, the business relation with the defendant was based on mutual good faith, for which no written communication was required till the time the defendant stopped making payments. Is there any document wherefrom it will appear that the defendant had stopped making payments? The copy of the ledger has been submitted and a legal notice has been served to the defendant by the plaintiff, wherein it has been clearly mentioned. When, according to you, was the copy of the ledger submitted to the defendant? Witness goes through the plaint and the affidavit of evidence filed in the said suit. Leave is granted. I shall check and revert on the next day. Kindly see. And your lordship remembers his answer in chief. May just give your lordship the question in chief. 135.
Yes.
He says, it was personally given to me by the defendant in my capacity as managing director.
Yes.
Day prior to that, he says, I don't remember. 131. How was this document delivered? I do not recall. 135, he says it was handed over to the defendant. Now, this is on 3rd of October. And now, my lord, 420 comes and says, again, I don't know when it was given. I shall revert on the next day. Now, I am suggesting to you, so 3 different answers. I am suggesting to you that prior to March 2019, there is not a single document forming part of your plaint or the affidavit of evidence wherefrom it will appear that you have sent the alleged letter to the defendant. I do not agree with your suggestion, as no such statement was required in writing, since supplies were being made by the plaintiff and the payments were coming in regularly from the defendant without any dispute. So in effect, my lord, he's saying that he does not agree with my suggestion. No ledger was required to be given as payments were regularly coming. And this, your lordship, contrasts with 135. He says, I have personally given. Now kindly come to 422. Therefore, there is nothing on record to show that the purported ledger was sent to the defendant at any time prior to March 2019. No, I do not agree with this, as confirmation of statement of account was done every year prior to the year in which the dispute arose. Have you disclosed this purported confirmation of statement of account as part of your evidence? No. This has not been included as part of our evidence, as the defendant has agreed, acknowledged and not disputed the outstanding amount due demanded by us. As a matter of fact, now let's kindly see now how the whole narration changes. As a matter of fact, the defendant agreed to pay the outstanding amount during the mediation proceedings without any dispute. Now, confirmation of accounts, he says, I've sent, he does not produce it. And he says, you have agreed in the mediation. I'll show you, lordship, mediation act, nothing which is said in mediation can be relied upon in court. Cannot be. His entire evidence now, I'll show you, lordship, everything is in mediation.
Mediation, whatever the talk between the parties, whatever the document delight, that cannot
be looked into. So, my lord, your lordship, recollect the learned counsel had admitted this, but he also made a reference to this in passing, in arguments. Now, his witness repeatedly says everything is now in mediation. So, he has no documentary evidence of any confirmation of accounts, and everything he says is in mediation. So, your lordship has seen 423. Now, kindly turn to 437. Are you in a position to answer question number 420 today? This was not required strictly, my lord, but then it has been put. Now kindly see, 420 was, how was this ledger given to the defendant? The ledger and the statement of accounts were regularly checked and tallied by the defendant during his regular visits to our office, and there was no dispute in the accounts. And defendant is a private limited company, your lordship will kindly bear in mind. My question was, when, according to you, was a copy of the ledger submitted to the defendant as deposed by you in answer to question 419? Besides the regular checkup of accounts and ledger during his visits, now kindly see, my lord, a proper ledger of pending accounts was also presented during the mediation proceeding. Everything is in mediation. 439. Have you stated anywhere in the pleadings regarding the alleged regular checkup of accounts which the defendant allegedly tallied during the so-called regular visits to the office of the plaintiff? If so, kindly indicate where in your pleadings or evidence you have stated so. No, it has not been submitted, as it was never required, and the defendant had already accepted and agreed to pay the outstanding amounts during the mediation proceedings. Evidence now being adduced beyond his pleadings. Then kindly see.
This is called the intelligent witness.
This is called the intelligent witness. Now, kindly see, my lord, how to the extent this witness is, my lord, economical with the truth, if I may put it mildly. Kindly come back to 424 once, please, my lord. Was this, kindly see 424.
Yes.
Was this purported confirmation of statement of account before the mediation committee when the pre-institution mediation took place between the parties? He says, I will have to check and get back. Now kindly see his answer. 441. Because 423, he says confirmation was before the mediation committee. 424, I ask him, where was it before the mediation committee? Now kindly see 441.
Not
Are you now in a position to answer 424 today? No, it was not placed as it was not required. Every second time, my lord, he changes his answer. Now kindly see 442. Please show from the records that there was any confirmation of statement of accounts sent to the defendant at any point of time as you have deposed earlier. No such confirmation of statement of account was submitted as it was not required, since there was no dispute regarding the amount outstanding with the defendant. And why did you say it was submitted year to year?
Yes.
Then therefore I take it that there was no purported confirmation of statement of accounts which was done every year as deposed by you earlier. I do not agree with your suggestion. But still he says it was not required since everything is admitted. Now kindly come to 456 and 457. Please look at the entry made on 1st January 2019. This I am showing him from the ledger. I am suggesting to you that payment of the invoice value reflected on such date was made on 3rd January 2019 as per your own narration in the entry dated 3rd January 2019, which says, being the check received from party above towards our invoice. Yes, I agree with your suggestion. So this is the, my lord, invoice-wise payment. He agrees. Then kindly see 457. Please look at the entry made on such and such date. I am suggesting to you that the payment was made on so-and-so as per your own narration in the entry dated 22nd January 2019 towards our invoice. Yes, I agree with your suggestion.
Yes.
And 455, I must show your lordship in fairness. Kindly see 455 now. Please look at the entry made on 15 December 2018. I am suggesting to you that the payment of the invoice value reflected on such date was made on 19 December. As per your own narration, so-and-so, being the check received from above party towards our invoice. Now kindly see. No, I do not agree with your suggestion as the amount is different and the only difference it is rounded off. So invoice-wise payments made in 2 cases he agrees. In the 3rd case he says, I don't agree only because it is rounded off. So his own evidence and his own documents would show payments were, my lord, invoice-wise and not on a running account basis. Now kindly come to, my lord. All this, my lord, I am showing your lordship just to say that on the facts, there is no case. On the facts, from his own documents, from his own evidence, there is no case. That this case does not stand in law. I'll show your lordship now. That even on the basis of a legal, if I were to advance only a legal argument, even then this case would not stand. Kindly now have, my lord, section 34 of the Evidence Act. Yes. Have the lordship handed over the right? This is the right chart. Madam, this, my lord, this is the correct chart. My lord, those 2 zeros were missing. This is the sum total of all his invoices from April 2017, 53 lakhs 100. Kindly have section 34 of the Evidence Act.
Yes.
Entries in books of account, including those maintained in an electronic form. So this is his case. These are entries in books of account maintained, regularly kept in the course of business, are relevant when they refer to a matter into which the court has to inquire. But such statements shall not alone be sufficient evidence to charge any person with liability. So, my lord, only the statement in his ledger is not sufficient to charge me with liability. Kindly see the illustration there. A sues B for rupees 1000 and shows entries in his account books showing B to be indebted to him in this amount. The entries are relevant but are not sufficient without other evidence to prove the debt. This section and the statutory illustration is clear.
Yes.
So, my lord, entries, and now I will show your lordship, my lord, that the ledger is not even a book of account. Your lordship has seen his evidence. He says ledger is something which I prepare from my books of accounts. It is not the primary document. If he brings in a secondary evidence, he first has to lay foundation as to why the primary is not there. There is no foundation. So, secondary cannot be looked into. And the secondary, my lord, is irrelevant. Even if this was the primary, even if the ledger was the primary, even then it is not sufficient to, my lord, prove the debt. Now, in a case of, my lord, sale of goods, this is his case of sale of goods, he only shows the invoice. He does not show any e-way bill, does not show any challan, and all these invoices, my lord, are under the GST regime. Your lordship knows under the GST rules, all the documents which are required to be filed, not a single document is produced. There is no proof of delivery of any goods against these invoices.
Yes.
The statutory returns which were required, the statutory documents which were required to be compulsorily filed, which appears from these invoices, GST, nothing shown. Now, kindly see the judgments on section 34, please, my lord. So, Assam first. Kindly have, my lord, AIR 1952 Assam, page 92.
Yeah.
The division bench judgment of the Guwahati High Court, my lord. Kindly come to paragraph 4. This was a suit on monies lent and advance, my lord. The case for the plaintiff was that the defendant borrowed different sums on 3 different dates. The total amount borrowed was rupees 2000. The amount was not repaid on demand. He claimed 2000 principal and the rest as calculated at so-and-so interest, 2% plus item. Defendant's plea was that a sum of rupees 1625 had been paid back. This consisted of 4 items paid on different dates during these months. He admitted his liability to pay interest at court date. The political officer, who's one of the court at the first instance, trial court, came to the conclusion that the plea of repayment to the extent of 1625 had been substantiated by the evidence given by the defendant. He therefore allowed the claim of plaintiff to the extent of 700 only, which includes interest calculated and so and so. It has been urged on behalf of the appellant that the payment of 1625 has not been proved, and the findings of the political officer on this point is unsustainable. We have only the statement on the defendant on this point. He did not examine any witness. His own statement was that he paid so-and-so. Now kindly see next, my lord. He also deposed that he had entered these payments in his account books which he produced. The entries were marked exhibit A, B, C and D. He further stated that gave him a clean sheet. I'm not troubling lordship with. So, my lord, the defendant examined himself and he produced his account book which said A, B, C, D. Now kindly turn over, my lord, to paragraph 7. The first question is whether the account books relied on by the defendant in support of the plea of repayment can be regarded as relevant. In order to be relevant, they must be kept regularly in the course of business. They must be in conformity with some known system of accounting. The books produced in this case do not fulfill these requirements. They are merely the ledgers of the defendant. These are not supported by any day book or roznama. They do not contain entries of transactions as they take place. There is no daily opening or closing balance in the ledger accounts. What has been shown from these books is that there was a plaintiff's account, and in that account entries were made. These entries could all have been made on any one day. These books therefore cannot be regarded as relevant under section 34 of the Act. The entries in books therefore could not be used in evidence. we are still left with the, I'm not troubling your lordship with the oral evidence. So, my lord, the ledger is not the books of accounts which are maintained. Now, in this case also, your lordship has seen his admission in chief that these are, I have books of accounts which are kept in the electronic system. From those books of accounts, the ledger is prepared. He does not show the original books of accounts. Electronic maybe, but he does not produce them. Now, my lord, this has been relied upon by the Bombay High Court, among other judgments also. This is, my lord, the settled position in law. AIR 1981, Bombay 446. This was in appeal before the division bench. This is in appeal before the learned single judge. Kindly have, my lord, paragraph 1. Diya maine judge ko. These two petitions arise from the judgment of the bench of small causes court in appeal number so-and-so. These two appeals in their turn arise out of so-and-so. Now, suits for eviction, I'm not troubling your lordship with this. Kindly come to paragraph 22, where, my lord, this, I'm sorry, kindly have paragraph 18 because this is matching with the facts of our case. Kindly come to paragraph 18.
Yes.
It is stated above, your lordship has that, my lord?
Yes.
It is stated above that as per the witness, the ledger entries were made not from any journal or from any day book or from any cash book or from Rojmail, that is the daily book, my lord, as such, but that entries were made directly from the bills. So this is what the witness said in that case. Even then, my lord, it was not believed. Our case is better. Our case says there were books of accounts. Now kindly turn to, my lord, the argument at page 22.
Yes.
Coming then to the most important point in this petition, it is urged by Mr. So-and-so that even according to the learned judges of the bench, the evidence of so-and-so was wholly insufficient. The portion of the judgment of the lower courts relevant in this behalf has been set out, and it becomes clear from the same that even according to the learned judge, the evidence of Tarachand had to be corroborated by some relatives. Mr. Rane contends that when the lower court, Mr. Rane, your lordship has that?
Yes.
Mr. Rane contends that what the lower court construed as reliable evidence is not only wholly unreliable, but also wholly inadmissible piece of evidence. He contends that at any rate, it is wholly devoid of any evidentiary value. For this purpose, Mr. Rane invited my attention to the following facts. The so-called ledger is not a book containing accounts at all. It is only a bundle of sheets which could be loosened at any convenient time. Any sheet could be taken out just for the asking and could be replaced by any other convenient sheet. It is not a bound book at all. Pausing here for a minute, your lordship sees the two different ledgers, one to the plaint, one to the affidavit. So it can be manufactured at any time at the sweet will of the plaintiff. Then your lordship kindly sees B. I'm showing your lordship the argument because the learned single judge of the Bombay High Court has accepted these arguments. The ledger by itself is only a secondary piece of evidence. Entries are always made first either in the Rojmail or in the cash book or in the day book as the case may be, and they are posted periodically into the ledger subsequently. As a matter of fact, it is evident from what is produced as a ledger before me that the posting has been done at so-and-so on one sitting in respect of compensation. I'm not troubling your lordship with this. So it is a piece of secondary evidence, not primary. Our witness has also admitted this, my lord. This is evidently a secondary piece of evidence. The primary evidence would have been the cash book or the day book or the Rojmail, whatever was being maintained. As a matter of fact, defendant number 3 had made an affidavit of documents, which this affidavit I'm not troubling you with. Kindly say the next sentence. The cash book, however, was never produced before the court. Now, my lord, kindly sees, then relying upon the final conclusion is there. The so-called ledger is not a book of account at all and is not admissible in evidence at all. Even if it is admissible, it is a sham document and it has no evidentiary value whatsoever. As regards the circumstances, Mr. Rane further contends that the so-called ledger by itself cannot prove any particular entry, it being only a secondary piece of evidence. The entries in a ledger only reflect the entries that are made elsewhere in ledger, initially in books, such as the Rojmail, the cash book, or the day book, etc. The primary account books, therefore, are the Rojmail, the cash book, and the day book, etc. Then, I'm not troubling your lordship with the other. Kindly come to now, my lord, the judgments which are noticed here. Kindly see the next page. Mukundram versus Dayaram, 1914, Nagpur. An entry to be admissible in evidence under Section 34 Evidence Act must be shown to be a book. that book must be a book of accounts and that account must be one regularly kept in the course of the business. The term book may properly be taken to signify ordinarily a collection of sheets or paper bound together with the intention that such binding shall be permanent and collectively in one volume. Now, this may not perhaps apply now because of the electronic media. A book which merely contains entries of items of which no account is made at any time is not a book of accounts for the purpose of section 34. This applies even today. The legislature did not intend to include in that category any record in which there is no process of reckoning. The fact of regular maintenance and genuine accuracy of account books, if not maintained, must be formally proved by the evidence of some persons competent. The evidential value of books will depend upon their formality and the checks against fraud, etc. Now, kindly see 23, where it is accepted. I do feel that Mr. Rane's contention in this behalf is unassailable. All the arguments of Rane are held to be unassailable. A mere look at the entries in the so-called ledger read with the index are enough to show that they could be brought into existence at any time. So, they are not kept in the usual course of business. It can be prepared at any date. Then kindly come to 27, please, my lord. I also find no difficulty in agreeing with Mr. Rane that the ledger which is sought to be produced and relied upon is not a book of account in the real sense of the term as contemplated by section 34 of the Act. In order that a document could be relied upon as a book of account, it must have the characteristic of being foolproof. A bundle of sheets detachable and replaceable at a moment's pleasure can hardly be characterized as a book of account. Moreover, what section 34 of the Evidence Act demands is a book of account regularly maintained in the course of business. A ledger by itself could not be a book of account of the character contemplated by the section 34. Even assuming that the book of accounts produced was a duly bound book of account, unless the other books, kindly similar, unless the other books for checks and cross-checks were made available, and unless the primary books of accounts are produced, the ledger by itself could have no evidentiary value.
How much time will it take, Mr.
I'll take another 20 minutes, please. There's a matter of fix, please. Yeah.
Sense appearing for the plaintiff, sense appearing for the defendant. Counsel for the defendant is argued the matter at length, but due to paucity of time, hearing could not be completed. Matter. July
2nd.
Next.
My lord has not been pleased to fix any time. It will appear in the list. Wait.
Very lucky you're here because of another.
Left with the pending undefended suits, so there's no written statement. So, wait, one after the other.
Yes.
My lord, I was distinguishing, my lord, the cases which my learned friend, my lord, had cited. And the case, my lord, last case I distinguished, my lord, was 2019, 6 Supreme Court cases, page 82, my lord. My lord, your lordship recalls the point here, my lord, and I must point this out, my lord, B, my lord, here, my lord, time to file written statement, my lord, has expired. So the right has been forfeited, my lord, to file a written statement. My lord, and Order 7, Rule 11 was filed, my lord, for dismissal, my lord, rejection of the plaint. My lord, that was rejected, and your lordships, my lord, categorically held there that the issue involved is, my lord, interpretation of a particular clause of, my lord, the, my lord, partnership deed.
Correct.
Now, my lord, interpretation is a question of law, and my lord, that can certainly, my lord,
argue.
My lord, on that interpretation, my lord, a decree, my lord, can be passed.
Yes.
Now, my lord, I must tell your lordship, my lord, another thing that has happened. From that order, my lord, it was carried to the Supreme Court. And, my lord, the Supreme Court, my lord, has, my lord, dismissed, my lord, the special leave petition. My lord, this is, my lord. What is wrong with you? Why do you attend conferences then? My lord, my lord, place that. So, my lord, as of now, my lord, earlier the stand was, my lord, matter is pending in the Supreme Court. That has gone. So, my lord, your lordship's decision, my lord, is holding, my lord, the field. Now, my lord, my learned friend had cited a series of judgments, my lord, as to, my lord, why, my lord, here, my lord, a decree should not be passed. My lord, having, my lord, the right to file written statement being, my lord, forfeited, my lord, none of these, my lord, cases, my lord, are relevant in my respectful submission. Last case, my lord, your lordship might note, I think I had, my lord, dealt with 2019, 6 Supreme Court cases, page 82. No, I want the... I think that's the last case, my lord. Your lordship had made a note, if I remember correctly.
Yes.
My lord,
2019.
Yes, 6 Supreme Court cases, 82. That's the last one, my lord, I had dealt with. Their cases, my lord.
Yeah, judgment सही है 2019 का है देखो 2019 नहीं है
Manupatra আছে Manupatra দেখুন
यहाँ दो
জগদীশ প্রসাদ পটেল পেয়ে গেছেন My lord, confusion might be, my lord, because I think Manupatra's, my lord,
Yes, Manupatra is
yeah, so that's why, my lord.
Jagdish Prasad versus
Yes, that was
Shivnath.
that was the last case, my lord, which I dealt with, my lord, which was cited by them.
Yes.
My lord, and my lord, there, my lord, there was, my lord, paragraph 6, your lordships will find, my lord, this related to title to immovable property.
Yes.
And my lord, in paragraph 6, my lord, your lordship will find, my lord, that a written statement, my lord, had been filed.
Yes.
Paragraph 14. Sorry, paragraph 14, my lord, paragraph 14, not paragraph. My lord, paragraph 14, your lordship will find that
Yes, WS fine. Yeah. Trial court while deciding so reverted and
yes.
Yes.
My lord, is a totally different case, my lord, when contest, my lord, where, my lord, an issue had been put, my lord, to title.
Yes.
Now, my lord, here, my lord, interestingly, my lord, title of the firm to the goodwill is not an issue. My lord, all that he says is, your lordship seen, my lord, in the affidavit in opposition, my lord, all that he says is, I have to get something in addition to that provided in clause 17 of the partnership deed towards my share of goodwill.
Correct. That's why
It's
he
a
is telling that.
compensation which is claimed.
Yes, he is telling that with regard to the compensation,
Correct,
how it has to
correct.
be
He's not-
ascertained without
so,
the.
my lord, there's no dispute as to title, my lord, regarding goodwill. My lord, it's the deed. Now, my lord, when the partner my lord, dies, or my lord, let us say had resigned, my lord, from the partnership, then my lord, the outgoing partner or his heirs, my lord, what are they to get? My lord, my lord, there's a provision made under clause 17, which includes goodwill, which I've shown your lordship, my lord, compensation towards goodwill. So it's a question of interpretation. Now, my lord, may I come to the next case, my lord, which is, my lord, 2014, two Supreme Court cases, 269.
Yes.
Now, my lord, kindly see, my lord, this decision, my lord, was again, my lord, relating to, my lord, immovable property. Kindly come to, my lord, paragraph 15. Yes, kindly note, my lord, number 1, my lord, that, my lord, there was, my lord, a written statement, my lord, which had been filed in this case as
A
well.
written statement and evidence was led and
Correct,
the
everything.
were exhibited.
Then, my lord, kindly have a look at, my lord, the prayers. My lord, paragraph 15, my lord, was, it is strike law that in a suit for declaration of title, the burden always lies on the plaintiff to make out and establish a clear case for granting such a declaration, and the weakness of any of the case set up would not be a ground to grant. Yeah, my lord, there is no title, nothing, my lord, which is involved. Then, my lord, and here, as I submitted, my lord, before your lordship, my lord, that, my lord, the title of the goodwill is of the partnership. What the, my lord, heirs, my lord, of a deceased partner will get, my lord, is provided for in clause 17. Now, my lord, the next decision which was cited was 2007, 4 Supreme Court cases, 306. My lord, here again, my lord, there was a written statement, my lord, which had been filed.
Yes.
And, my lord, the documents relied on, I'm sorry, my lord.
मनु तो तुम लोग रखो इसको निकाल कर दो रखो उसमें नहीं है इसमें देख
Lordship has that, I'm sorry.
Yes.
My lord, it's the case of Amarnath Agarwal versus Dhillon Transport Company. My lord, paragraph 2, my lord, 5th line. My lord, your lordship will find again, my lord, written statement. My lord, the ground for eviction was creation of wrongful wrongful subletting, and, my lord, transfer of, my lord, tenancy. My lord, written statement was filed. Yes. My lord, paragraph 2, your lordship will see, and, my lord, my lord, evidence, my lord, was taken.
Yes.
And, my lord, documents which were not exhibited at the trial, my lord, was sought to be, my lord, utilized for the purpose of proving subletting.
Yes.
Court said no, that can't be done.
Yes.
My lord, this is, my lord, no manner of application, my lord, in this case. Then, my lord, comes the case of, my lord, 1976, 2 SCC, page 58.
Yes.
Which is, my lord, the case of Executive Committee of West Degree College, etc.
Yes.
Now, my lord, here, my lord, kindly come to, my lord, paragraph 2. My lord, this is, my lord, a case on, my lord, declaration. My learned friend says the declaration which has been sought for cannot be granted. My lord, kindly see the appeal arises, para 2, if I may just place, my lord. The appeal arises in the following circumstances. The appellant, which is the Executive Committee of Vaishya Degree College in the district of Muzaffarnagar, was registered under the Cooperative Societies Act as an institution for imparting education. The affairs of the college were managed by the Executive Committee of Vaishya, which is the appellant. In the year 1957, Vaishya Degree was affiliated to Agra University, and as a consequence, college agreed to be governed by the provisions of the Agra University Act, statutes and ordinance made thereunder. With the establishment of Meerut University sometime in the year 65, Vaishya Degree got affiliated to Meerut. The plaintiff respondent was appointed as a principal of the college on permanent basis with effect from July 1, 1964, and his appointment as principal was formally approved by Vice Chancellor of Agra University. 2 years later, it appears that differences arose between Executive Committee of the college and the plaintiff respondent, resulting in allegations countered and culminating in a notice served by Executive Committee on the plaintiff respondent, directing him not to discharge duties of principal, and another letter was sent to defendant number 4 as member of the staff of college to officiate. This was followed by a counter notice by the plaintiff that the notice sent to him was illegal, and respondent also asked for not to assume charge of principal. On 12th March, the Executive Committee by resolution terminated the services of the plaintiff respondent with effect, and this even before the formal resolution terminating the services of the plaintiff was passed, it appears that the plaintiff had filed present suit before the court of so-and-so, which was transferred to for disposal to the court of the judge of the Munsif Kairana. The plaintiff's case was that, my lord, and my lord, kindly see his prayers, my lord, at para 3, my lord, last 4 lines of that page. The plaintiff accordingly played for an injunction restraining the defendants from interfering with his duties, so-and-so. It appears, however, from the record that after notice was given to the plaintiff by the plaintiff was bereft of all his powers, and in spite of his attempts to get into the college and work as principal, he was not allowed to do so, which led to it is therefore clear that at least after the resolution of the Executive Committee was passed, terminating the services of the plaintiff, he has not been. The position is not disputed before us by counsel for the parties. Then, my lord, defense, my lord, is referred to. My lord, your lordship will find, my lord, written statement had been filed. My lord, in paragraphs 4 and 5, evidence, my lord, was given.
Yes.
Then, my lord, your lordship, my lord, will find that, my lord, the suit, my lord, had been dismissed.
Yes.
And, my lord, the passage, my lord, which was relied on, my lord, paragraph 22. Kindly take, my lord, paragraph 22. My lord, before that, may I read para 21, my lord? My learned friends relied on 22, 24 to 27. My lord, may I read, my lord, para 21? In Jerome Francis versus Municipal Councillors of Kuala Lumpur, Lord Morris observed as follows. In their lordship's view, when there is been a purported termination of a contract of service, a declaration to that effect that the contract of service still subsists will rarely be made. This is a consequence of what? Of the general principle of law that the courts will not grant specific performance of contracts of service. Special circumstances will be required before such a declaration is made, and its making will normally be in the discretion of the court. In their lordship's view, there are no circumstances in the present case which would make it either just or proper to make such a declaration. So, my lord, this is on a contract of service. My lord, personal, my lord, obligations, my lord, are involved. Then, my lord, and trust, my lord, is involved. Furthermore, under similar circumstances, though the dismissal of the employee was by an authority which was not competent to dismiss him, namely municipal, their lordships of Privy Council refused to grant declaration in view of the peculiar facts and circumstances. The Privy Council in so-and-so, Municipal Council as so-and. As against this position, Mr. Ramamurthy, counsel for plaintiffs, submitted that Hill and Parsons, a declaration that termination was granted by the court. In that case, however, it was pointed out the declaration was granted under very special circumstances of that case, etc. Now, my lord, kindly take para 24. a division bench of Allahabad High Court in so-and-so observed. The second thing is court is given a discretion to make declaration sought, and the plaintiff need not ask for any further relief. Relief being discretionary, no person can claim declaration as of right. Then para 25. It must, my lord, another case, my lord, is cited of the division bench of the Assam High Court. My lord, again, my lord, discretionary relief, that my lord, paragraph 26, section 20, subsection 1, my lord, is specific performance itself, my lord, is discretionary. And my lord, after that, similarly, section 34 also gives a discretion to the court to grant a give a declaration of the legal character.
Yes.
A person entitled to legal character or to any right or to any property may institute a suit against any person denying, etc. This also gives, my lord, a discretion. Then, my lord, para 20, it seems to us neither the first additional civil nor the, while decreeing considered the aspect of the matter, whether this was a fit case in which discretion should have been exercised. It is manifestly clear from authorities that relief of declaration of injunction. Now, kindly mark, my lord, this. Under the provisions of the Specific Relief Act is purely discretionary and the plaintiff cannot claim it as of right. So, my lord, if I am saying, my lord, that, my lord, it affects my legal character or right to property, my lord, it's one issue. But, my lord, when I'm seeking a declaration based on, my lord, a written instrument, which is binding, my lord, it is not under, my lord, the Specific Relief Act.
Okay.
The relief has to be granted by the court according to sound legal principles and ex debitio justice. The court has to administer justice between the parties and cannot convert itself into an instrument of injustice. In these circumstances, while exercising its discretion, court must keep in mind well-settled principles of justice and should exercise the discretion so and so. So now, my lord, if your lordship sees, my lord, the Specific Relief Act. Yeah. Yes, my lord. My lord, kindly have a look at Specific Relief Act.
Yes.
My lord, kindly have a look, my lord. My lord, the point I'm trying to make, my lord, is the Specific Relief Act is not a complete code. Why is it not a complete code? Because it doesn't seek to consolidate the law. It only is amending the law. Kindly have a look, my lord. An act to define and amend the law relating to certain kinds of specific relief. Now, my lord, 34 with regard to declaration is a particular kind of declaration.
Correct.
Not, my lord, a declaration, my lord, with regard to what is the impact, my lord, of a document. My lord, the clause, my lord, in, my lord, a written deed. And, my lord, a suit, my lord, is maintainable, my lord, for this purpose under section 9. My lord, it's civil character. My lord, whatever relief I'm claiming, unless they can show, my lord, that the suit is barred.
No, it is not there, it is barred or it is their claim. Mainly, Mr. Thakkar has argued the matter. Okay, whatever this, but what you have assessed the claim, that they are not accepting because other claims are also there. That claim has to be pleaded in the evidence. Unless and until it has not been pleaded, how the other claim will come? That is the main argument made by me.
So, my lord, it's, my lord, if your lordship looks at, my lord, my reliefs once, in, my lord, the plaint, my lord, the first is declaration that the defendant number 1 is entitled to a sum of, my lord, a figure is maintained. In the particulars given in para 12, being his share in the amount payable to the erstwhile senior partner of so-and-so. So, my lord, kindly have a look at para 22 now.
Yes.
My lord, in the facts and circumstances, the plaintiffs are entitled to a declaration that the defendant number 1 is only entitled to a sum of so-and-so, etc. Being his share of the balance lying in the capital account of late Dinobandhu Mondal in the firm as on the date of his death, and a sum of 17 lakh as his share on account of the agreed share of the deceased partner in fees realized till 30th June on bills raised till the death of Dinubandhu Mon as per clause 17 of so and so. The plaintiffs are also entitled. Now kindly have his affidavit. He's admitting everything. My lord, kindly take, my lord, his affidavit once. My lord, which he has filed in GA1.
Yes.
That's his stand. Affirmed on 31st January.
Yes.
My lord, first, my lord.
GA1.
Yes, my lord. His affidavit in opposition of D1 and D2.
Yes.
To a better case.
More difficult case. My lords, kindly from here.
My lord, kindly have a look, my lord, at paragraph 6. My lord, page 3. Before dealing with the statements, allegations, contentions made in the petition, I say that the following facts are important to be considered. Kindly come straight away, my lord, to my lord, paragraph E, my lord.
Yes.
As such, in terms of clause 17 of the partnership deed dated so and so, the legal heirs of the said Dinobandhu Mondal are entitled to the following. Money lying in the capital account of so and so as on 30th June 2020. So all admitted. Now, my lord, the share of Dinobandhu Mondal in respect of outstanding dues up to 30th June, which has been realized on or before so and so, less the cost of realization. And then, my lord, shares in goodwill. Kindly see, then shares in goodwill.
Yes.
We are saying, my lord, nothing more. This includes goodwill. That's the only dispute, which is, my lord, a legal dispute, not a factual dispute. Whatever I have quantified. And, my lord, that clause 17, my lord, is the basis. My lord, kindly have a look at G. Kindly have a look at G. I say that the documents annexed to the petition would show that I've always tried to settle accounts relating to the share of my deceased father, who was a partner of the plaintiff firm, in terms of clause 17.
Yes.
And then, my lord, I. Kindly have a look at I. While I was consistently requesting the plaintiff to hold the fund and disburse upon they disburse funds to my brothers on the basis of an alleged settlement behind my back, it is the contention of the plaintiff firm that in respect of the entitlement of legal heirs of Dinobandhu, I am entitled to receive so-and-so being share of balance lying in so-and-so in the firm. The plaintiff further contended that between July a sum of could be realized out of. Accordingly, in terms of partnership deed, a sum of so-and-so has been allocated as amount payable to the estate of Dinobandhu, and on such basis, plaintiff determined so-and-so to be my entitlement in this regard. However, no amount for goodwill. There's no dispute as to these amounts. He says, I am entitled to more on account of goodwill. And we are saying clause 17. Now, kindly have a look at. Then, my lord, kindly see. Thus, the plaintiffs have been seeking to deprive the legal heirs of Dinobandhu, including me, in respect of entitlement of Dinobandhu Mondal on account of goodwill, which is contractually payable. So now, my lord, if these two figures are admitted and he says he wants anything more on account of goodwill, and he says that right arises out of contract, the additional amount, kindly have a look, my lord, at clause 17. If your lordship finds that, my lord, these sums are included, my lord, in clause 17. Clause 17 to the page 39 of my lord, page 39 of the plaint, my lord. Amended plaint. My lord, kindly have a look.
Yes.
The death or retirement of a partner shall not dissolve the partnership, but the partnership shall be carried on by the surviving partners. The partnership account shall be made up after 2 years from date of death, retirement of a partner, but within 3 years from the said date. The share of the deceased or the retiring partner in the outstanding bills up to the date of his death stroke retirement, which has been realized within a period of 2 years from his death retirement, less the cost of realization assessed at 30% of amount realized on these bills, shall be paid to the retiring partner or legal representative of the deceased partner on account of his share of profit and goodwill. My lord, my humble submission before your lordship is, my lord, first, my lord, it's an interpretation of clause 17, which is, my lord, a question of law. Second, my lord, under that, my lord, interpretation, my lord, on the face of it, my lord, the amounts which has been mentioned, my lord, on which there is no dispute, includes goodwill.
Correct.
My lord, his case is that it does not include goodwill, there's something more. Contract will just show it. And the contract is, my lord, this deed of partnership. There's no other contract.
He says he wants to settle in terms.
And my lord, he agrees that the settlement has to be in terms of clause 17. So the sole repository of the rights of the parties is clause 17.
Correct.
And my lord, the amounts, my lord, I've shown your lordship, my lord, are not disputed anywhere. Nowhere, my lord, has, my lord, have the amounts, my lord, been disputed.
Yes. Next.
Then, my lord, and your lordships, my lord, had put a query also, whether at any point of time a dispute had been raised, my lord, as to the computation. Never.
That's why I'm asking.
Yes, never, never. And my lord, I've shown your lordship their pleadings also. They say this I'm to get, but I have to get an additional amount on account of goodwill.
That's why once you have offered
Yeah.
and he has disputed, with
lord-
regard to the dispute, what amount he has disputed and what was the-
Nothing. He says I have to get additional on account of
if
goodwill.
he had given some figure or some disputed, that
Nothing, never.
Okay.
Never.
Next.
Now, my lord, আমরা তো দেখিয়ে দিয়েছিলাম যে overruled হয়ে গেছে the case. No, at the bottom. My lord, one of the cases my learned friend had cited, my lord, we had, my lord, indicated, my lord, that had been, my lord, overruled by the division bench.
What procedure we have adopted is the correct procedure.
Yeah. My lord, the Marico case, my lord, I've given your lordship.
That I have noted.
Yes. Now, my lord, I come to the next case, which is, my lord, 1961, 39 ILR Madras, page 80.
देखो 1958 Madras.
My lord, in fact, my lord, this case assists me because if your lordship kindly come to, my lord, page 82.
Just a minute. नहीं मिला.
My lord, this is the, my lord, old, my lord, specific relief act, which is involved. I mean, pre-1963, my lord, 1877 Act.
नहीं मिला. 1958.
1961, 39 ILR, Madras, page 80. They've given from ILR, my lord. KP Ramakrishnan Pattar versus KP Narayana Pattar.
Yes.
My lord, kindly come straight away to page 82. Exactly what I was arguing before your lordship, which is the view of the Supreme Court also, my lord, in Hungerford Investments case.
Yes.
My lord, kindly see, my lord's last 4 lines at page 82. Section 42 of the Specific Relief Act is no doubt not intended to be exhaustive as regards circumstances under which declaratory suits can be filed. My lord, 42 is now 34
Yes.
under, my lord, the 63 Act.
Yeah. Yes.
And my lord, what my learned friend actually relied on was that my lord, kindly come to my lord, page 83, bottom. My lord, in fact, before that, my lord, 83, fifth line. This seems to show that declaratory decrees can be passed, though they may not come under section 42 of the Specific Relief Act.
Yes.
Now, my lord, kindly come to what he has really sought to rely on. This only shows that learned judges were not prepared to say without hesitation that such a suit would not. But we have not been referred to any case in which any of the high courts in India has given a declaratory relief in respect of rights arising out of a contract which would affect only the pecuniary relationship between the parties to the contract, and we do not think there are exceptional circumstances in the case to take it out of the ordinary rule. Now, my lord, here, my lord, we are on an interpretation and closure of accounts. It is not, my lord, who is creditor, who is, my lord, debtor.
Yes.
Then, my lord, the next decision is AIR 1955, Madhya Bharat, Gwalior bench, my lord. The name of the case is Madan Lal versus State of Madhya Bharat.
Yes, here.
My lord, paragraph I will kindly have a look at Pray 2. On this basis, plaintiff claimed the reliefs. Firstly, a declaration that according to the contract between the Congress Committee, Basoda and the state, plaintiff was not personally responsible for payment of any amount due on account of sale and distribution. And secondly, injunction from recovering any amount on so and so. My lord, these were the prayers. My lord, here also, my lord, kindly come to, my lord, paragraph 4. My lord, section 42, para 4. Section 42 in suit for must show that he has some legal character or some right and that his opponent is denying. And the declaration can only be that the plaintiff, now legal character is the same as legal that is position wrecking. A suit for declaration that under a certain contract the plaintiff is not liable is not a suit for declaration that he is entitled to a legal character. It is obvious from that there is no question of the plaintiff's or any right. As to the relief, so my lord, it wasn't a 42 suit. Here, my lord, it is, my lord, nobody is claiming, my lord, that it is a 34 suit.
Yes.
But, my lord, 34 is not exhaustive. And therefore, my lord, I am, my lord, entitled to this declaration when a dispute has arisen as to the construction of clause 17. My lord, similar, my lord, is the case of 1960 Allahabad 254.
Yes.
My lord, they are all decided as if, my lord, the only basis on which, my lord, declaratory relief can be granted is as provided in Specific Relief Act, which is not the law. Then, my lord, 1960, there was also no contract. Then, my lord, kindly take, my lord, now, my lord, Now, my lord, all these cases, huh? 72 3 ACC. My lord, kindly take para 21. Sorry. 1972 3 SCC 684. Judgment. Kindly have a look, my lord.
Yes.
Para 21st. We also agree with the finding of the division bench that since section 28 of Specific Relief Act provides only for an application for rescission of a decree for specific performance for sale or lease of immovable property, no application to rescind a decree for specific performance of an agreement to sell movables would lie under that section. The question then is whether the application was maintainable under any other provision of law. The Specific Relief Act, kindly note this, is not an exhaustive enactment. It does not consolidate the whole law on the subject. As the preamble would indicate, it is an act to define and amend the law relating. It does not purport to lay down the law relating to specific relief in all its ramifications. In Ramdas, it was held that was not exhaustive. In so-and-so court said specific relief is founded on English equity jurisprudence. It is permissible to refer to English law so-and-so. Although a matter on which the Act defines the law, it might generally be exhaustive. The Act as a whole cannot be considered as exhaustive of the whole branch of the law of specific performance.
Yes.
So, my lord, all these cases, my lord, now, my lord, were before, my lord, also 72, my lord, Supreme Court, which says, my lord, that it is not, my lord, exhaustive. Similarly, my lord, 60 Allahabad, my lord, 254, I distinguish on the same basis.
Yes, that is over.
Then, my lord, 1983 4 SCC 625, Cotton Corporation. My lord, this related to, my lord, whether, my lord, interim relief could be granted in aid of a final relief which was barred by law. 41B says you can't have a.
Yes.
So, my lord, that was the prayer in the suit. And, my lord, they filed the proceedings. My lord, that, my lord, no, my lord, proceeding should be instituted. This has, my lord, no application at all. Then, my lord, just 4 cases, my lord. I'll quickly, if your lordship gives me 3 minutes, my lord. Then, my lord, 2022 8 Supreme Court cases, my lord, 633.
Yes.
My lord, this is, my lord, with regard to, my lord, my learned friends have relied on, my lord, paragraphs 3, 43, 45, 46, 50 to 55. Now, my lord, kindly have a look at, my lord, paragraph 50. My lord, it's a case of, my lord, a dishonor of check. My lord, kindly come to, my lord, paragraph 50.
Yes.
My lord, this point, my lord, para 50, my lord, is, my lord, kindly have a look on a holistic reading of the plaint and on consider find that barred by law inasmuch as no plaintiff can be permitted to seek relief in a suit which would frustrate the defendants from initiating prosecution or seeking any other remedy. It's like Cotton Corporation, my lord. There's a bar. You can't do that. In fact, the attempt made by the plaintiff to seek such a day is in substance to seek a relief of injunction, but framed in the name. In other words, plaintiff has sought an injunction, and my lord, kindly see, my lord, 41 is quoted of the Specific Relief Act. These are, my lord, provisions, my lord, which bar. Then, my lord, comes the case of 2022 8 SCC 633. Oh, sorry, my lord, my lord, the next one, 53 Guwahati, page 162. Sorry, my lord.
53 Guwahati.
Yes. Which one?
Yes.
My lord, my lord, 53 Guwahati 162. This is again section 42, my lord, and it's before, my lord, the Hungerford judgment.
Yes.
Now, my lord, I come to, my lord, 2015 5 SCC 588. My lord, paragraph 4, my lord, was, my lord, relied on. Oh, sorry, para 41, my lord. Para 41, kindly come to.
Yes.
My lord, this was a case of absence of defendant. Here, my lord, defendants present but forfeited the right and has filed an affidavit in court which shows there is no dispute. The only issue is with regard to interpretation. And these are, my lord, all coming in, my lord. These judgments, my lord, are all before the Commercial Courts Act. My lord, your lordships have interpreted. My lord, just two more quick cases, my lord. 1995, 34 DRJ 86. My lord, about proof of documents. This is again, my lord, before Commercial Courts Act. My lord, what would have had to happen, my lord, in a trial?
1990 DRJ.
Yes, my lord. 1995 34 DRJ 86.
Yes. Yes.
This is again, my lord, before Commercial Courts Act, how documents are to be proved, etc. And my lord, the most important thing is, my lord, the partnership deed, my lord, is not document which is not in dispute. Accepted that clause 17, my lord, is the sole
That is
repository.
not a dispute here.
So, my lord, I don't need to prove any other document. And the figures are, my lord, accepted. All that he says is on clause 17, I should get more on account of goodwill. But goodwill is included, my lord, in that figure. And the last case, my lord, is 2013, 14 SCC, page 50. My lord, paragraphs 12 to 14 was shown. My lord, this is land acquisition case.
Yes.
Burden of proof, my lord. I don't know where all we are traveling, my lord. In my lord. And my lord, I must.
17 এর interpretation নিয়ে খালি মামলাটা that has been applied.
So, my lord, I am praying for, my lord, A to E, and this is the Supreme Court, my lord, dismissal of the special leave petition.
This order. 711 order যেটা আপনার
Your lordship's order, my lord, has not been interfered with. Order and judgment. And my lord, I am seeking, my lord, prayers A to E. My lord, not only, my lord, the declaration, but my lord,
A to
also the injunctions which are consequential.
A to E.
Yes. Because if I am entitled to the declaration, my lord, this is a consequential thing of injunction. And my lord, there is no question of any trial now, my lord, because of, my lord, the right to file written statement having been, my lord, forfeited.
Yes.
My lord, those are my.
Thank you.
Yeah, file a written notes, my lord. Within, lordship, kindly give us a date, my lord.
1 week. Sense suffering from the plaintiff, sense suffering from the defendant.
I'm grateful, my lord.
Thank you. Hearing concluded. Counsel for the parties are directed to file their written notes of argument within a week. List the matter on 2nd July as to be mentioned only for the purpose of filing written.
Obliged.
Yes.
May I brief you, my lord, kindly, my lord, for drawing up and completion, my lord.
When, what was the order?
This was an old order, my lord. Passed.
Old order?
Yes, my lord. Not by my lord also.
2023?
Yeah, yes. My lord, they want to try their luck once, my lord. For drawing up and completion, my lord.
Okay. 2023?
For determination, my lord. I'm so grateful.